It's just when I work too much.
Who's Ann Wallace? Does that make ring a bell for anybody? Get them to confirm.
Did you just not let many people in, or not many people coming?
They're just in the waiting room right now, just
Okay.
figuring out the names.
Nick Wallace is Environmental Law and Policy Center
Ah, thank you.
in Chicago.
It was Nick, you said?
Nick, N-I-C-K Wallace.
Two Nicks in this case. All right, we'll let in 25. We'll see. That's all we're going to get, or there'll probably be plenty more to come in.
Oh, I don't like two screens.
Well, good morning, everybody. We're just checking everyone in, getting started here. We have some people still joining us, so take a bit to adjust their names here before I let them in.
We could teach everybody how to label their name.
Yeah, I don't know. We could try. I think if people wanted to do it, they could figure out how. But I'm not going to go through the trouble of showing them and teaching them how. Oh, Paul. Who's Paul? So there's two people I don't recognize. There's M. Kenneth and Paul. I let you in without looking you up. So if
Yeah.
you could let me know who those people are.
Judge Newmark,
Yeah.
I think that we have a extra conference room where witnesses are located, so I think, and they have the video playing in there, so that's that.
Which one, Paul?
Holly, I think.
Holly, I don't. So I have MKENET, and Paul. Those are two. And also Bert Garvin's also in the waiting room. So I don't know if that's a connection for.
So I am on MKENET,
Oh, you are. Okay, great.
and you could rename that Quarles 2 or something.
Is that going to be the attorney's connection, or is that going to be mixed up?
It'll be the witness that once we get through the preliminary matters.
Oh, okay. All right.
Yeah.
And you're I'm sorry, you got a heavy echo on your microphone, Joe. So there might be cross tracking another mic or another speaker somewhere.
Yeah, we're working on that. Sorry.
Yeah, no problem.
Is this better?
No.
All right, we're going to get our tech guy in here. Just one second.
Okay.
Sorry.
That's right. And then Paul, can you guys, someone identify the person, or if Paul can just let me know which party you're with and your full name. Although I don't see any more. I think you might have dropped out. Okay. All right.
Judge, this
Yes.
is a test. Does this sound better?
That's better. Yeah.
Okay.
Sounds like you got something. Sounds a little gruff, but I think it's definitely not echoing, and it definitely sounds better. So I think.
Okay, great. And yeah, Bert Garvin was in the waiting room. If you could let him in, he's just at a remote location. That'd be great.
Okay. Yeah.
Thanks.
He's already in. Yeah. All right. It looks like I was going to say the pace of people coming in slowing down, but it's not. All right, just give me another second here. We'll be done with this in a minute, I think. All right, so I just admitted a user with the name Steine, Steine. Just give me your full name and if you're connected with a party. I'll just unmute you, and if you can let me know who you are.
Judge Newmark. That's Eric Stein at the PSC, and I think I've been added twice to the hearing.
Oh, so E is your first. Okay, yeah. I don't know why you're connected twice. I saw you already on there. So where are you? Yeah, your other connection dropped out. All right, I'll just switch you here. Okay, all right, it's quiet. Now it's quiet. All right, can we get started? All right, excellent. So let's get on the record. Welcome, everyone. This is Docket 6630 TE 113, the application of Wisconsin Electric Power Company for approval of its very large customer and bespoke resources tariff. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're on Zoom with parties and commission staff in attendance. I also want to make sure I welcome Commissioner Hawkins for attendance here. I'll have you, you can keep your screen on or turn it off. It's up to you, but you know, leave it on as you wish. When you are speaking, though, I'll have you turn your camera on, please. I just wanted to give a little bit of detail about, well, let's just go through the notice first. So first we have, we've had the public hearing session on Tuesday. So we took comments from the public, and we'll continue to take written comments up until February 17th. They should be filed at the Commission's website at the link here on the notice, our public comments webpage, or mailed to us by U.S. mail. We have hundreds of comments now filed, and several hours of hearings on Tuesday, where we collected many comments. I wanted to note that we do have some instructions on how to file a comment in the notice of hearing. So for people watching the YouTube live stream and what will become the video, as well as on the transcript here, if you want to refer to that before the public comment period ends, just wanted to make sure that people are aware and understand that my job is to ensure the integrity of the process, including that public comments are valid, and we have assurance that they're comments from individuals that know and understand what they're doing when they file a comment, that they're giving their comment freely and knowingly, but also that we've seen in many cases in the past, I know parties are familiar with this, but I want the public to understand, to the extent I can get out to reach them, that I do have some standards. If someone is filing a comment on behalf of someone else, this top paragraph on page 2 of the notice gives you the standards that I apply to make sure that the comment was valid. It was filed when the commenter was freely and knowingly agreeing that someone else files the comment on their behalf. So I need to see that on its face, the comment demonstrates that exactly that commenter freely and knowingly agreed to another person offering the comment on their behalf and agreed to forego the opportunity to file their own comment. And also that comment should show me that the comment comes accompanied with a sworn statement by the person offering the comment that explains the process by which the comment was solicited, processed, and retained. So, you know, when it comes to things like petitions, when it comes to mailings, with a mass mailing with many comments in an envelope, I'm going to apply scrutiny to that to make sure I'm comfortable that there are real comments from people who knew what they were doing when they gave their comment to someone else to file. Best way to do that is to have an affidavit that explains the process, like I'm showing here. So, so I just want that out there for everyone to understand. It's nothing new. We've been trying to implement. We've had this standard for many years. We're trying to implement it in every case. So in order to do that, I just wanted to be clear that that will be the process I apply in this case, like all the others. Also, I want to make sure people know that I need to have the comments in the commission by the deadline, Tuesday, February 17th. So filing it online on our comment webpage will get it to us instantly. That link dies on when February 17th turns into February 18th. So at that moment, the link is no longer active. If you're going to mail a comment to us, we need to get it to our office by the deadline. So that require you mail it before the deadline. It's not the postmark date. It's we need to have it in our office by the deadline. All right, just want to make sure everyone's clear. So we are live streaming, like I mentioned. The link here is where the live stream is going on, and that will become a recording once we're done. The recording is an unofficial version of the hearing, so the commissioners will not review the video. I will give them the transcript of the hearing. That'll be the official version, official documentation of what we're doing here today, and there'll be a process by which we allow parties to request corrections, and I will either accept them or not, but there's vetting that goes on in creating the transcript, whereas the recording is just the raw footage, which is not what the commissioners will see. Same goes for the public hearing. We'll do the same process for them, although there's no correcting. Parties don't request any corrections to that transcript. All right, so I just wanted to publish oh yeah. Okay, it's off the record for a second. Okay, so now that so I just want to state that we do have one commissioner in attendance, so welcome.
Back on the record.
Oh yeah, back on the record, sorry.
Thank you.
We have one commissioner in attendance, Commissioner Hawkins, welcome. We will look forward to hearing from you. I did want to mention that in terms of the record that is presented for the commission for their review, that's the documents that I will package into the received evidence list that'll be put online. So the evidence that I receive, the exhibits and testimony that I receive, as well as the transcript of this hearing, all the public comments that I receive and accept, and the transcript of the public hearing, that's the evidentiary record. So, things that we do here, may not go into the record. So I just wanted to make sure we understand that sort of like when a jury may be looking at evidence that ends up not getting received or admitted into evidence, that's not something that the commissioner will be using to make the decision. That decision for all three commissioners will be based on the received evidence.
LJ Newmark, I just got a message that the YouTube stream is not working or frozen, so just wanted to flag that for your attention.
Okay. Let's go off the record then. All right.
Sounds like it's back up, so whatever you did may have worked.
I think I'm gonna have to start that over.
Sounds like it's back up and working now.
Okay.
I don't know.
I'm not seeing it yet. All right. Well, you have a contact that's monitoring that for us?
I got a couple of messages from people watching.
Okay, I'm going. Yeah, I can see it now. Okay, I'll just keep it up and running. Okay, good. Better not to start a new one because then we have two files. All right, excellent. So thanks for interjecting there. So let's see. So let's get back on the record, and I think we can start taking appearances from parties. We'll just start on the service list here at the top. So let's hear from the Citizens Utility Board.
Good morning, ALJ Newmark, Daniel Narvi appearing for the Citizens Utility Board. Also joining me are our witnesses, Corey Singletary, Steve Klein, and Jeff Adams.
All right, Clean Wisconsin.
Good morning, Judge Newmark. Brett Cordy on behalf of Clean Wisconsin.
All right, Cloverleaf Infrastructure.
Good morning, Judge. Richard Heineman, Wortman Clark on behalf of Cloverleaf, and also have, though not in the same room, Nor Bernhardt appearing on behalf of Cloverleaf as well.
All right, thanks. Environmental Law and Policy Center.
Good morning, Judge. On behalf of ELPC, it's Brad Klein, along with my colleague Nick Wallace, and we also have our witness, Saad Sadiq, on the Zoom.
Great. Microsoft Corporation.
Good morning, Judge Newmark. Delaney Brewer on behalf of Microsoft, and our witness is standing by needed.
PSC.
Good morning, everyone. Evan Whites on behalf of the Public Service Commission of Wisconsin.
Sierra Club.
Good morning. This is Priyam Desai on behalf of Sierra Club, and I'm joined with our witness, Jeremy Fisher.
Great. Vantage Data Centers. You're muted. I can.
There we go. Thomas McCann Maluli for Foley and Lardner for Vantage Data Centers. Along with me is my colleague Arata Kekumagawan, and we have a witness whose name I'm not immediately seeing, Nick Phillips.
Okay. Walnut Way.
Good morning, Judge Newmark. Krista Westerberg here on behalf of Walnut Way, as well as my colleague Eduardo Castro with Princeback, and our witness Ron Nelson is also on the Zoom.
All right. Wisconsin Electric Power Company.
Good morning, Your Honor. Attorney Patrick Proctor Brown on behalf of Wisconsin Electric Power Company. With me are attorneys Phillips, Wilson, Goldschmidt, Rosso, and Fortune.
Yes. Okay, excellent. Wisconsin Industrial Energy Group.
Yes, good morning, Your Honor. Steve Heinzen on behalf of the Wisconsin Industrial Energy Group.
All right, that's all the parties. Great, welcome. All right, so let's now move on to offered evidence.
Your Honor.
Yes.
Excuse me, we had one correction to the service list.
Oh, okay. Let's see what we got here.
Katie Nicola is not on this list, even though she is included on the spreadsheet on IRF.
Okay. Yeah, that could just be my typing error here. So that's okay. Well, I think let's go off the record. Debbie, I think, do you have Katie on your list?
I do not.
You don't. Okay.
Unless it's not in alphabetical order, but.
Well, I don't think so. Okay, I'll send that to you, and we can. So this list, yeah, this is a temporary thing, so we can add that in.
Thank you, Your Honor.
Yeah. Okay. So for now, I'm going to show. So it's got on the record. I did show. Send this document out to parties last night. Apologize for the late timing. I was catching up, as probably we all were. But I'm just going to show the PDF for now. I do have the live version, and I can make adjustments to if there's corrections we need to make. But figured this way you'll see what you've seen before. We can all follow along. But first question is, any errors or omissions to the list as we've seen the filed evidence so far in the case? Let's start with the applicant. Anything you need me to adjust here?
No errors or omissions, Your Honor. I do have 2 clarification questions on Mr. Zagantz's testimony. If you want to do that now or later.
No, we'll do that later.
Okay, thank you.
How about Cub? Any errors or omissions?
Nothing that I can see, Your Honor.
Cloverleaf, anything wrong with that filing?
None.
Okay. ELPC, any errors or omissions?
No, Your Honor.
Oh, I did want, well, okay, I guess we can do that later, yeah. Microsoft Corporation, errors or omissions?
No, Your Honor.
Sierra Club?
None. Thank you.
Vantage?
Looks good, Your Honor.
Walnut Way?
I'm sorry, who responded for Vantage?
Oh, yes.
Thomas Malooly.
Oh, there you are. I'm sorry.
Sorry, Krista Westerberg for Walnut Way. Nothing for us. I think Clean Wisconsin may have been passed over though.
Oh, that's what I was, yeah, I had a question for them too. Okay, no, we'll get down to the bottom first. Any errors or omissions?
No, Your Honor.
And commission staff?
The only thing I would note, Your Honor, is the public comment exhibit is not listed, but that may have been intentional on your part.
Yeah, usually I add it as a placeholder, but yeah, that will be coming in after the comment period is over. We'll compile that public comment exhibit for sure. Yeah, thanks for mentioning that.
Thanks.
Let's move back up to Clean. I knew I'd forgotten something. Clean Wisconsin, any errors or omissions?
Yes, first, Your Honor, I didn't see Clean Wisconsin indicated as having cross-examination for witnesses that we identified yesterday.
Okay.
In our pre-hearing notice, we said that we intend to cross WEPCO witnesses Aaron Gerlikowski, Shelendronath, and Stasic. And then I did have one issue with our exhibits.
So Stacey, I mean, okay, it's just, and having you on the list here for cross isn't determinative. It's just to gauge the amount of cross. So you had Stasic and Gerlikowski, and who was the other witness?
Aaron. And Shelendronath.
Okay. Okay. Yeah. So I think the issue with, are you talking about Jester 3?
Yes, Your Honor.
Okay. Let's save that and go back. I'm just going to look at comment issues. We'll start at the top of the list first. So let's have the applicant ask if they had an issue with the comments or clarification. So go ahead, whoever wants to handle that.
Thank you, Your Honor. So on exhibit WEPCO Stasic 13, we did refile that. So I think your comment is, and that's reflected in your exhibit list as well. That's on page 3, first comment.
Yes, you're right. And I was holding that as a placeholder so we don't get confused. But yes, that'll all the stricken items here will be eliminated for the received evidence list. I was keeping it here just in case we need to reference it during the hearing. But yeah,
no, that makes sense, Your Honor. I just wanted to make sure I closed it out with you that it is, and it's reflected as an exhibit there.
Yes.
And then the other one is on Mr. Zagantz's testimony.
Yes.
That is correct as drafted. If necessary, Mr. Zagantz can explain, but that is correct as drafted.
Okay, that's fine. Yeah,
that's all I had here.
No reason to explain that if that's what he has. All right, great, thanks. So, Cub, any questions about the? There's only one.
No questions, thank you.
All right, so let's go on to Clean. Go ahead, Attorney Cordy.
Thank you. I saw your note that Exhibit CW Jester 3 was not filed. We did file it. I have the confirmation of receipt from the PSC IRF, and it was served on the parties with the rest of the exhibits. So I did notice that it wasn't on the IRF offered exhibits list today, but I don't know why that would be the case.
Okay, so let's just go off the record. Do you have any chance have the PSC number for that?
Yes, Your Honor.
Just let me get to my spot here and I can take it from you. All right. Yeah, go ahead.
The document ID is 572291.
Oh, okay. So it was unaccepted. I don't know why. Okay, so I have it as an unaccepted filing, but it wasn't confidential. Maybe it had confidential information, and it was just removed.
No, Your Honor, it was a website for Microsoft, and again, I got the filing with PSC accepted email and didn't notice a rejection at least, and it says it's accepted on my IRF upload portal as well.
Okay. Yeah, I mean, as long as parties had it, you served it. We're just need to figure this out for our filing. I don't know what this is trying to reflect. So I can show you on the back end here. It's just telling me that it was now it's labeled as an unacceptable filing on IRF, which means we can't open it. I can see if I can have records switch that document type. That might be the easiest way to move forward with that. If you wouldn't mind just emailing me a copy so I can have it for the hearing.
Yes, Your Honor.
Okay, great. So quickly, I'm just going to make a note of that. All right, back on the record. Anything else from Clean?
No, thank you, Your Honor.
10:29 a.m.
Okay, so comments from Cloverleaf. Any questions about the comments for?
Well, Your Honor, obviously we will be talking about the joint request.
Oh, right. Yes, of course.
I assume we'll do that later, but once that's clarified, then we know how to proceed.
Okay. How about ELPC comment questions?
Yeah, thanks, Your Honor. The third comment regarding ELPC Sadiq 18, your comment notes that it's a duplicate of 17, but it looks like it's a separate document when I click on the PSC ref number for both 18 and 17 are distinct documents. So I'm not sure if that's an error.
Could have just been having so many files open at once. Let me see. Oh, that's weird. Okay, I don't know. Okay, good. Thanks for pointing that out.
Sure. And then I did also have one other question. The first comment just has the exhibit label, but it doesn't have a comment attached to it. I was wondering if I was missing something there.
Oh, yeah. Well, I think I should maybe have addressed these general issues first, but that one won't comply. So I'm not sure why. I may have deleted the comment because it was okay, but just forgot to remove it, the whole entry. I don't see anything wrong with it as far as I can tell. Okay. All right, is that it?
That's it. Everything else is fine. Thank you.
All right. Microsoft, there's no comments there. Sierra Club. No.
I'm happy to address. There are some questions about the redactions in a couple of the documents. I don't know if you want to wait to cover those later.
I guess I think those were mostly for you guys. So let's review. Just see what we had here. Yeah. So well, now that you brought it up, let's tackle this. So it looked like so it says what it says. So there's several exhibits that it looks like there's public only information, and so there's a public only document with redactions, or documents that are filed confidentially with redactions, and that's not our usual practice. We need to either have a fully unredacted confidential version and a redacted public version. So if you're going to redact the public version, there should be a confidential unredacted version. So is there some reason for the mismatch in your filings?
Yes, Your Honor. So we actually pulled all of those documents reference a document that we pulled from a separate docket, and we are not interveners in that docket, and so we have not signed the confidentiality agreement that the utility would have, and so we only have access to the public document, and we only need the information from the public document. So I'm happy to include, we can adjust the table so that it's currently a screenshot from the PDF, but I can always add in, or rather replace it with a table that just has the publicly available information, if that's helpful. Or I can add a footnote.
So which exhibit in particular did we have here?
Exhibit 12 is the one that I'm specifically referencing, and the SIR rebuttal pulls from Exhibit 12.
All right. Okay. I'm understanding what happened here. I didn't identify all these. Okay. Yeah, I thought this was odd, especially because you're putting the table in. It's redacted. Now, this was on the direct or the SIR rebuttal?
It was on the SIR rebuttal.
Just going to display the.
Well, the exhibit 12 was submitted with direct, and then we referenced the table in the SIR rebuttal.
Yeah. So this is how the chart appears on both the confidential and the public version.
Correct.
So is this a file? This filing is from in the other docket. That's a filing from WEPCO or from the merchant plant.
It's I believe that's the filing from WEPCO. It's from the buy-sell docket.
So the confidentiality agreement wouldn't cover your use of this information, the confidentiality agreement you have with WEPCO currently, if you would ask WEPCO for this document, they should be able to give it to you under your current confidentiality agreement, would be my guess. So I think since these dockets are closely related, it's just, and it's information from the company, from WEPCO. I'm gonna.
Your Honor, I think at this stage of the proceeding, we would certainly object to discovery of that nature, and we don't agree with the premise that those dockets are closely related, such that confidential information, other dockets, should be cross-pollinated to this docket.
Okay. Well, I didn't. I'm sorry.
Confidentiality agreement doesn't
Let's go off the record.
That information.
We're off the record. I'm sorry, Attorney Proctor Brown. I didn't ask for your opinion yet, so I will ask for the WEPCO's input when I want it, and so please refrain from interrupting. But also, let's get on the record. So I think the commission needs to see all information. It shouldn't just have a redacted public version in the confidential filing. That's not our practice. So what I'm going to have you do is have WEPCO share this document under your confidentiality agreement, and then have Sierra Club refile its surrebuttal and Exhibit 12 with the confidential version that appears as it should, fully unredacted, and then the public version with the redactions. Now, there was a number of other exhibits where that was the case. So I think we want to conform our filing standards to that practice. So if we can have you two, WEPCO and the Sierra Club, coordinate on that and then fix those filings for us, I would appreciate it.
Okay, yes. And then for Exhibit 9, that one, we only referenced a discovery response, the public version of a discovery response, but I can file the confidential version as well.
Okay, good. Okay, so Vantage, were there any comments? So is that it for Sierra Club?
Yes, I believe so. Thank you.
Sorry. Vantage, any questions?
No questions, Your Honor. We understand the comment. We'll refile appropriately.
Walnut Way?
Yes, Your Honor, thank you. So I just want to make sure I understand the three that are highlighted on the right, the 2, 3 exhibits 2, 3, and 6. My understanding is that the 2 and 3 go to your comment page 10 about refiling an exhibit that adds something to an original document that was filed before with the commission.
Yeah, so let's move on to that general statement. Sure. So so we want to see on exhibits, if you have an original document, it shouldn't be modified. So we've seen a number of exhibits where parties have put a page number and put the marking of the exhibit on those pages of an original filing that didn't have those markings before. So that's where you need to refile your exhibits to remove that original mark. I'm sorry, remove that new mark from an original document. So yeah, that's what's being, and I don't think I've identified them all on this list. I'm just asking parties to look through their filings and make those corrections. I think I might have caught a few and then just said I'm not gonna list them all. So yeah, so Nelson 2. I can't find these. Look at my document. Oh, I see what I did. All right, yeah. Okay, I was just highlighting them, but those are some that meet that requirement where they're not properly filed. So yeah, so 2 is one of those.
And just so I understand that one as well, Judge, is I don't think we did add a page number to that. Is there something else that was added?
Oh, was that on the document? Okay.
Yeah.
Okay. No, I don't think there's anything added on that one. You're right.
Thank you. And then I think the same goes for number 3.
Yep. Oh, yeah, you're right. Oh, that's the original one. Okay, that's what it was. Okay, yeah, you're right. So your original has that in there. That's fine.
Okay.
Yeah.
So 2 and 3 we can leave as is, and then 6 I wasn't sure why that one was highlighted either.
No, okay, yeah, no marks there. I don't know.
Judge Newmark, I think at the bottom of this exhibit, there's a revision history, but it's my understanding that this is part of that. Those markings are part of the original document reflecting the.
Yeah, you're right. I don't think that's what I was looking for. I just may have not sure what the highlights are for.
Okay.
To be honest with you at this point. Yeah, no, those 3 are good. Just look for where you see the exhibit mark. I mean, usually it's the actual mark that we're given. I think for some of them, you added a number, a page number to each data request. Those were added in after. I think that should be easy for you guys to find and identify.
Okay. And then as to number 8, exhibit 8, and maybe this is a discussion to have with WEPCO, but we can refile it with the public and confidential. But I think most of the information that was originally redacted, and this was kind of an older document as they go, is now out there in public. So I could speak with.
Oh, I see.
With WEPCO about that, or I don't know if we can talk with them during the day today and see if we can just publicly file that and not need to file 2.
Okay, that's up to you. I'll let you figure that out. But I mean, since we have these documents already on Earth, it would be fine just to refile them, or yeah, it'd be fine to refile them as packaged as the exhibit, or you can, yeah, I think that's fine if you want to put in a new document. I think. Yeah, so I'll just leave it at that. And if you guys want to look that up, that's fine.
Okay, thank you. And I do have one other question. I understand the rest of the comments. As to the ones sort of in that later range, like the 27, 28, refiling with the version that appears on Earth, we're happy to do that. One of the documents I emailed yesterday as part of the ones we may use at hearing that are not already in the record had that same defect. So I could email the service list right now with the updated one, if that would be the best way to handle that.
No, if we do accept that as an exhibit, then when you refile, when you file it on Earth, then just use the version that appears on Earth.
Okay, we can do that.
But we don't need to update that now, just for purposes of the hearing.
Okay, thank you. And then I think this is a question for later when we're talking about the request to compel, but there was one other additional document we wanted to add, and we can take that later if you'd like.
Add in for use at the hearing?
Yes.
Okay. Yeah, well, let's wait on that. We'll have to, we can talk about that later.
Okay. Then I don't have anything else. Thank you, Your Honor.
All right. How about Weeg? Any questions?
Yes, Your Honor. Thank you. I have questions with regard, I guess, to Pollock 3, 4, and 5. And a couple of questions with regard to each, but as I understand it, for 3 and 4 at least, 3 and 4 are documents or is a citation to a worksheet on an Excel spreadsheet that WEPCO filed in connection with the strategic energy assessment. And so what I will do when I refile it, I will take off the reflection of what the exhibit number is and the page number that it appears on the right hand side, because that is not on the original. But the two questions I have is the green that you suggested that we take off is on the original.
Okay.
And the other piece is that what I have identified here as the source is not in the testimony. We just state in the testimony there's a statement of fact. We refer to an exhibit. This is the exhibit, and I put the source on the exhibit. Would you like me to take the source off of the exhibit because it's not part of the original and put that into the testimony?
Let's do this. Put this have the cover page. So leave the green because I just thought maybe we were.
Oh, understood.
We didn't want to misrepresent that it was one of the data center, some data from one of the data centers, because that's what we're using. That color is what we're using in the confidential version. So so leave the green because just give me the document as you saw it in the original form.
Okay.
If you want to put the source, just throw it on the cover page. How about
Okay.
that? And then
That's just fine.
Yeah.
Okay. Thank you so much. And that's all the questions I have there.
Okay. And commission staff, any questions?
No questions, Your Honor. More of a note, and I think this relates to a discussion that I see you have highlighted for later about refiling some of the responses to data request TCM 1.1. Depending how those are refiled and the attachment numbers associated with them, I would just note that I believe in the surrebuttal testimony of PSC witness Coble, there is reference to one attachment. So if those attachment numbers change, that may need to be refiled. So just flagging that for everyone's attention.
Okay, great, thanks. All right, so there are a couple of sort of generic notes I wanted to give. First of all, we're seeing, again, the misfiling of the IRF document description that the applicants use, still adding that PDF at the end of the testimony or exhibit name. Please refrain from doing that. I've asked you several times in several proceedings not to do that. If you do want to see what the naming convention is, go to the FMO Table A for testimony. Clearly shows you not that the .pdf is not part of the IRF name. I need to go and manually change it all, and I'd rather not do that. If we could file it correctly the first time, I'd appreciate it. Other things is on discovery, I noticed that several parties are naming counsel, just the word counsel, as the respondent to with respect to discovery objections, but the FMO requires the person be identified who is responsible for the objection. We had some discussions about that in prior cases. Surprised to see that that's not been understood yet. Is there something that I need to further clarify for parties?
Your Honor, this is Joe Wilson. Understand the direction. So you want the name of a lawyer who is making the objection on the data request response?
Yeah, that's what it says.
Okay, and just for my edification, can you help me understand what the purpose of that is? And that's not really how I read the facilitating matters order, which talks about responses to the data requests as opposed to objections. But maybe I'm reading it in too narrow a fashion.
Let's see. So if we look at FMO 2, 3. So it says both a discovery response and a data request response shall identify the person or set of people who provided each response. This identification shall indicate the name of the person and the nature of the person's role in providing that response as either 1, responding with assertions of fact, or 2, responding with conclusions of law, or responding with both assertions of fact and conclusions of law. So is an objection not a conclusion of law? Should I be more clear about that? I can be, it's fine. I can change it to say objection specifically.
Okay, that's fine. We have obviously continued our longtime practice of identifying the person providing the substantive response, but have, as we've done in the past, put counsel for objections. If you need the name of a lawyer, that's fine. But I guess our position would be that, you know, if we have multiple lawyers on a case, any of them are capable of talking about the objection at hearing or otherwise as necessary. It's not typically an individual lawyer making the objection, but
okay.
We'll follow your direction on it. I just want to make sure we understand it.
Okay. Yeah, that's what it is. Thanks. But just so should I change it to objections as well? Add objection, would that be clearer? Because I mean, we're dealing with this in many other cases. So I guess I'll add that as well.
Yeah, I mean, that would be, I think, clearer.
Okay. I appreciate that. All right, so there is an issue with the applicant's responses to the data request, TCM 1.1. And I know I sent this out pretty late. This is rather complicated, but so if we need to work this out, it may take a while. But if the applicant does have a response for this, let me hear what it is, and if we need to hash something out, we can do it off the record. But go ahead for now. Just, is there any more clarity you guys can give about that?
Yeah, thank you, Honor. So most of this has to do with PCAs that are in the execution version docu-signed. So the protective orders requirement to color code the confidential version, that's not possible, the docu-signed copy. So we have to find the last Word version to pair with the docu-signed version to be able to comply with the protective order. We were given a very limited time to do that under the protective order, and it obviously made some mistakes in terms of how they were filed. We're working on those now, and we'll file a supplemental response. There's no difference in the content between the two responses. They're just organized slightly differently.
Okay, because I didn't see the same batch of documents filed. The ones that were filed on December 1st versus the ones filed on December 16th appear to be a different set of documents. There's a lot of overlap, but there's some that are missing in either batch. And maybe I'm not, but I could be wrong. I was hopefully maybe missed something there, but I think there's some. So if there is any missing documents, we want to make sure we're getting the entire batch filed in the new filing.
We're not aware of any missing documents, Your Honor. We believe we filed all of them. Again, the protective order changed which versions we could use because a DocuSign version can be redacted. It's the color coding that really threw a wrench in the gears of this process and required us to go and find other versions. So we're working through that now. We understand the direction, I believe, and if there's continuing issues, we'll follow up with staff.
Okay, so then in terms of the labeling, is it?
Yeah, my understanding, Your Honor, is the spot, the cover sheet in some sense.
I'm sorry, you broke up, Mr.
Oh, yeah, sorry.
You just broke up. My understanding, Your Honor, is?
My understanding, Your Honor, is that the supplemental response, the cover sheet, if you will have a guide to the filings this time around.
Okay. All right, great. I appreciate that. So is that something you're anticipating you can file by the refiling deadline, or do you need more time?
My understanding is by the refiling deadline will work.
So this ties into the next item here, which is the issue with agreements. So it looked like there were agreements that were filed for this data request response, this TCM 1.1. They were filed under request for confidential handling, but the public versions redact the signature blocks and the entities, and that's something that I've have long-standing disagreement with, that we should at least have the entity names and the people who signed those agreements available for public review without necessarily giving out any trade secret information or other confidential information. The entities signing and the people involved should be disclosed. That's been my longstanding practice since becoming an ALJ. Is there any reason why we don't want to continue that for these particular documents? Is there a reason why we need to keep the identity and signature blocks redacted from the public in this case?
Your Honor, I believe customer identities generally are confidential. Certainly, we think the individuals who sign the agreements should be confidential, as you ordered when we submitted the exemplar of a service agreement under the CP1 tariff earlier this week. In terms of WEPCO employees, we don't believe there's any relevance to their identities and could be subject to harassment or other doxing in the public domain if their identities are not redacted. And one thing that took longer in this process is we coordinated closely with the VLCs to ensure that their trade secret information was redacted and highlighted appropriately under the protective order. So I would defer to the VLCs themselves on the trade secret nature of those documents. But just generally speaking, we agree with them that the connection between an entity and a specific generation resource that has not yet been disclosed publicly should not be disclosed publicly in this tariff proceeding. But I would defer to the VLCs for additional argument on the trade secret portion.
Yeah, it's that the trade secret's not at issue. It's just the name of the entity.
I guess I'll defer to them, but just my understanding in those discussions is that they consider it a trade secret that they are connected to a specific generation resource or specific capital expenditure, but I would defer to them further.
Okay. Yeah, so it would just be the entity named in the first paragraph. So that's been redacted. So I don't...
Your Honor, if I may.
Yeah, is it Delaney?
I'm sorry,
Yep, this is Delaney on behalf of Microsoft.
Ms. Burra, can you raise your computer, your screen up or something? Because I can't see you. I'm sorry.
Sure, that's okay. Is that better?
Yes, thank you.
Okay, yep.
Go ahead.
I think, understand the desire of transparency. I think the pattern of unredacting the identities, across several agreements can demonstrate collectively trade secrets. That said, I think, just keeping in mind that trade secrets are protected by law, that these are customers, that they are not, regulated monopolies. So there is a sensitivity there. I think we can probably get comfortable in most cases with unredacting at least Microsoft's identity, but we definitely agree with drawing a hard line on any employees' names or contact information.
Okay. Yeah, I see that. I'm not even sure if these involve Microsoft, but let me review it, and if I want to press this issue, I'll issue an order about it. But at this point. I can take more. I don't know if Cloverleaf or Vantage has any opinions on this. I don't even know if they're involved in these documents at all. I just I can hear any. I don't want to show these documents, obviously, so it does make this a little more tricky. But I think that basically it's I think it's really what I was talking about is that top paragraph. You know, it's WEPCO and such, and that's. I mean, it just seems like, well, who's WEPCO agreeing with? We don't know who the entity is, and then who signed the document. It doesn't have to have personal information. It doesn't have to have contact information, but the idea that these were actually signed, these are executed agreements is something that, to me, is something that I've always wanted to see in the public realm. But any comment from? Did you have a comment, Attorney Malooly?
Thank you, Your Honor. Yeah, I just wanted to underline what my colleagues have already said. Mr. Patrick Brown, Dr. Brown already indicated in today's climate, the issues with particular names being out there in the public, it poses a risk to particular individuals. So that makes a lot of sense to me. And as Ms. Brewer said, the point of a lot of the redactions here are keeping confidential the association of a particular company with a particular facility at this point. They won't always be confidential as the relationship with a particular bespoke resource develops. But at this point, that has been protected as confidential. And so it's consistent with that approach to have the name left out.
Mm-hmm. Okay. And any comment, Attorney Heineman?
I have nothing to add on this issue, Your Honor.
Okay, that's fine. Thanks. All right, so let's move on. There's those issues. We can skip that.
Your Honor, before we move on, Evan White's on behalf of Commission staff.
Well, yeah, absolutely.
If I could just ask one question. I know the applicant said that they could get the responses to TCM 1.1 refiled by the revised evidence deadline. There's going to need to be some revisions to Commission staff's data request response exhibit accordingly. So I would just ask if we could have some additional time to refile that, make any modifications required because of the refiling.
You got it. You take whatever time you need.
Thank you.
Your Honor, on TCM 1.1, if I may. I just wanted to know, counsel for applicants have indicated that they don't believe any of the documents were not refiled. As best we can tell, we've identified several, and I can just give the original attachment number if that's helpful for the applicant. Those are attachment numbers in the original filing 6, 7, 8, 27, and 28.
Okay.
We can take a look at that. I think that's a difference in the numbering, but again, we are looking at making sure that we have all the comprehensive documents. We attempted to do that the first time around, but may have made some mistakes given the very tight time frame.
Okay. Well, we'll be watching you. So, yeah.
I'm sure that's true, Your Honor.
Judge Newmark, if I may, before we move on, I appreciate this is Krista Westerberg.
Yes.
Attorney Brewer's comment that I think, if I'm understanding it right, that there's not an objection to connecting Microsoft to a particular resource at this point. I think that's a good move for transparency, and I would support that kind of information being available on the docket for all the VLCs. Thank you.
Okay.
If I may, Judge, I just want to clarify.
Yeah.
I just want to clarify.
Who's speaking?
This is Delaney. This is Delaney Brewer
okay.
on behalf
Sorry.
of Microsoft. There are PCAs where the project is still redacted. So we're not. I think Attorney Westerberg maybe misrepresented our position. Our position is the name of the party could be unredacted. We're not necessarily agreeing that in all cases that means the parties and the name of the projects need to be unredacted.
Yeah, in that case, I misunderstood. I didn't intentionally misrepresent the position, but I think the point remains that it would be beneficial for there to be more public information about which user is being connected to which resource.
Okay, thanks. And I should add, just so you know, I mean, commission staff does work hard to vet documents that get filed under request for confidential handling. And as WEPCO knows, they've been through many iterations of debate as to what is confidential and what is not. And staff has pushed back significantly with that. This case in particular, as you can see through the various orders, we've had some complications with delineating those parameters as to what's a trade secret and what is not. And so I do want to acknowledge, especially on staff's work and focus on attempting to make public what can be made public and respecting trade secrets where it needs to be. There's certainly no intent on behalf of staff to keep confidential what is not legitimately filed and should receive confidential treatment. So yeah, I'm not going to rule on this now. Like I said, if I do want to change in the filings, I'll send an order out about that. So let's move on to. So anything else on this? Sorry, and I don't when I'm moving on. If people do have, I guess I should be more thoughtful of asking. I didn't mean to cut people off there before. So the first thing we have want to discuss in these preliminary items here is the joint request to correct.
I'm sorry, Your Honor. Are we going to discuss 7?
7
right above that.
No, that's for the hearing.
Well, I guess I would like to discuss it if you don't mind, Your Honor.
Okay.
So for A and B,
go ahead.
So for A and B, Your Honor, we can have a witness prepared to testify. I believe it will be Mr. Stasek on A and B. C and D are questions of law. We are not prepared to present a lawyer to testify in this case. They're both outside the scope of the issues in the pre-hearing. For instance, PURPA has not been mentioned in testimony by any witness.
Mm-hmm.
And WSTAT 196.371 is not one of the statutes that's listed in the issues of the hearing and doesn't apply because this isn't a construction docket. So we could address this in briefing, but we'd like to understand a little bit more how this is relevant to this tariff case.
Yeah, I think the question's clear. So if you want to address that in briefing, please do that. Yeah, I think it would be useful for the commission to get a full scope of the legal. I mean, the statute does clearly identify setting rate-making principles for generation facilities, and that's also what's being proposed in these tariffs. So,
Your Honor, just point of clarification, and I apologize for interrupting. There are no generating facilities being proposed for construction in this docket whatsoever. They're being proposed in separate dockets, and so we can address this in briefing. I think it'd be helpful just to have any context you can give us to help us be as helpful as we can be in briefing.
All right. Well, first of all, for letter C, is there questions about that?
It's same thing. I think, how can we help the commission on that issue? We're just not seeing the obvious connection to this case.
Okay. Well, my understanding is that the tariff this is a test, I suppose. Does the tariff actually say that this is the case? that it prohibits an eligible customer from bringing their own generation. So I guess it's just a matter of describing what the company's position is on that or not. Because from what I've heard is that there's some debate. Maybe there's debate. Maybe there's just. I mean, I just haven't seen the language. That's really the question. There is where is it in there or not, and what's the impact? So it's not necessarily a legal conclusion. It's more saying, is this what you're intending? Is there any impact with PURPA and these tariffs? So I mean, I don't know who wants to answer that, or if you want to deal with it legally, but I think the question there is just, is this an unintended consequence, or is there something in the tariff that kind of points to this being an issue? Because it seems like it's kind of slipping off. I think it's been raised in terms of bringing your own generation, but maybe in a different context, more in terms of planning. But what I haven't seen is that, there is this world out there that kind of that utilities do have to deal with when it comes to PURPA requirements. So I want to flag that and make sure that we're not missing it.
That's helpful, Your Honor. And we've just had a few hours to think about these questions. Yeah, and as Attorney Parker Brown said, we don't have a PURPA expert here to testify today, but we can certainly address it in briefing.
Okay. And then in terms of letter D, so this relates to, the question is, is the proposal implicating in any way Wisconsin statute 196.371? And does that create any procedural issues here? It's really the biggest question. Is there, because the legislature has set up the process under 196.371, where a utility can ask for certain rate making parameters be attached to an electric generation facility. Now that's either in a construction case or a purchase case. So that statute covers both the construction of a plant and the purchase of an existing plant. So that's where the tie-in would be to a bespoke resource, at least how they're currently envisioned. So I think the idea is is there any conflict? Is there any prohibition? So make sure we're not violating anything by moving forward in light of the process that's been already provided by 196.371. Okay. And if that wasn't identified in the issues list, I apologize. But I think because these items are aligned in that way, in terms of especially the ROE, setting up an ROE in the process that's being envisioned by the tariff. Is that in conflict, or is there any connection? Is there anything we need to think about when it comes to what's already been provided for that process under 196.371?
Okay. That's really helpful context. We appreciate that.
All right.
And then thank you. On E, Your Honor, we weren't intending to have a witness on this either. We didn't present any modeling in this application. We didn't develop any modeling for this docket. In the two buy-sell dockets related to Red Oak Ridge and Foundry Ridge, the B-store analysis is called out and explained in those dockets. On occasion, we will develop additional analysis in support of testimony. So the idea is that all analysis needs to be done at the time of application. I don't think that's accurate how these dockets work. We have the opportunity to develop additional analysis in support of testimony later as well. So I'm not sure what one is getting at. Anything that was used to develop the application is in the application. That's our practice. But the B-store analysis we presented here wasn't part of this docket, and so I don't know how we could have, in this docket, complied with one, if that's the implication. Mm-hmm. And for two, some of these tools, BStore and other analysis tools, are proprietary and subject to licensing that can't be transferred to staff. So we can't commit to two. Again, it is and has been our position that modeling is not relevant to the standard under 196, 1922. We just had to submit it because other witnesses talked about modeling in their direct testimony.
Sure. Okay, I understand. Yeah, I think you may be missing the point here. It's going forward. So it's talking about future cases. Obviously, we have we have the utility here. I think we're obviously seeing that modeling is playing an important part in what would be the development of the cases that relate to these tariffs, these bespoke resources in particular. I think we're seeing new models coming forward, and in the past, we've discussed this in rate cases where we've identified situations where commission staff needs to get access to modeling, and I believe my recollection is the company had agreed to something like this in the past, where it was going to give staff time and notice and allow staff to use equipment and software to run models that it had and commission staff did not. Maybe I'm confusing it with another utility. I don't know. I seem to recall this something we've done in the past. But I know that in that discussion, my research showed that many of these licenses allow for the sharing of this kind of information for purposes of a regulated entity seeking approval of an application from a regulatory body, and that the software, the models can be shared with staff of that regulatory body for that purpose of processing that application. Maybe that's changed over time, but I think it's something to think about. And something, maybe it's not something we can address here, but I think the company should be thinking about that. And I think it would benefit everyone for coming to some understanding about that. So I'm glad we got a chance to discuss.
Yes, thank you, Your Honor. I mean, we have certainly worked with staff on the modeling before. I think the concern here is that it would be some sort of condition on approval of this tariff. And that's just, to your point about many licenses, there are certainly some licenses that don't, and predicting that and how it works out in the future here seems like a bridge too far for us. But we're committed to working with staff to make sure that they ensure the models, the dockets that the BStore analysis is in, don't have notices of proceedings yet, I don't believe. So we can have those discussions in those dockets with staff at the time it's needed. Okay,
well, I would hope that's something the company can commit to. I mean, hearing you say it, I guess I'll leave it up to staff to pursue this further with the company.
Thank you.
Let's move on to the requests here. First of all, the joint request to correct rebuttal CI Bernhardt. That's a request that came in. I just have to use my version. I don't know why this is doing that. So I just wanted to, this is not, well, I don't know why the link isn't working. All right, let's go off the record. Mm-hmm. Okay, so we got this. So let's get back on the record. So the joint request to correct Cloverleaf direct. So this was filed on February 3rd. We received no objections, no responses to the motion. Therefore, there was a 3-day period for parties to respond. Actually, because it came in at 4:30, we were starting that count on the next day. At this point, the way the FMO works is that even though there's been no objections, and the special considerations paragraph of the FMO, this request would go into effect automatically, but I still have time to claw that back and discuss it, and this is what I'm doing now. So I'm curious about this request. The items that are requested to be changed, I'm not in favor of. I think that it does modify the testimony significantly. I understand the reason for this is that the witness was at one point a Microsoft employee, is now a Cloverleaf employee, and in the testimony sponsored by Cloverleaf, the witness is describing the witness's experience while being a Microsoft employee. Well, I don't really think there's anything fundamentally wrong with that. I think if the witness has something to say, the witness is on the stand, so to speak, and if that witness has relevant testimony and is giving it voluntarily, which is what's happening here, I don't really see a reason to rescind that or retract that testimony, since it's not being claimed that it's inaccurate and needs correction. It's being claimed that deletion is needed in order to clarify that the witness is not testifying on behalf of Microsoft. That's what's indicated as a reason for a change for, I guess, all of these. So I can hear more from the parties and staff on this, but my inclination is to reject this. Let the testimony stand as it's been filed. And I think the clarifications that need to be made can be done on when the witness takes a stand, either through the witness's direct statements or through cross-examination. We'll get to the same result, that we can clarify that the witness is not testifying on behalf of Microsoft, but it appears to me, and we can delve into this if we need to, but it appears to me that the witness is testifying on information that this witness has firsthand experience on that's relevant. There's no objection to that. So I would be rejecting this as part of that clawback procedure in the FMO. So do we have any comments? I can start with Cloverleaf and Microsoft, but if anyone else wants
Sure.
to.
I mean, I can judge Richard Heineman from Cloverleaf.
Yes.
I understand this joint filing may be unusual. The Mr. Bernhardt's experience with respect to the development of these tariffs is also unusual. I mean, and he obviously indicates in his testimony that he was an employee at Microsoft, and the intent of providing this joint request was really to provide clarity to all the parties that Mr. Bernhardt is not testifying on behalf of Microsoft and not in a position to testify on behalf of Microsoft. I understand that based on other motions and discovery-related motions involving the company and other parties in this proceeding, and your orders with respect to those, that it could be deemed relevant that there were negotiations that took place to the development of these tariffs, and the purpose of filing this joint request was to really just foreclose the possibility that Mr. Bernhardt would be cross-examined on any of those discussions that might have taken place when he was an employee at Microsoft. So the intent here was really to try to simplify the proceeding, honestly, and forestall any discussions that would require him to wade into territory that he's not in a position to be able to do. And the discussions that when this issue was brought to Cloverleaf's attention by Microsoft's attorney, we found a way to work through modifications to the testimony that we thought provided that clarity and would have achieved the goal here, which was to simplify the proceeding and eliminate a lot of unnecessary back and forth over areas that Mr. Bernhardt is just not in a position to comment on, and at the same time preserve the substantive elements of his testimony that we believe are germane to the proceeding, and give him he has the ability to offer a perspective that's reflected in the substantive portions of the testimony that remain. And then we chose this method as well, knowing that if the proposed modifications did create concerns, other parties would have the opportunity to respond. And so, we were very sensitive to the due process elements of all this, and we did it. We thought we were doing it in a way that would preserve the ability for parties to develop their rebuttal testimony appropriately. And so again, the intent here was to try to achieve administrative efficiency and clarity. So I guess I'll defer to Microsoft's attorney. She wants to add her perspective, since again this was a joint request.
Sure. Yeah. Anything to add, Attorney Brewer?
I agree with everything Attorney Heineman noted, and I would also note that there are several instances in the testimony where changes were made where it was just unclear on whose behalf the statement was being made, and I think those clarifications are certainly important to note that it was on behalf of Mr. Bernhardt's current employer.
Okay. Any other parties want to chime in here? Commission staff?
Your Honor, Evan White's on behalf of Commission staff. Ordinarily, Commission staff wouldn't necessarily have a position on this one way or another. Really, our only interest is ensuring that there's a complete record for the commissioners to make a decision. However, I guess one thing, and I could have misheard this, but one thing that stood out from Attorney Heineman's description of the purpose of these corrections was that it was done to foreclose cross-examination on certain topics. And I'm a little bit worried about that. And I understand that there may be objections that the parties may want to make, whether that be relevant on relevancy grounds or privilege or something like that. But I feel like those kind of need to be specific to the questions asked and not necessarily remove portions of pre-filed testimony for the purpose of preventing cross-examination. So that's all I have. Thank you.
Okay.
Can I respond to that?
Is that Richard? Yeah, go ahead.
Sorry, Attorney Heineman, in response to that. I understand that point. Based on the availability of witnesses that exist in this proceeding, to the extent that a party, for example, would like to ask questions about negotiations concerning the development of the tariff, there are witnesses available for such cross-examination. Those questions really are not, from our standpoint at this point, appropriately directed at Mr. Bernhardt. And so my statement that the intent of this joint filing was to forestall cross-examination, really what I mean is cross-examination of Mr. Bernhardt on areas of testimony that he just can't provide based on his position as a current employee of Cloverleaf and not Microsoft.
Okay, so I'm going to interrupt. I'm sorry.
All right, go ahead.
I don't want to spend too much more time on this because I think I understand the parameters, what we're dealing with. If witness Bernhardt has personal experience and is a witness in this case, and that the questions that are posed with respect to that personal experience is relevant and has probative value, he's going to need to answer those questions. So I don't know why we're debating this exactly at this point. I agree with Attorney White's that sure, there can be, first of all, if the witness wants to clarify who the witness is testifying for, who the what the direct testimony who's sponsoring the direct testimony, and it's not on behalf of one party or another, let's get that in the record. That's not a problem. If Microsoft wants to question the witness to make sure that the statements the witness is making is not on behalf of Microsoft, I totally understand that. But in terms of this witness's personal experience and relevant information that the commission certainly has a right to know in this proceeding, that's going to be fair game. And I don't want anyone to go into this thinking otherwise, and we'll need to spend a lot of time on rulings about that, because the particular question may have some issues, but I think as a general parameter, we have a witness, we have personal experience, this has all been documented, not disputed, and I think it doesn't matter who this person works for now. I mean, it's just irrelevant, and it's just not something that I don't think anyone has experience with being a valid argument. So if you can cite to me where that's would prevent or bar questioning, please let me know so we don't make any errors. But I can't imagine that exists. So so I'm going to reject the request, and we can move on with the understanding that questions related to witness Bernhardt's experience that's relevant to this case is certainly will be allowed, at least presumptively, or on its face. We'll have to check objections to particular wording, but I think as a matter of principle, I would allow those questions. So I don't want to get too much more into this. Let me just say the Walnut Way request to compel responses. There's been a number of those, and there's been some back and forth. It looks like parties have stipulated to responding, and I just wanted to mention that I'm going to honor that agreement. So what we have here is good to go. I don't want to give advice, but I would say discovery is very important, and I think we all benefit from getting as much information as possible that we can bring to the hearing. However, I like what I said in the Microsoft motion for protection. We do have to look at burden when it comes to timing, and I hear Walnut Way saying that it didn't know that there were negotiations until late in the game, but even the application states that this is negotiated tariff. So I want parties to really think about their discovery and how they could be more effective and get information sooner, and give us all more time to discuss discovery disputes. I'm just not sure what the issue was, and this seems like a basic question you'd ask in any case. Who was involved in these negotiations? Give us the documentation. And that could have been done. I think I granted Walnut Way's intervention on August 6th or August 2nd. At that point, Walnut Way has the rights for discovery. So the application was filed months before that. That would have been my practice to say, let's get that information now. But maybe there's other issues I understand. Maybe Walnut Way didn't have an attorney yet, things that I don't know. So I apologize if I'm misconstruing this, but I would think that, or maybe didn't have intervener compensation yet. I don't know that. That could be a reason for this, but please get your discovery in as soon as you can, so we can all benefit from that information, and we can also deal with objections, and really it will hopefully eliminate the issues, the problems we face when we have late discovery, and when discovery comes late in the process, and then really burden does become an issue for me. I think that there's a valid case to say it's the day before the hearing. It makes responses very difficult. So I see that, but I do want to promote rights to discovery. I think it's beneficial, but there's the other side, and that's all I want to indicate there. For the motion to require supplemental testimony, you've all seen that, I hope. There's a person in the public that wishes to file these in many cases. I just wanted to let everyone know that this was not, that motion was not filed by a party, so it's invalid. I'm not going to rule on it. It's moot. It's not legally triggering any need for action. So just so we're clear on that. All right, so I think we've gone through all the preliminary items. Any questions, any comments, concerns we need to address?
Not from the applicant, Your Honor. We're going to do our usual musical chairs act over here. And
we got to do the cross identifications, Your Honor. I think.
Oh, right. Yes.
All right.
Okay, is that off the record? I don't know what you mean by cross identification.
So, Your Honor, our understanding is 2 of our witnesses do not have any cross identified for them.
Yes.
I think that's usually what you do next.
I do that usually. Now, we do have a commissioner in the audience, and the commissioner, I will certainly make witnesses available for the commissioner to ask questions of. So at this point, this is an old, and we get the right document here.
3, actually. It's Nelson.
Nelson, yes, sir.
So yeah, so who would you like not to have to call? Let's see.
Yes, thank you, Your Honor. Miss Ann Bulkley and Mr. Joe Zagantz do not have any live, whatever we want to call it, testimony on the stand, and so we'd ask that they be excused.
Okay.
Are we still off the record?
No. I can just restate. Let's get back on the record. Yep. So the applicant has indicated that witness Bulkey and Zagantz are witnesses which so far we've identified no questions for, and the applicant wishes to validate their testimony through an affidavit. And I'm going to ask, so we have Commissioner Hawkins here, so I did want to make sure he's not had a chance to weigh in on this. So Commissioner, did you have any questions for those witnesses?
I do not.
Okay. All right. And at this point in time, any parties or commission staff have any questions for these witnesses?
Oh, no, Your Honor.
Your Honor, no questions from commission staff for those witnesses. I would just add that initially we had identified potential cross for WEPCO witness Nelson and would not have cross for witness Nelson. So if we're the only party that would have had cross for witness Nelson, perhaps witness Nelson could be excused too.
Okay. It sounded like they were going to call him anyway, but that's...
Yes, thank you, Your Honor. That's exactly right.
Okay, so for Bulkey and Zagantz, we'll take their verification by affidavit. And should we just do the rest? Looks like so let's move on then. Thank you for reminding me about that. So for Cub, do we have questions for Adams or Keim?
None from applicant, Your Honor.
And so I don't know if Cub wants to call their witnesses, but you can. Well, we'll excuse them if you wish.
We'd like to ask for witnesses Adams and Keim to be excused. Thank you.
Okay. And Singletary has questions.
Yes, Your Honor.
Clean has questions. Cloverleaf.
Your Honor, sorry to interrupt. This is Brad Klein for ELPC. After the email went in with our cross estimates yesterday, ELPC was able to reach an agreement with WEPCO to mutually waive cross of witness Sadiq, and ELPC will have no cross for WEPCO's witnesses. So and I believe WEPCO is the only party that intended to have questions for witness Sadiq. So if nobody else does and Commissioner doesn't have any questions, we'd request for him to be excused as well.
I would just confirm that what Attorney Klein said is entirely accurate.
All right. So any questions as we sit here today? Any questions for witness Sadiq? Parties? Any questions? Commissioner Hawkins? Any questions?
I'm all right without.
Okay. And commission staff?
No questions.
Don't get too excited though. This will still be a long hearing. Okay, we got the rest of everyone here. I don't have any questions so far for witness Pollock. Is that still the case?
None from applicant, Your Honor.
Commissioner Hawkins, did you have any questions?
No, I did not.
And commission staff?
Nope.
So and I'm assuming commission staff witnesses will take the stand?
Yes.
Okay. All right. So back to the top. I think we have all of that. So did I actually say we'll excuse Sadiq and Pollock?
Thank you, Your Honor.
Yes.
Your Honor, if I may, Sierra Club had identified WEPCO witness Reese as someone we wanted to cross-examine. I'm no longer planning to ask him questions. So if we're the only party, then
Okay. Then I'll ask again. So any party wish to question witness Reese?
I'm
I
sorry,
had a
witness
question.
Reese?
Reese.
Thank you.
I had a question, Your Honor.
Okay. Give you an acronym here. All right. All right. So we'll keep witness Reese in play. And okay, yeah. All right. Anyone else? No. All right. So how about we take a 15-minute break and we'll take our witnesses at noon. Just to reset and get back on it with witnesses. So quick 15 minutes and we'll get back at noon. Thanks.
Thank you, Your Honor.
All right, let's get it back on the record. Who do we have first for the applicant?
Your Honor, we have Tony Reese first, and we're just working on getting his camera turned on. Oh, there it is.
And I'm sorry, counsel. Oh, go ahead.
Yeah, just go ahead. Just give us your name for the court reporter.
I couldn't remember.
This is Attorney James Goldschmidt for the applicant.
Thank you. Sorry.
Okay. Just let me know when you're ready.
We're ready on our end, Your Honor.
I'm not seeing. Oh, there you go. Okay. Let me just. All right, I was going to pin you guys, but I think I'm going to let it go for now. All right. So I'm sorry. Who's our first witness?
Mr. Tony Reese.
Reese. Okay. All right. Witness Reese, I see you there. So raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right. So go ahead.
Thank you, Your Honor. Mr. Reese, would you please state your full name for the record?
Yeah, Anthony Reese.
Did you prepare and cause to be filed in this docket rebuttal testimony and 5 exhibits?
Yes.
Were the answers in your pre-filed testimony correct and true to the best of your knowledge?
Yes, they were.
If I were to ask you the questions contained in your pre-filed testimony today, would your answers be the same?
Yes.
Do you have any changes or corrections to your pre-filed testimony?
No, I do not.
Your Honor, we do have some brief sir rebuttal testimony from Mr. Reese. Would it be appropriate to offer that now?
Now's the time.
Thank you. Mr. Reese, Sierra Club witness Dr. Fisher suggests at pages 5 to 6 of his surrebuttal testimony that you have mischaracterized WEC's projected load growth in Wisconsin between 26 and 2030. Is he correct?
No. My rebuttal testimony addressed load growth for WEC's Wisconsin segment, which included load served by WEC's Michigan jurisdiction utility in Michigan's Upper Peninsula. Combined, all the utilities in that segment have a historical summer peak demand of 7.5 gigawatts, and VLC load is expected to add 3.4 gigawatts to that peak by 2030. So combined with a slight decline in non-VLC load over that same period, WEC's projected peak demand for its Wisconsin segment in 2030 is 10.6 gigawatts, which is an increase of approximately 40%, as I stated in my rebuttal testimony. And VLCs are projected to represent approximately 30% of that load. Dr. Fisher's different figures come from focusing on Wisconsin Electric's load in isolation. Of course, that results in a higher relative percentage, but the underlying capacity additions are the same and are undisputed. Other witnesses for the company are better equipped than I am to testify on the basis for those load projections. The purpose of my rebuttal testimony was simply to point out that WEC's and Wisconsin Electric's credit rating agencies are familiar with those projections and are not concerned about them from a market concentration perspective, given the credit supportive features in the proposed tariffs.
What about the higher projections that Dr. Fisher cites from a confidential discovery response?
I was not involved in the analysis that produced those figures, and I am not aware of the assumptions behind that analysis. Mr. Arendt, Mr. Gerlikowski, or Mr. Stasek would be able to answer questions about those figures and what they represent. Again, my focus here has been on the VLC-related risk and perceived by the credit rating agencies based on public available investor materials.
Yeah, page 4 of his rebuttal testimony, staff witness Mr. Mielemans suggests that if the VLC-related growth in WEC's asset base is not a concern to the rating agencies, then perhaps the ROE component of the proposed tariffs is not necessary. Is that a fair inference to draw from your discussion with Fitch?
No, it's important to understand that our discussion with Fitch was not limited to market concentration or changes in WEC's asset base. It was a wide-ranging discussion encompassing all aspects of the proposed tariffs, including the credit supportive features of interest to the rating agencies, and specifically including the enhanced ROE. We did this because we understand that the rating agencies analyze risk and counterbalancing projections holistically, which is also what we were asking the Commission to do here.
Thank you, Mr. Reese. With that, Your Honor, the witness is available for cross.
All right, thank you. So I wanted to say that I can accept the Reese offered evidence into the record, and let me also state that I'll accept all the offered evidence that's been identified on the offered evidence list, pending verification and then refiling corrections that we've already discussed before. So now, do we have any? Looks like we had questions for this witness from Commissioner Hawkins. Is that the case?
Yes, that's right.
Okay. Well, go ahead with your questions, Commissioner.
Thanks. I just had one question on your testimony related to repurposing of a bespoke resource. And I was just wondering if the tariff as proposed would allow for repurposing at a value below the remaining net book value, or if all of the Commission's consideration of whether or not repurposing of a bespoke resource would have to be at the remaining net book value.
I think that's going to be subject to the Commission's ultimate approval as to.
I'm sorry, who's speaking?
Oh.
Yeah,
this is witness Reese.
Oh, I'm sorry. Your box didn't light up. I apologize, sir. Go ahead.
Right.
Yeah, Commissioner Hawkins, I believe in terms of your question there, it would really rely on ultimately what the Commission was deciding to do as to whether they felt a value below that net book value was reasonable in terms of what should be put into rate base.
All right.
And in which case, in that situation, you still would have the VLC customer that would be on the hook for the differential.
Great. That was my assumption. I just wanted some clarification on that. Thank you.
All right. Any other cross for this witness?
This is Krista Westerberg. I just have a brief question and for Walnut Way. Good morning or afternoon, Mr. Reese. I just wanted to clarify, since I don't think it will come across on the transcript, the Cercer rebuttal testimony you just provided, you were reading from a document, is that right?
That is correct.
Okay. And did others within WEPCO have the opportunity to review that document before you read it?
Yes.
Thank you.
All right. Anything else? Redirect?
No redirect, Your Honor.
All right. Thank you very much. You're excused.
Thank you.
Yeah. Who do we have next?
Your Honor, next up, applicant calls Mr. Jody Art.
All right, so let's just go off the record for a sec. When you guys switch attorneys, you have to announce your name because the court reporter doesn't see it on the screen. So just give us your name for that purpose.
Sure, this is attorney Lauren Rosso for the applicant.
All right, and who do we have on the stand?
Mr. Jody Art.
All right, great. All right, let's get back on. And okay, we have witness Art called. I'm going to swear you in. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth?
Do.
All right, go ahead.
Mr. Arndt, did you prepare and cause to be filed rebuttal and surrebuttal testimony in this matter?
I did.
Did you also prepare 11 exhibits?
I did.
Is everything that you stated in your testimony and compiled in those exhibits true and accurate to the best of your knowledge?
It is.
Do you have any corrections to offer today?
I do not.
Mr. Arndt has some brief surrebuttal testimony.
All right, go ahead.
Mr. Arndt, what is the purpose of your surrebuttal testimony?
To respond to staff witness Ms. Groschel and Ms. Witzling.
Staff witness Ms. Groschel is concerned that the tariffs don't require VLCs to subscribe to sufficient energy resources, which she says could negatively impact non-participating customers. How do you respond?
Wisconsin Electric's current generation portfolio hedges market prices for non-participating customers. Even with the introduction of VLCs and bespoke resources, this will not change. If VLCs do not have enough bespoke resources to serve their load, the non-participating customers will continue to be hedged against the higher MISO market prices by the existing resources and any new generation facility or portion thereof that is not a bespoke resource. In addition to the tariff requiring a VLC to subscribe to a sufficient level of bespoke resources to meet their firm service level, the exposure to higher market prices would also provide the economic incentive for the VLCs to subscribe to sufficient bespoke resources to cover their energy needs. Moreover, the Commission will be able to review every proposed resource and acquisition project to ensure that Wisconsin Electric does not build or acquire resources for non-participating customers to solve a problem for the VLCs.
Ms. Witzling's testimony discusses estimating excess capacity needs of non-participating customers. She responds to a table that you included in your rebuttal testimony at page 24 and says that your table shows the percent change in each season between the initial and final planning reserve margin requirements, while she believes the effective margins to analyze are the PRM plus RBDC opt-out adder and PRM plus RBDC clearing beyond PRM. How do you respond?
I agree that the effective margin is the final total PRM for each season. Ms. Witzling and I simply used different calculations to analyze this margin. Wisconsin Electric's proposed method of determining how much excess capacity will be available to sell to VLCs is more conservative than Mrs. Witzling's approach simply because we have a difference in opinion on how the PRM for the RBDC is calculated.
In response to your testimony that there is no method to transfer resource credits to a VLC asset owner after the PRA has concluded, Ms. Witzling notes that MISO has a process for settled resources to change asset owners called settled resource switching. Is Wisconsin Electric opposed to settled resource switching?
I'm going to interrupt for a second. Sorry. It's off the record. Debbie, can you hear the WEPCO people talking?
Yeah, I can hear them. It's some of the words are kind of dropping, but I can gather it after the fact. If that makes sense.
That's not probably good enough for us. Yeah, if you guys can get maybe closer into the microphone, it just seems like it's kind of stretching the hear you guys. If that's what microphones do, I don't think that's really true, but we'll try it again. So I think that you probably have that question in front of you. So if you just want to answer it for us now, we'll get on the record.
Sure. This option requires additional research. To date, I have not found any documentation that fully explains how settled resource switching is used. If it is a viable and functional option, we would not oppose truing up the VLC fleet firm service volume to the final planning resource auction results.
Thank you. Mr. Arndt is available for cross.
All right. Excuse me. So we have Clean Wisconsin and Walnut Way. Let's start in alpha order. So take Clean Wisconsin's questions first.
You ready for me?
Yeah, yes.
Okay, thank you. Good afternoon, Mr. Arndt. I'm Brett Cordy, staff attorney at Clean Wisconsin. Just a couple questions for you today. Are you familiar with PJM interconnection?
Somewhat, not in great depth.
But PJM is a regional transmission organization, or RTO, correct?
Correct.
And are you familiar with the term system mix as it relates to an RTO?
I'm assuming, I shouldn't assume, but my guess is that that would mean the mix of resources within the portfolio for those RTOs.
Thank you. Judge Newmark, I'd like to pull up a document provided to the parties yesterday titled PJM System Mix by Fuel, January 2025 to December 2025.
Okay, let's go off the record. Okay, I'm gonna put this on the screen. All parties should have this for themselves, so I don't know if this screenshot is really gonna do us much good for your purposes, but if you need me to zoom in on something, let me know. But we'll just at least have this in front of everyone. Does anyone need some time just to find that document for their own screens? All right, well, gave you a chance. So let's get back on the record. Go ahead and go ahead.
Thank you. Your Honor, if we could zoom into the top left corner just to see the title of the document. Mr. Arndt, do you see that this document is a table from PJM's generation attribute tracking system titled PJM System Mix by Fuel?
Yes.
And that we're looking at the system mix for January through December 2025?
Correct.
Judge Newmark, if we could scroll down to look at the far left column at the bottom. Thank you. Mr. Arndt, do you see wind listed in the third row above total in that far left column?
Yes.
And Judge Newmark, if we could pan over to the third row.
Third row.
Third column, I'm sorry.
Oh. Just make this bigger, I think, in order to do that. Okay, there we go. All right.
Maybe a little bit tough. We might have to zoom in if you can't see it. Yeah. But Mr. Arndt, do you see that wind was 3.7332% of PJM system mix in 2025?
I do not see that, no.
Yeah, I'm gonna have to to make it smaller to get it all in there.
Well, Your Honor, that I had the witness identify the third row from the bottom would be wind.
Wind, so we'll just do third row from the bottom. It's not letting me, So it's percentage by fuel. Third row from the bottom.
Yep, 3.7332.
Thank you. And then if we could, I apologize, Judge Newmark, but if we could go back to the left column and identify if Mr. Aaron could confirm that the seventh row from the top, from the top is gas, natural gas.
Yes.
And then over to the third column, that natural gas was 43.1771% of PJM's mix in 2025.
I can see that, yes.
Thank you. Clean Wisconsin moves to enter this document into the record as an exhibit. I believe that would be Aaron 12.
All right. Is there any objections?
Yes. Excuse me. Yes, Your Honor. Applicant objects. I don't see the relevance of this exhibit. The resources that are the subject of these tariffs will not participate in PJM's actions.
Will not participate in
PJM's auctions.
Thank you.
Okay.
You're-
Okay.
If
Go
I
ahead,
may respond,
Attorney.
Your Honor.
Yes, go ahead.
In his rebuttal testimony, witness errant, starting on page 14, while discussing challenges MISO is facing, discusses impacts of a recent winter storm Fern, and submitted as an exhibit, which is exhibit WEPCO errant 10, article from Politico that discusses the mix of load within PJM during that storm. The exhibit offered here today is to put those figures in context of PJM's overall mix for the year previous to that storm.
Okay. Any other response from WEPCO?
No, Your Honor, I think my objection still stands that we're getting a little far afield of relevance.
Okay. All right. Well, I'm going to allow it because of the connection to the storm, which has been testified to, and being in the PGM territory. So we'll need to have that filed. That'll be filed by Clean Wisconsin as ARNT 2. I'm sorry, ARNT 12.
Thank you, Your Honor.
Okay, go ahead.
I would now like to pull up the other document Clean Wisconsin provided the parties yesterday titled 2025 MISO PRA Results Posting.
Okay, let's go off the record. Oh, it's a little bigger. Bigger text, that's good side. All right, let's see.
Thank you, Judge Newmark. Mr. Aaron, do you recognize this document as MISO's planning resource auction results for planning year 2025 to 26?
Yes.
Your Honor, if we could turn to page 27 of this document.
Looks like they're numbered here. Go ahead.
Mr. Arndt, do you see the table within this document beneath the title Historical Summer Auction Clearing Price Comparison?
Yes.
And in the planning years displayed here, the column on the left being planning years, was the summer auction clearing price in Zone 1 ever more expensive than in Zone 2?
Objection form.
Okay, if you want to restate that.
Mr. Aaron, this the page that we're looking at shows MISO planning years on the left column. Is that correct?
Correct.
And then at the top rows are zones within MISO.
That is correct. That is correct.
Thank you. For any of the planning years on this page, do you see Zone 1 having a higher clearing price than Zone 2?
Not on what you're showing me, no.
Thank you. If we could go to the next page, Your Honor. Do you see this page titled Fall Auction Clearing Price Comparisons?
Yes.
So the same question for the summer auction in the planning years displayed here. Do you see any Zone 1 prices that are higher than Zone 2 prices?
Nope, I do not.
Thank you. If we could go to the following page. This is the winter auction clearing price comparison for 3 planning years. Is that correct?
That is correct.
And do you see that zones 1 and 2 had the same clearing price?
I do.
And finally, one more page, the next one, Your Honor. So you see that we're looking at now the spring auction clearing price comparison?
Correct.
And for the 3 planning years provided in this document, zones 1 and 2 have the same clearing price. Is that correct?
That is correct.
Thank you. Clean Wisconsin now moves to enter this document into the record, and I believe that would be Errant Exhibit 13.
Any objections? Okay, we'll make that.
No, Your Honor.
No. Okay.
Thank you. No further questions. Thank you, Mr. Errant.
Of course.
Let's take a second off the record here. This is okay. All right. So we have Walnut Way signed up for cross here. We'll take you first, and then we'll ask for others. So let me just clear the decks here a bit. Okay, go ahead, Walnut Way. Who's representing you at this time?
Thank you, Judge Krista Westerberg. And good afternoon, Mr. Arndt and Krista Westerberg on behalf of Walnut Way. I have some questions for you about your rebuttal testimony. If you want to pull that up, or the judge want to pull that up.
Just give me a second here. I thought I had it in front of me, but it's okay. Yes. All right. Where should we be?
And I wanted to start at page 6.
All right.
And specifically line 18 and 19. You're talking about the needs of VLCs or very large customers. Is that right?
Correct. Talking about the VLC customers and their energy use at different times of the year. Correct.
Thank you. And it lines 18 and 19, you also say VLCs will also consistently need electricity all day, every day. And I didn't see a basis for that statement about your understanding, where you derive your understanding about the power needs of VLCs being all day, every day, consistent rate. So could you enlighten me as to the basis for that statement, please?
Sure. Part of it is given data center load itself. The base for data center load, they're a very high load factor. So typically they will have data centers on the order of 90% load factor, which means they're running very high all the time throughout the year.
Is that statement, that understanding based on very large customers generally and data centers generally, or did you, is that specific to the VLCs that have sought service in this case?
For data centers in general, for the most part, correct.
Okay. And did you consider in making this statement whether certain kinds of functions of data centers like training artificial intelligence can be flexed at certain times?
I'm not familiar with data center operations and what they can and cannot do.
Okay, thanks. I would like to move to page 12. And line 6 specifically.
Okay, go ahead.
Are you there, Mr. Arndt?
Yep.
Okay, thank you. You talk here about the shortfalls, energy shortfalls in extreme weather conditions. Is that right?
Correct.
Sorry, the what for shortfalls?
I think I said energy shortfalls.
Okay, that's it.
Thank you. Did you consider in making this, in your discussion about shortfalls due to extreme weather, the ability of things like demand response to assist with these shortfalls?
This was a statement from NERC and their analysis that they would consider that there's potential for shortfalls. So that's, you might have to consult with NERC and what their assumptions were.
Okay, so to the extent you're repeating that statement, did you consider the ability of demand response to deal with shortfalls?
Demand response can be used to deal with shortfalls. It just depends on the amount of demand response available during that period of time.
Thank you. I'd like to move to page 16. And the question and answer starting at line 7 to 17. And you talk there, I'm paraphrasing, about the importance of a diverse generation portfolio. Is that right?
Right.
Okay. And then on the next page, on table 1, and following on page table 2 on the next page, looks like for purposes of your testimony that the resources listed in tables 1 and table 2 is the entire universe of resources you're considering would be part of a diverse generation portfolio. Is that right?
No, it's just examples of typical generation resources.
Okay. Are you offering an opinion in your testimony about whether demand response could contribute to a diverse generation portfolio?
I don't believe I've mentioned demand response in any of my testimony.
Okay. So it sounds like that's a no.
I did not mention any demand response in my testimony.
Okay. And you're not offering any opinions in this proceeding about the role of demand response and contributing to resources that may be needed by large loads, right?
Demand response already plays a role, certainly within our portfolio, and I assume it will continue to some level, although that's very dependent upon the customers themselves and the risk they're willing to take under that tariff.
Have you personally discussed with large loads their willingness to utilize demand response?
I have not been involved in those conversations.
I'd like to move to page 27. And line 6.
Yes.
Thank you. And here you're speaking about, you make the comment that requiring a very large customer to limit service to reduce reliance on the PRA would be discriminatory to that kind of customer. Did I paraphrase that correctly?
That is correct.
Okay. Have you discussed that option with any of the VLCs seeking service under this tariff?
I have not been in any of those discussions with the VLC customers.
So you don't know whether they would consider it discriminatory?
I can neither confirm nor deny.
Looking down to page 32. At lines 16 and 17.
Yes.
Okay. And you say here by 2030, 54% of energy from the Wisconsin electric generation portfolio will be generated by gas resources, and 46% will be generated from carbon-free resources. Did I state that correctly?
That is correct.
When talking about Red Oak Ridge and Foundry Ridge, did the 54% that you quote there include those resources?
Yes, that was out of our current model runs.
How do you know, sitting here, or can you approximate how much of the portfolio would be gas without those resources if they weren't to materialize?
I don't know that I can offer
a guess other than these are low capacity factor machines capped at a 20% capacity factor, meaning Red Oak and Foundry Ridge. So my assumption is the impact would not be significant.
Not be significant to the overall 50.
To the greater portfolio, correct.
Thank you. And one benefit you cite of these two CT projects, the Red Oak Ridge and Foundry Ridge projects, would be that they can be quickly dispatched. Is that right?
That is correct.
Okay. And they can, you're assuming they would be implemented by 2030. Is that right?
Correct. In that time frame, correct.
Did you consider whether other sources of non-carbon energy, such as demand response, could be implemented with that time frame as well?
Demand response is included in the typical model runs that we do as an option to be selected.
Okay. When considering the benefits of natural gas versus other resources, did you consider that in your testimony?
Did I consider that?
Oh, that was a poor question. Sorry. I do want to ask you, we can move off of your rebuttal. I want to ask you about the SRSA rebuttal you provided at the outset here.
Yes.
And just again, because I don't think this would come off on the transcript, it appeared to me through the Zoom you were reading your SRSA rebuttal. Is that right?
That is correct.
And you reviewed that with others.
Don't talk over each other. It's off the record. Yes, guys were just talking over each other, probably because these are easy answers, but just so the transcriptionist can catch what everyone's saying, please wait for everyone to finish and then answer or ask. So, Debbie, did you get this is yes. Right? Yeah, okay.
Yes.
All right, go ahead. Back on the record.
Thank you. And Mr. Arndt, did you have the opportunity to review your SRSA rebuttal testimony with others within WEPCO before reading it today?
Yes.
That's all. Thank you.
Okay. So we've done Clean and Walnut Way. Any other cross?
Your Honor, Evan White's on behalf of Commission staff. If I could just ask one brief follow-up question on the SRSA rebuttal.
Of course, go ahead.
Good morning, Mr. Arndt. I just had a quick question on your clarification about your estimate being different than Dr. Witzling's, in that WEPCO's calculations are more conservative. Do you remember that testimony that I'm referring to?
Correct.
Would that be true in all circumstances, such as when the PRM is positive and negative, or just one or the other?
I think it's true in all cases, simply because it's not clearly defined yet within MISO, and we're all trying to arrive at it from maybe a slightly different place, but they're extremely close. I don't have too much concerns about it, but I would say it's fairly consistent that our view would be a little more conservative.
Okay, thank you.
Yes.
Okay, and Commissioner Hawkins had your hand up. Go ahead.
Thank you. I just had a couple questions. The statements related to reliability of remote wind as compared to local resources, I'm wondering if you provided any evidence as to the claim that out-of-state resources are not nearly as reliable as local resources.
Yes, and I don't think particularly I'm saying that an individual site or project is more or less reliable from the standpoint of wind production. It really comes down to the way we approach planning, and historically how we've always approached planning from the standpoint of having resources close to the load as possible.
Okay, and so then on page 16 of your rebuttal testimony, you talk about the importance of a diverse portfolio. Is it safe to assume then that you're only talking about technology diversity there and not geographic or locational diversity of resources?
Certainly within the footprint, geographical, right? Again, even in your own footprint, being closer to the load is preferable for many reasons, including reliability and lower losses. But from the standpoint of diversity, it's technology, it's fuel type, it's emissions, it's the ability to provide resiliency and essential reliability services. So it's the broad characteristics of each generation resource that you have to look at.
So diversity is not geographic.
I believe I said that geographic within the footprint is something we certainly would look at in regards to the circumstance on the transmission system. Is it a redundant area? Does it not have strong transmission? So yes, that is a consideration within this footprint itself.
Okay, and could you clarify, are you referring to the Wisconsin electric footprint or the MISO footprint?
Within Zone 2, ATC's footprint, correct.
Okay, so constraining geographic diversity in your response there.
For reliability purposes, correct.
For reliability?
For reliability purposes.
Reliable, thank you.
Okay, and then I had a different question related to the insufficient capacity charge. And I'm tracking all of the back and forth that's been going on related to the 100 megawatt threshold, and the purpose of the 36-month timeline, and all of that was clear to me. I'm curious though on the consecutive nature that's required for 36 months. Given that MISO has a seasonal auction and certain seasons regularly have excess capacity available, would it be fair to assume that it would be impossible to reach this 36-month consecutive over-reliance on the PRA, given WEPCO's fleet is historically long in spring and fall and would have excess resources available? It seems to me that the 36-month consecutive is actually going to capture 3 years, and that the consecutive part might be overkill. And sorry if that doesn't make any sense, but I could try.
It does, but I'd probably have to defer to witness Stac in that regards, from the tariff itself and what the design was and how it's constructed. I would comment it on the 36 months from a length of time it takes from a generation resource and the 100 megawatts.
Okay. I'll leave it there then and follow up with witness Stac on that.
All right. So we've given everyone an opportunity to ask more questions. Do we have any redirect?
I do not, Your Honor.
All right. Thank you very much. Witness Art, you're excused.
Applicant calls Mr. Brandon Gerlikowski.
There you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right. Go ahead.
Mr. Gerlikowski, did you prepare and cause to be filed rebuttal testimony in this matter?
I did.
Is everything that you stated in your rebuttal testimony true and accurate to the best of your knowledge?
Yes.
Do you have any corrections to make at this time?
No.
And are you prepared to provide some brief sir rebuttal on the stand today?
Yes, I am.
And as part of that sir rebuttal, did you prepare an exhibit?
Yes, I did.
Your Honor, we shared that exhibit with the parties in Your Honor yesterday.
Yes, I have it here.
Mr. Gerlikowski, what is the purpose of your sir rebuttal testimony?
I respond briefly to staff witness Mr. Field and Sierra Club witness Dr. Fisher.
On page 4 of Mr. Field's sir rebuttal testimony, he discusses Wisconsin Electric's analyses of the costs and benefits of Red Oak Ridge and Foundry Ridge to non-participating customers. He says that the information provided in Exhibit PSC DRR AJF 3.4 only shows benefits for the future one scenario. Is this correct?
No, the model provided shows future one, but the spreadsheet allows the user to change the planning future as an input assumption to evaluate the economics for each of the planning futures. This allows the user to switch from future 1 to any of the other futures. The model also allows for changes to the sensitivity inputs to identify the economic impact of each unique sensitivity in the analysis.
Mr. Field seeks additional clarification about how firm gas costs will be allocated. Your rebuttal testimony indicated that firm gas costs will be divided between VLCs and participating customers according to the 75-25 split. Can you please provide more information?
Yes. As noted on page 45 of company witness Stasic's rebuttal testimony, the company will be presenting a cost allocation methodology for the firm natural gas delivery charges in its next rate case. This methodology will remove these costs specifically for generation resources from Wisconsin Electric Gas Operations Purchase Gas Adjustment and instead charge the generation facility a demand charge. That demand charge will be accounted for as non-fuel O&M of the generation facility, which would then be allocated the same as all other base rate revenue requirement for capacity-only bespoke resources.
Mr. Field questions whether firm gas costs will be included in monitored fuel costs. How do you respond?
If the tariff is approved, once it takes effect, the firm gas costs will be allocated to VLCs and non-VLCs as explained in my previous response. Only the non-VLC portion would be included in monitored fuel.
Dr. Fisher challenges the results of the economic analyses for Red Oak Ridge and Foundry Ridge. Can you explain why did Wisconsin Electric present those analyses in this docket?
We provided these analyses in response to staff data requests and Mr. Field's testimony. They are illustrative examples, and we are not seeking approval of these projects in this docket. The Commission will make case-by-case decisions regarding Wisconsin Electric's acquisition and subsequent construction of Red Oak Ridge, Foundry Ridge, and other proposed bespoke resources in their respective dockets. Dr. Fisher's testimony debating certain details of the analysis goes far into the weeds for the tariff docket.
Dr. Fisher discusses Mr. Shelendronath's B-store analysis. Was this data used as an input to your analyses?
Yes, the data was used in the analyses for both Foundry Ridge and Red Oak Ridge. However, we calculated each value or each annual value in a base real dollar, which in both analyses was $2,029. Consistent with how these values were included in our Plexos model as a fixed O&M credit for both projects, as well as all generic gas units and battery technologies, the average value across the study period was then used as the basis for each revenue component with general inflation implied, based on the assumption for each planning future. These values were further evaluated by applying the 15% sensitivities to each value in the analysis.
At page 16 of Dr. Fisher's rebuttal testimony, he discusses Red Oak Ridge and testifies that when the values for Mr. Shelendronath's B-store analysis are brought directly...
I'm sorry, you were breaking up. And testifies that...
When the values from Mr. Shelendronath's B-store analysis are brought directly into the need and economic analysis, rather than simply being averaged and then imported into the model, it materially changes the results. And he goes on to state that it reduces the overall savings in the base case from $287 million to $231 million, and it shifts the break-even year from 2034 to 2042. How does using the raw B-store data change your analysis for Red Oak Ridge?
Using the raw data from B-store actually provides a higher percentage of overall savings for Red Oak than our base analysis. Our base analysis indicated that 80% of the sensitivities resulted in positive savings. Using the raw data results in positive savings in 88% of the sensitivities. Exhibit WEPCO Gerlikowski 1 shows this comparison.
How does using the raw B-store data change your analysis for Foundry Ridge?
Using the raw data from B-store still shows 60% of all sensitivities provide net benefits compared to the original analysis showing 67%. Exhibit WEPCO Grylakowski 1 also shows this comparison. Moreover,
I'm just going to interrupt a second. Can we just get a little foundation on Exhibit 1 before we refer to it?
Mr. Grylakowski, did you prepare an exhibit with your SIR rebuttal testimony?
I did.
And how does it respond to Dr. Fisher's SIR rebuttal testimony?
Yes, it does. In his SIR rebuttal testimony, he used the raw data from the B-store analysis. We then replicated that analysis using the raw data and calculated what the relative savings or costs are for all the nearly 3,000 unique sensitivities that we ran, and then charted that on the graph similar to what was provided in my direct testimony or rebuttal testimony.
And this exhibit reflects those comparisons for both Red Oak Ridge and Foundry Ridge, correct?
That is correct.
Your Honor, do you need any more information?
That'll do it. Thanks very much.
Okay. So would you like me to just ask my last question again?
That makes sense. Yeah, go ahead.
Mr. Grylakowski, how does using the raw B-store data change your analysis for Foundry Ridge?
Using the raw data from B-store still shows 60% of all the sensitivities provide net benefits compared to the original analysis showing 67%. Exhibit WEPCO Grylakowski 1 also shows this comparison. Moreover, most of the less favorable sensitivities are part of the future 3 scenarios. We think this future is very unlikely because it shows the lowest load growth, highest annual inflation rate, and moderately high CO2 penalty, gas prices, and coal prices. And it assumes that these poor economic conditions occur for 30 years.
Do your analyses show that non-participating customers are protected from cost shifts under the capacity-only arrangement?
As I stated, the Red Oak Ridge and Foundry Ridge analyses are illustrative examples for this tariff docket. Individual analyses will be presented for other resources in their respective dockets where parties, staff, and the Commission will have opportunities to seek additional information. However, the Red Oak Ridge and Foundry Ridge analyses do show that non-participating customers will be protected under the proposed tariffs. The purpose of our analyses is to show that non-participating customers will not be harmed. When a project breaks even, that is accomplished. The cost-causing customers receive their fair share of benefits and pay their fair share of costs. Our analyses for both resources show benefits to non-participating customers in most sensitivities. While the interveners want to argue that the benefits aren't as high as they would like, that simply isn't the standard for approval.
Thank you, Mr. Grylakowski. This witness is available for cross.
All right, thank you. Get back to my... So the Clean Wisconsin have questions. We got you on the list here. We'll take you first.
We no longer have any questions. Thank you, Your Honor.
No longer? Okay. Anyone else have cross?
Yes. I do, Your Honor.
Let's see.
Krista Westerberg, but I see Commissioner Hawkins has his hand raised and I don't want to step on those.
So thank you. Let me check in with Commissioner Hawkins. I don't see your screen, but I see you're there. Okay, there you go. You have questions for the witness?
I do. Thank you. I wanted to ask a question about your rebuttal testimony on page 27, where you stated that relying on out-of-state resources, which are not nearly as reliable as local resources. I'm wondering if you had any evidence to support that.
Similar to what my colleague, Mr. Arndt, had stated, we are looking for resources that are within our geographic area, and having resources geographically outside of our area do potentially impact reliability because they are not close to the load centers and load zones, which when load is really high, those units may not benefit the customers as much.
Okay, thank you.
Okay, is that it? All right, so move on to Walnut Way.
Thank you, Judge. Good afternoon, Mr. Gerlikowski. I'm Krista Westerberg on behalf of Walnut Way. I have some questions for you about the Sir rebuttal testimony you just offered. And to the question about harm to non-participating customers in particular, you mentioned that you consider break even as demonstrating that there is no harm. Is that right?
That is correct.
And
okay, off the record. So let's off the record. Hang on. So let's please try not to speak over each other. Just wait till people are done asking their questions, and so we can capture what you're saying accurately. Okay, let's get back on. Start with your next question, please.
Thank you, Judge. And you mentioned also what the standard was for approval. What's from where did you obtain your understanding of the standard, or and which standard are you speaking of? The non-harm to other customers?
Based on a net present value analysis, if you break even, that means costs are fully captured by the benefits.
And when you say I understand the technical aspect of your answer. I'm asking from where did you obtain your understanding of what the standard for non-harm is, the legal standard?
I am not a lawyer, so I don't have a legal standard.
So when you were saying that this that the position of the interveners is not the correct standard, did you mean it doesn't satisfy the legal standard?
No, I'm stating that the benefits that we're showing aren't high enough for them to indicate that it meets the standard. Whereas economically, if you break even, you have met the standard of covering all your costs with benefits.
And from where did you obtain that understanding of what the standard is?
Economic background?
It's not a legal determination, correct?
No, I'm not a lawyer.
Your Sir rebuttal, it appeared to me from the Zoom presentation that you were reading that, is that right?
That is correct.
And before you read that Sir rebuttal here today, did you discuss that with others at WEPCO?
Yes, I did.
Okay, and who aside from counsel did you discuss it with?
My colleague, Mr. Arndt.
That is all I have. Thank you.
Thank you.
All right. Any other cross?
Your Honor, I have a few questions.
All right. Go ahead. Just introduce yourself and ask away.
Hello, Mr. Gerlikowski. My name is Priyam Desai. I am an attorney with Sierra Club, and I just have a couple of questions for you based on your Sir rebuttal testimony. You just said that you used the B-Store raw data in the analysis you discussed in your Sir rebuttal testimony. Is that correct?
Yes, I did.
Did you prepare a table or anything of the sort that shows us the benefit in your base case, not the sensitivities that you discussed?
No, I don't believe that was provided.
Can we pull up Mr. Gerlikowski's rebuttal, please? And I'm looking at page 18.
I think I have it here.
Okay. Mr. Gerlikowski, what is the value of the Foundry Ridge combustion turbines to non-participating customers in your base case and future one?
In the base case,
Yes.
it's not identified here on page 18.
Let me clarify. In the reference case.
Are you referring to the table that is on page 18?
Well, I'm using the table as context.
The values shown in the table are looking at the entire set of sensitivities in each future. So there is no one reference case that's identified in this table.
Okay. No further questions. Thank you.
All right. Thanks very
Your
much.
Honor, Commission's staff have a couple of questions.
Let me just ask for other parties. Any other parties? Questions? No? Okay, go ahead, Attorney White.
Thank you. Good afternoon, Mr. Gerlikowski. My name is Evan Weitz on behalf of Commission staff. I just wanted to follow up real quickly on your Sir rebuttal. You were responding to some concerns from Commission staff witness, Mr. Field, about the allocation of gas infrastructure costs. Do you remember that portion of your Sir rebuttal testimony?
In my Sir, I was referring to firm natural gas costs, not infrastructure costs.
Right, but within those subsumed, some of the costs would be billed to the generating customer. Is that correct?
That's my understanding, but that would be better directed as a question to Mr. Stasek.
Okay. Let me ask a follow-up question based on what you said, because I think you had testified that those costs as billed to the generating customers would be passed through as O&M expenses, not as a monitored fuel cost. Did I understand that correctly?
As a VLC customer?
Correct.
Yes.
So for those capacity-only resources, none of those costs billed to the generating resource customer would be included in the monitored fuel costs.
Correct. The only portion that would be the 25% that would be allocated to the non-VLC customer.
Okay, walk me through that, because maybe that's the part that I'm not understanding. So 75% would be an O&M expense, but 25% would be a monitored fuel cost?
No. The 25% would be allocated to the non-VLC customer, and the 75% would be allocated to the VLC customer.
But those would all be O&M expenses, not monitored fuel costs.
The allocation, again, that would be better asked to Mr. Stasek, because we will be addressing that within the rate case, and he is much more familiar with that allocation.
Okay. All right. Thank you.
Yep.
So I had a question for you, Attorney White. As it related to the data request, I think it was the field data request that the witness had walked us through how to view that. I didn't know if staff maybe needed, if they had any questions about that, or if there was something maybe that they needed more clarification on.
I can check. I'm not aware of any need for further clarification at this time.
Okay,
So.
just want to make sure, because I couldn't follow that, so I'm hoping staff knows. All right.
If it helps, Your Honor, this is one data request response that Mr. Gerlikowski's rebuttal testimony refers to as well.
Yeah.
So there's context.
Yeah, I just want to make sure that if staff maybe had any specifics about how to view that the way the witness was explaining on the Sir, then we would want to clarify that now. But
I think we're good. Thank you, Your Honor.
You're good. Okay, that's fine. All right, so any other cross? How about redirect?
I do not have redirect, Your Honor.
All right, great, thanks. All right, thank you very much. You're excused.
Thank you.
And we are going to be switching attorneys again.
Okay. Ominous silence.
Joe Wilson.
All right, Debbie, did you get that?
Yep.
I'm having some problem with my audio. Hopefully this is not going to affect anything, but I'm reading the closed captioning as well. So
when you
all right,
when
so
you turn to your left, it gets quieter.
I knew you were going to say that. All right. I was trying to give myself a little more room to operate, but I'll move my microphone around.
That's okay. I get every couple words.
That's not good. Wait a second. You can't just hear every couple of words. Come on. All right. So we're all set with our witness. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do. I do.
All right, great. Okay, go ahead.
Mr. Shelendronath, please state and spell your name for the record.
My name is Akar Shelendronath. It's spelled AKARSHEILENDRANATH.
Did you prepare and cause to be filed rebuttal testimony and 4 exhibits?
I did.
And was the information contained in your testimony and exhibits true and correct to the best of your knowledge?
Yes.
If I asked you the questions contained in your testimony today, would your answers be the same?
Yes, it would.
And do you have any corrections to your testimony?
No, I do not.
A bit of certiorari rebuttal for Mr. Shelendronath. What is the purpose of your certiorari rebuttal testimony?
I respond briefly to Walnut Way witness Ron Nelson and Sierra Club witness Jeremy Fisher.
In his rebuttal testimony at page 15, Mr. Nelson expresses doubt about your projection for 9 gigawatts of 4-hour battery storage to be added to MISO through 2045 and claims that MISO executives have stated that they expect to add more than 3 times the amount you assume. How do you respond?
As I explained in my rebuttal testimony, this statement is derived from MISO member plans for new capacity projections based on MISO's own RRA study, which I provided as Exhibit 3 to my rebuttal testimony. MISO member plans projected capacity additions are dominated by renewables in comparison with projected flexible resource additions such as battery energy storage systems and gas by a 3x to 1 ratio. All else equal, more renewable additions relative to flex resource additions will lead to higher price volatility.
Are the new capacity projections in MISO member plans sufficient to address all of MISO's resource adequacy needs?
No, they're not. As the RRA study shows, there is a significant gap in capacity projected by MISO member plans and what the MISO region needs to address MISO states' policy goals and resource adequacy. The MISO RRA study projects the MISO region would need to add 174 gigawatts of new renewables capacity and approximately 41 gigawatts of battery energy storage flexible capacity starting in 2030 through 2043. The RRA study shows a 3.5x to 1 ratio, which is higher than the member plan ratio I just talked about, at 3 to 1, for renewables to flex capacity additions. What it indicates is that there's even more greater likelihood of higher price volatility and not lower.
On pages 15 and 16 of his rebuttal, Mr. Nelson criticizes your citation of MISO's 2025-2026 planning resource auction, where he claims, quote, summer capacity prices cleared at $666.50 per megawatt day, driven by declining surplus capacity. However, just a few months later, the Organization of MISO States MISO annual survey showed that just 1 year after facing a 2.7 gigawatt capacity shortfall, the market now expects a 1.1 gigawatt surplus for the upcoming summer, end quote. Is this accurate?
No, not quite. In my opinion, Mr. Nelson conflates short-term projections of capacity surpluses and shortfalls.
I'm sorry. He conflates what kind of projections?
Short-term projections of capacity surpluses and shortfalls with long-term trends in capacity needs. Exhibit 3 to my rebuttal testimony, MISO RRA study, reflects MISO's most up-to-date projections for capacity need in the region and shows that MISO will need to build on an average of 17 gigawatts of new capacity annually through 2043. The recent historical development rate, which MISO reports in that same study, for 2020 to 2022 was only 4.7 gigawatts per year. Even under the 2025 OMS MISO survey's upper end projections, MISO's new resource development is expected to be 6.2 gigawatts per year, which is significantly lower than the 17 gigawatt per year that the MISO RRA study identified as necessary. Further, the MISO RRA study cautions at page 31 that the 17 gigawatts per year need could even be higher given the large load additions that are expected in MISO region due to growth of data centers, electric vehicles, and other factors. It says the load assumptions used in the RRA study do not account for those types of large load additions.
Do you have any other reactions to Mr. Nelson's characterization in his rebuttal testimony of the MISO survey?
Yes. The 1.1 gigawatt projection that Mr. Nelson references on page 15 of his rebuttal is based on one end of the range of surplus shortfall projected by the 2024 OMS MISO survey. For the 2025 planning year, the survey projected a potential surplus of 1.1 gigawatt and up to a potential shortfall of 2.7 gigawatt. Even 1 year out, projections cannot be determined precisely due to the uncertainty of resource development trends, which is why the survey uses a range and not a point estimate.
On page 14 of his rebuttal, Mr. Nelson criticizes WEPCO for not considering, quote, a wide range of sensitivities in the amount of storage and transmission capacity, end quote, that he argues could result in lower price volatility. How do you respond?
I disagree with this, with his criticism. The company's analysis only adds historical realized volatility to projected prices, which is conservative given the projections for significant amount of capacity need in MISO and significant renewable additions forecasted to meet MISO's state's policy goals. Reasonable sensitivities around volatility projections would include all those with higher volatility, which would increase the value of the bespoke facilities. Projecting lower than historical volatility has no basis and is inconsistent with MISO's long-term resource development trends that address the system's resource adequacy needs.
Turning to Sierra Club witness Mr. Fisher, on page 19 of his rebuttal testimony, he presents what he calls a corrected version of the Red Oak Ridge and Foundry Ridge CT net benefits and costs analysis. How do you respond?
Mr. Fisher's analysis shows that the expected value of excess benefits to non-VLC customers is robust, regardless of the use of B-store value trends or the company's averaging methodology. Mr. Fisher's own analysis, which he notes employs the projected values directly from B-store, shows that both assets, bespoke assets, still yield expected value excess benefits of $16 million to $330 million to customers. These figures are extra benefits to non-VLC customers, which they realize after fully recovering their allocated 25% of cost share. Mr. Fisher's analysis also reveals that the future 3 downside case, using B-store values, is more favorable to customers than the company's analysis. Red Oak Ridge is projected to yield an excess benefit of $12 million on top of fully allocated cost recovery, and Foundry Ridge is projected to yield a cost recovery deficiency of $45 million or 19%, compared to the deficiency projected by the company's analysis of $67 million or 28%.
What do you make of Mr. Fisher's argument that the base case net benefits decrease from 14 million by 2058 to effectively zero on page 18 of his surrebuttal testimony?
This argument appears misleading. The 14 million estimate reducing to zero indicates that non-VLC customers in this scenario do not recover more than their allocated costs, but rather that they recover benefits to fully offset, but no more than their allocated costs. Non-VLC customers fully break even at zero excess benefits. In other words, even under Mr. Fisher's overly pessimistic scenario, non-participating customers aren't harmed.
Do you have any other thoughts on Mr. Fisher's response to your analysis?
Yes, just last one. The volatility reflected in my analysis is simply the realized historical volatility. As I mentioned earlier, there is no evidence that future volatility will be lower than historical. All fundamentals projected by MISO indicate that the potential for higher volatility than historical, which will lead to greater benefits from bespoke resources due to higher market energy prices.
Does this conclude your surrebuttal testimony?
Yes.
Mr. Shelendronath.
All right, thank you.
Our commissioner questions.
All right, so we had Clean and Walnut Way for cross. So go ahead, Attorney Cordy.
Thank you, Judge. Good afternoon, Mr. Shelendronath. My name is Brett Cordy. I'm an attorney with Clean, Wisconsin. Just a couple questions for you today. So in your rebuttal testimony and in SurSur today, you've been discussing modeling for Red Oak Ridge and Foundry Ridge. Is that right?
Yes, that is correct.
In your rebuttal on page 20, starting on line 7, you said, quote, in years when the unconstrained dispatch exceeded 20% annual average capacity factor, I performed a ranking analysis to retain only the most profitable operating periods and associated net revenues until the annual capacity factor was reduced to 20%. My question is, for how many years within the modeling did you perform this ranking analysis? And if it's different for the two projects, I'd like to know.
I perform it for every year. So as I've explained, I run the model for 5 historical years. And for each historical year, I perform that ranking analysis. It matters if that 20% constraint is binding when the asset's market dynamics allow it to be economic more than 20% capacity factor. That capacity factor constraint binds, and that's when I perform that for each historical years. And then I perform for each forward year as well, from 2029 through 2055. And for both the assets.
So I'm sorry if I'm misunderstanding, but the unconstrained dispatch exceeded 20% annual average capacity factor for every single year?
Not for every single year. I'm performing it for 4 different scenarios and for 2 different assets for roughly 30 years. Not for every single year, but for most years in most of the fundamental futures or the company scenarios, they do exceed more than 20%. There are a handful of years, I believe a couple years in historical years for one of the 2 assets and a few years. I'm going to have to check exactly which year, but largely for almost every year, they do exceed 20%.
I'm sorry, they do exceed how much percent?
The 20% annual capacity factor constraint.
Thank you.
Okay, that's helpful. Thank you. No further questions.
All right, thanks. Walnut Way, questions?
Krista, you're muted.
Classic. Thank you. Sorry about that. Good afternoon, Mr. Shelendronath. This is Krista Westerberg on behalf of Walnut Way. I have some questions for you about your, your rebuttal testimony.
I'm sorry, which testimony?
Rebuttal.
Thank you.
And in particular, can I have you look at page 3, line 21?
Give me one moment. Did you say line 21, counsel?
Yes. Yes. And lines 21 to 24 in particular.
Yes, I'm with you.
Okay. And can you just, these lines of the testimony describe the analysis you were asked to provide by Wisconsin Electric related to the value of Red Oak Ridge and Foundry Ridge, is that right?
Yes.
And that was your rebuttal testimony containing this information was filed on January 28th, 2026, correct?
Subject to check, I'll accept that.
Okay. You were retained to do the analysis itself on July 10th of 2025, is that correct?
Yes.
And then you provided it to the company on October 10th, 2025, correct?
That is correct, yes.
And just to understand a little bit more about that analysis, can you go down to page 6? Line 15.
I'm there.
And you say you employed PSO and B-Store as part of your analysis, is that correct?
Yes, that is correct.
And can you just briefly explain what PSO is?
PSO is a production cost simulation software. It's a commercially available software. And B-Store is a module that Rattle developed that functions with the optimization engine of the PSO commercially available production cost software.
And I believe you say earlier in your testimony that B-Store is proprietary, is that right?
That is right. We developed that internally. It's really an analytic framework, but the simulation is entirely done on a commercially available software. But the framework is the module.
And the commercially available software is that subject to licensing?
It is.
The SIRSA rebuttal that you were providing us before, is it fair to say you were reading that from a document you'd prepared ahead of time?
That's right, yes.
Okay. And did you work with anyone else at WEPCO in order to prepare that?
No, those are my statements. I prepared them.
Okay. And did anyone with WEPCO review them before you read them?
My counsel reviewed them.
And by that, do you mean the WEPCO counsel?
Yes, WEPCO counsel.
Thank you. That's all.
All right, thanks. I see Commissioner screen is up, so did you have any questions?
I did. Thanks, Your Honor. I had a question related to your rebuttal testimony. You state that the Brattle RA analysis, the WRAS, analyzes geographic diversity, and I was wondering if the results of the modeling support the idea that all resources to serve
new loads should be located within a single zone.
Commissioner, that analysis is still underway. It's a capacity expansion analysis that considers broader geographic scope, all of MISO, rest of LRZ2, WEPCO, and the trade dynamics between them. I don't have the results to speak to yet, but in general, resource diversity can occur from within LRZ, within WEPCO, or across LRZ, WEPCO, across MISO, WEPCO, across MISO, LRZ2. But it is not the only aspect that affects resource adequacy. It's contemporaneous with coincident and non-coincident load conditions, temperature correlated outages, resource mix in different places. So all of those are collectively they collectively have an impact on resource adequacy. That's why we run the model to identify them. We don't have results to speak to it yet.
Okay, thanks. And that leads to my next question. Your description of the modeling states that severe weather events are analyzed in the RA analysis. And I'm wondering if those severe events impact generators that are geographically located close to one another, assumed to occur at the same time, or is that randomized? How is the severe weather impacts assessed in the modeling?
Yeah, so it's not randomized, as in it's not a probabilistic loss of load expectation analysis type of a study where different variables are randomly triggered off or on. Rather, we do a statistical assessment where I review what the temperature correlated outages of conventional resources have been historically. So this is actual data. And there's a statistically significant relationship. We measure that statistically significant relationship, and we use that in forward analysis where there's a range of weather conditions that are simulated. When those temperatures occur, that relationship of outages of conventional resources are then modeled. For renewables, it's the same thing. We use publicly available data source. Renewable Ninja, for example, provides satellite specific information of renewable surpluses, droughts, actual hourly production, and we sample from that. And then that's contemporaneously analyzed with the weather condition that we're simulating.
Okay, thank you. And then my final question was related to your description of how resource adequacy value is shared between the VLC and non-participating customers. And I just would like you to clarify how non-participating customers could be receiving resource adequacy value when 100% of the capacity value would be assigned to the VLC.
So that's a tariff structure just to on the assignment of capacity value. But in resource adequacy paradigm, all load needs to be served, regardless of who the customer is. And resource adequacy manifests because there is a firm capacity need as well as a non-firm energy need. And both needs to be satisfied for all customers. The system is operated that way even within the context of MISO. And MISO's requirement for the company is to carry sufficient firm capacity to address its firm requirements, including operating reserves. That's not broken down by customer classes, participating or non-participating customers. They just have to carry that much firm capacity. So all of that load plus non-participating customers' load and their growth projections are collectively analyzed with the entire portfolio of resources Wisconsin has, plus energy trade dynamics that's available through the transmission system between them and rest of LRC2. So
I'm sorry, between them.
and the MISO LRZ2.
Thank you.
So these resources provide capacity value, regardless of whether it's allocated to non-participating, VLC customers or not, during resource adequacy conditions, based on their availabilities, based on their temperature, ambient temperature correlated outage risk, all of those conditions.
But would it be fair to say that you have to meet that resource adequacy obligation for the VLC load and non-participating customer load together?
That's right. That's how we would model it, and that's the way MISO sees it as well. The requirement is for WEC to carry enough firm capacity for all its projected firm demand, which may be broken down by VLC and non-VLC.
And so then you wouldn't be able to count it twice for the VLC and the non-VLC?
Can you please elaborate on that question? I just want to be sure I fully understand what you're asking.
To meet the requirement, you have to add up, a certain amount of capacity, and if a certain quantity is counted towards the VLC load, you wouldn't be able to use that quantity to count towards the obligation of non-participating customers. Is that correct?
That sounds right, but the way I think it would manifest, what you're asking me, is you would add both their loads and you would add the full capacity plus all of the portfolio, and together that full portfolio should be sufficient on a firm basis to address the needs of the full load, including VLC and non-VLC loads that are projected. So there's no double counting there. It's just analyzed collectively.
Okay. I think I'm still confused on how your testimony states that there would be a resource adequacy benefit when the full resource adequacy contribution would be allocated to the VLC. In your response, you started to talk about providing energy in different hours, which is not a resource adequacy or a capacity benefit. That's an energy concept. So I'm just trying to be clear on if we could double count the resource adequacy value of these capacity only bespoke resources, and if they would value or add value to both the VLC and non-participating customers, or if the value of the resource adequacy contribution would only go towards the VLC.
The first part of the analysis, the energy value estimation, are associated with the net revenues the asset generates by participating in MISO's energy and ancillary services market. It earns revenues there. The resource adequacy construct is a requirement to have sufficient firm capacity. It's not a monetized concept. There is no, there is a capacity value and there is a market, but there are no monetization or trades of those capacity. But the resource adequacy concept is simply one that says, as a load serving entity, you have a certain native demand, and that could be bifurcated across customer classes regardless. But in totality, there's a certain native demand, and all of that native demand needs to be met with firm capacity resources. You can buy that from the marketplace, or you can have your own assets. So we study that collectively. One is a monetized concept, and the other one is a requirement, which still captures the value. It's just not monetized into dollar terms.
No further questions.
All right. Thank you, Commissioner. And do we have other cross? How about redirect?
No redirect, Your Honor.
All right, that's fair. Thanks very much. You're excused. And we'll take, who do we have left from the company? Just Stac.
Got Mr. Nelson up next, Your Honor, and then Mr. Steve.
Okay, that's fine. Thanks.
Good afternoon, Your Honor, and good afternoon, Debbie. Attorney Patrick Proctor Brown, returning to the attorney chair.
All right. Welcome back. And we have our witness there. So let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Mr. Nelson, would you state and spell your name for the record?
Aaron Nelson, AARON, NELSON.
Mr. Nelson, did you prepare and cause to be filed rebuttal testimony in 2 exhibits?
Yes, I did.
Is the information contained in that rebuttal testimony in the 2 exhibits true and correct to the best of your knowledge?
Yes.
Your Honor, I would offer those that testimony in those exhibits for the record.
Yes, they're in.
Thank you. Mr. Nelson, I have a couple more questions for you. Have you reviewed Commission Staff Witness William Cable's analysis and exhibit PSC Cable 4P?
Yes, I had the opportunity to briefly review the analysis prepared by Mr. Coble, which was provided to me on Tuesday.
What is your reaction to Mr. Coble's analysis?
Although I have no reason to dispute Mr. Coble's math, given the short time frame, my review is only preliminary. However, I was able to analyze a break-even point on a net present value basis between the 2 cost recovery methods based on varying the estimated project costs.
Please explain how you conducted a break-even analysis.
Although I did not have Mr. Coble's work papers, I understand that his analysis begins with the work papers, Wisconsin Electric, provided in response to Commission staff data requests. I modified those work papers to use the same inputs that Mr. Coble relied on for exhibit PSC Coble 4. I then solved for the amount of capital investment that would be needed to produce a $0 net present value comparison over the study period, holding all else equal. The resulting amount of rate base is approximately $978 million of transmission project costs. This amount is roughly $421 million less than the total amount informed by the payment and cancellation agreement referenced in Mr. Coble's surrebuttal testimony.
What does the $421 million number represent in the break-even analysis?
If the capital costs for transmission investments to exclusively serve a VLC customer are $421 million less than in Mr. Coble's analysis, then non-participating customers on a net present value basis do not have costs for transmission service shifted to them under the proposed tariffs. My colleague, Mr. Stac, discusses this further.
Does that complete your testimony, Mr. Nelson?
Yes.
Your Honor, Mr. Nelson is available for cross.
Okay, did we have any questions for Mr. Nelson? No.
If none of the parties do, Your Honor, Commission staff has one follow-up question.
Yeah, I think Commissioner Hawkins is also on the line for that. So let's take the Commissioner's questions first.
Thanks, Your Honor. I just had a question on what was just stated about the lack of cost shift to non-participating customers. Was there a timeline provided for that in your finding of the lower total cost?
Yes, there was. So the analysis focused on the entire study period and determined a net present value over that entire study period.
Okay, but I think you started talking about a break-even point. Was there a year associated with that?
Just the collective net present value of the costs under the direct assign method compared to the net present value of the costs under the load ratio share method. Over the entire study period, the net present value arrived at the same result. So the difference between the two scenarios was 0.
Okay. I don't think I have anything further then.
Okay. And commission staff?
Good afternoon, Mr. Nelson, Attorney Evan Whites on behalf of commission staff. I guess my follow-up question, so it sounds like you performed some sort of new analysis based on some adjustments to the assumptions in commission staff witness Cobal's testimony. Do I understand that correctly?
Yes, that's correct. The assumption that was varied was strictly the capital costs.
Okay. And I infer, but I want to get your confirmation. Did you produce a similar then work paper to commission staff witness Cobal's exhibits that would have the breakdown of those costs that you used to arrive at the conclusion you stated here today in Sir rebuttal?
I do. There will be a slight difference because I do not have the additional rows of analysis that Mr. Cobal performed from a commission staff analysis perspective.
And
are you willing to provide that as an
example? I have to interrupt for a sec. Apologize here, I didn't interrupt. You should take a quick break. We're just going to be back in a minute or so.
Sure.
Okay. Thank you for indulging that. I will be paying a lot better attention now.
Your Honor, I wonder if we might have a discussion off the record about the line of questioning that
we weren't on the
Attorney
record.
White's.
We can.
Yeah.
Well, let's just hear.
We
what
just
you
weren't
have
on
to
the
say
record. I
this
could
thing.
hear you talking, and I heard you say on the record, but
Right.
No,
Right. Okay.
So we weren't
Okay.
provided.
We can be off the record. Go ahead.
okay.
We weren't. I'm not muted. I don't think.
No.
Okay. We weren't provided Mr. Cobal's
No, I
work
can hear
papers. He had the PCA that he based his analysis on in December, but chose to present the analysis on Tuesday. We're now at the hearing. It's basically the offered evidence list is closed. I don't think it's appropriate to have some sort of delayed exhibit after the close of the evidence. We've presented the break-even analysis, and I think that's sufficient for the clarity of the record. But opening up the evidence here to get a work paper that we had to scrape together in 2 days when we didn't have the work paper to begin with is a little bit tangential to the overall proceeding. This infrastructure project is the subject of a different construction docket before the commission as well.
And Your Honor, I guess my concern is, so we have a conclusion in the record at this point, but there's no way to verify any of the inputs that go into that conclusion in the...
That's true of staff's testimony that was filed on Tuesday. They didn't provide their work papers, and they have a position that they won't provide their work papers to us.
Well, I think that there's numbers provided to support the analysis and the exhibits accompanying the testimony. I'm not looking for, and that's why I asked the question if it was in a similar format to the exhibits that were provided by witness Coble, which I think the answer was yes, other than a couple of lines maybe that were not included. I think witness Nelson said. That's what I'm looking for.
But it can't be presented with any other testimony. The record's closed. So we would have a freestanding exhibit that, what will we do with it? It would just be filed?
I think
staff
it's
doesn't file briefs. Staff, will we hold the record open for analysis, to rebut analysis that should have been done in Mr. Coble's direct testimony? We've really kind of gone pretty far afield from the schedule in this case to talk about a construction project that is pending in a different docket.
I think the reason that it should be in the record is it's up to the commissioners to take a look at it and determine whether or not it supports the conclusion that was just drawn in Sir rebuttal testimony.
I guess I just disagree. That's not how this is set up, right? Where the FMO says we're not really supposed to even use exhibits in Sir. The analysis was very late in Mr. Coble's Sir rebuttal testimony. It really, frankly, wasn't responsive to anything in rebuttal. So now we would have a freestanding document that can't be explained by a witness in the record.
Well, we have a freestanding conclusion that has no numerical basis supporting it, is my concern.
You've asked him questions about it, and you're entitled to due process. But that's the nature of these hearings, is we're supposed to kind of sift and winnow the issues. And we had a day to respond to new analysis that was based on data that Mr. Coble has had since December.
I don't know what to say further, Your Honor. I think that it is valuable for the record if there is going to be a conclusion about a break-even point and testimony that differs from exhibits that are in the record to have a comparable data supporting that conclusion.
Okay, let's get on the record. So I guess first, let's just have Attorney Weiss describe again for the record the exhibit, that the information that staff is seeking.
Sure, and it might be helpful to recap. I think before we took a break, I was asking witness Nelson if supporting the conclusion that he testified to just now in Sir rebuttal, he had a similar work paper to those that are included in Commission Staff Witness Coble's exhibits supporting that conclusion about, I believe he testified, his term was break-even point. And I believe, but witness Nelson can correct me if I'm wrong, that he said he did have a similar work paper with maybe a couple of lines that were slightly different. So my request, which is where I think I was headed at the time we took a break, was whether or not witness Nelson would be willing to provide that comparable work paper as an exhibit.
Okay.
And I think that's generally correct, Your Honor. What I would say is Mr. Coble didn't provide his work papers, and that's what Mr. Nelson testified to, is he had to use our own analysis. We understand, although it's not entirely clear from Mr. Coble's Sir rebuttal testimony. He used our work papers, which we provided, to create new work papers, which he didn't provide. And so we had to do some adjustments to our work papers to reach that break-even analysis. And we've really reached, I think, the point of diminishing returns here, because Mr. Coble had all of the data he presented in Sir rebuttal in December, just as he had the data for the testimony he presented in his direct. But Mr. Nelson hasn't had the opportunity to provide written testimony fully explaining an exhibit because Mr. Coble chose to present new analysis unresponsive to rebuttal testimony in his Sir rebuttal testimony filed on Tuesday. So now we essentially hold the record open for a new exhibit that can't be explained by testimony. That's what Mr. White's request is, even though Mr. Coble didn't provide work papers of his own either.
Okay.
Your Honor,
so
if I could just respond, I think we're misusing the work paper term because witness Coble did provide PDF files as exhibits with the numbers that support the tables in his testimony.
And I guess I would say that's not the complete worksheet, right? So there are formulas, there are other inputs that we did not see and had to essentially assume were the same as our analysis because Mr. Coble did not provide the actual work paper, the spreadsheet that went along with it. He provided a flat PDF. And it's my understanding that that's commission staff's position, is that they won't provide work papers to other parties because they're not subject to discovery. They will only provide flat PDFs. Mr. White's argument is we need to be able to test the data, test the quantitative analysis, and he's asking for Mr. Nelson to provide the work paper, the Excel spreadsheet.
Your Honor, maybe I can short circuit this. That's not my request. My request was that the numerical underpinnings be provided in a similar format to witness Coble's exhibits so that the commissioners reviewing the record can test the numbers that support the conclusory statement that witness Nelson testified to.
Okay, so let me chime in here if I can get a word in. Is the company seeking to strike the surrebuttal? I haven't heard a motion to strike that surrebuttal as being filed out of order.
No, we haven't moved to strike it, Your Honor. We decided we would not strike it. We don't think it complies with the scheduling order, to be fair, but we didn't want to burden the proceeding with additional motion practice when we believed Mr. Nelson could provide just 3 questions to clarify some of the inaccuracies we saw in that analysis.
Okay, so the company has in the past and did in this case file offer an exhibit here today for surrebuttal. What's the issue about offering exhibits on surrebuttal that you mentioned?
My understanding is, Your Honor, from past proceedings, and the FMO I think slightly addresses that, is that lengthy exhibits shouldn't be provided on surrebuttal. We did offer the exhibit for Mr. Gurlikowski. Didn't have any objections. What we're now talking about is offering an exhibit unmoored from testimony at a later date that can't be explained by testimony. So when does the record close? I guess is my question, Your Honor.
Well, let's get some clarity. I mean, the witness is here. The witness produced that study. What can't the witness testify to now?
Your Honor, he doesn't have it in front of him. It isn't prepared as a PDF, and he's not prepared to talk about all of the details of it. I don't believe. We could take a break and recall him, I guess, if that's the way we want to go. But
yeah, I think that's probably the best case. Let's do that. We'll recall the witness when this proceeding will certainly go on for a while. Let's have the witness get recalled. We'll prepare those work papers into an exhibit, and we'll be able to discuss it. I guess I think that would be helpful. I don't necessarily condone where we're having exhibits filed after the hearing. There is a process for doing that, however. So when I just want to make sure we understand that there is a timing and there is certainly we try to make a robust a directional winnowing of the record as we move on from filed evidence, rounds of filed evidence. However, there is an opportunity even after the hearing to request that I admit additional evidence. And then there can be a process by which we vet that evidence. It could either, depending on the needs and what people may agree to, it could be another hearing. It could be a paper process. But It sounds like this issue, and this issue in particular, is obviously one of great importance and attention that the commission is giving. So, we're not off on a tangent here. I think we'll have the witness come back and be able to be more prepared for this. That's our best solution. And like I said, I just want to re-emphasize that the way it's characterized as saying the record is closed. I don't use that terminology. I think there's a fairness factor. There's a due process that we need to provide, but there is no closing date of the record per se. So depending on the needs of the case, we can handle new information if necessary. So having said that, I think our best opportunity to solve this conundrum here would be to recall the witness during the course of the proceeding. If not, we can work on a post-hearing exhibit filing. But I think it's fair to say if the witness is stating a conclusion and parties or staff need more information about that, the work papers that go about rendering that, getting that witness to the conclusion, that's fair, and we can handle that procedurally if needed. So let me ask Attorney Whites if there's any other questions you got.
Your Honor, no, and I would just offer, I don't intend to cross on that particular topic. I just think for parity's sake, if there's going to be a conclusion in the record, it should have a supporting exhibit, just as witness Coble has supporting exhibits so that the commissioners can compare those directly rather than just looking at a bare conclusion without seeing whether the numbers match up or where they differ. So if the company is willing to provide that in a similar PDF format to the exhibits provided by witness Coble, I don't think we necessarily need to recall witness Nelson.
That's fine. We'll submit.
Okay.
I guess we'll file exhibit Nelson 3, which will be a similar PDF schedule.
Okay, let's just go off the record for a second. Too many Nelsons. Or maybe not enough. I don't know. So, how should we define this exhibit? Is there someone who can give me sort of a title or a description? We can take that on the record if someone's prepared.
Now?
Well, let's see if someone's prepared to give us. I mean, the witness may be the best person for that. So,
yeah, I can ask a question to them, Your Honor, if you don't mind.
So, you ready there, Debbie?
Mm-hmm.
Okay,
Mr. Nelson, you were present for the discussion of your work papers and your analysis of the break-even point, correct?
Yes, I was.
And Mr. White's asked you some questions about the spreadsheet that you developed to conduct that break-even analysis, correct?
Correct.
And we've marked now Exhibit WEPCO Nelson 3. Would you please describe generally what that exhibit would be?
That exhibit would be indicative transmission analysis with a additional break-even sort of results. Guess one more thing, if I could note, that would be a DCI secret.
I'm sorry.
So, Mr. Nelson, what would the content of the exhibit WEPCO Nelson 3 need to be protected under the protective order in this case?
Yes, I believe it would need to be protected under DCI trade secret.
Thank you, Mr. Nelson.
All right. Well, let's file it confidentially, please.
Thank you. We will.
All right. Great. All right. Is there anything else from staff?
No, Your Honor, that was it. Thank you.
Okay. So before we get to redirect, and we have all the parties checked in here. Any other questions from parties while we're?
Yes, Your Honor. This is Krista Westerberg. I do.
Okay. All right. Go ahead.
Good afternoon, Mr. Nelson. This is Krista Westerberg on behalf of Walnut Way. I have some questions for you about your sir rebuttal you provided. As I've asked the other witnesses, did you read your sir rebuttal testimony today as you're sitting here?
Yes, I did.
Okay. And did you have the opportunity before you read that to discuss that with others within WEPCO?
Yes, I did.
Okay. And with whom within WEPCO did you discuss it?
My colleague, Mr. Rich Stasek.
That is all I have. Thank you.
Okay, that's it. All right. So I did have a question. It relates to the document I asked the applicant to provide the CP1 sort of standard tariff forms, and I don't know if the witness would be the best one to ask a question about how CP1 is a customer in CP1 is normally or under typical circumstances applies for service, and how that's evaluated. Is that,
don't believe Mr. Nelson has a customer-facing role. Maybe, and to be honest, I don't think any of our witnesses have a customer-facing role in that concept.
Okay, and then in terms of, well, I know. Okay. So that witness wouldn't have any familiarity with the application for CP1 service?
I don't think any of our witnesses that we've sponsored in this proceeding, Your Honor, have direct knowledge of how a prospective CP1 customer applies for and starts to receive service. They may have some tangential familiarity with it, but I don't believe any of them are directly involved in the process of an industrial customer applying for and receiving service.
Okay, that's fine. All right, so we'll so then we have this witness available for redirect.
No redirect, Your Honor. Thank you.
Okay, great. All right, well, thanks very much. You're excused.
Thank you.
Your Honor,
So
applicant would call Mr. Stasek.
All right, so just off the record, so I had a break, but I'm willing to take a break for everyone else. We can do a half hour before we take Stasek and then get back.
That would be fine with applicant, Your Honor.
All right. Anyone else have anything to say? All right, let's do that. So we'll round it off for 2:30. Get back at 2:30. Thanks.
Thank you, Your Honor.
muted it. I just have that paranoia. So
Yep, I had an older co-counsel who did it, and but did
All right, it's 2:30, so let's get back on track here.
Why does everybody move?
They turn their cameras off. I think that's...
No, like everybody's well, not according to anybody but me, but everybody's all over the place now. I'm used to seeing people in certain spots.
Oh.
Like you're usually up in the upper left-hand corner. Now you're in the middle.
Don't know why that's happening. Yeah, I can set the view for everyone if you want me to.
No, that's okay. Mr. Stasek, can you move the camera down a little bit because I can't see your mouth. Thank you.
Well, maybe that'll be... So I thought there was a way if I could spotlight more than one person and it's just them that everyone sees, but I think I don't know why that's not working today, but what I can do is...
Don't take the time for me. Don't worry about it.
That's okay.
Your Honor, while we're off the record, I did, someone noted that on YouTube when the applicant witnesses were testifying, it was because I think the YouTube just registers who's speaking.
Yeah.
That they weren't visible. So I don't know if there's a magic way to fix that for the reasons you just said that you'd have to spotlight two people, but noting it for your awareness.
No, well, YouTube doesn't work like that. It follows whoever's mic is on. It's going to show that screen. So because Quarles and Brady, they're using one microphone but two cameras, it's only going to show the person who's in front of the microphone on YouTube. So just so you know, attorneys over there, you're always on even when your witness is talking, you're the one people are seeing on YouTube. But it's just a quirk. I can't really, unless you guys want to switch seats every time, or I don't know what you do, fix that. So, but looks like we're ready to go. Everything seems to be working at least. So let's get started with witness Stasek. I think we're ready to go. So I'll swear you in. Raise your right hand. And do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, great. Go ahead.
Thank you, Your Honor. Mr. Stasek, would you state and spell your name for the record?
Sure. It's Richard Stasek, Stasik.
Mr. Stasek, did you prepare and cause to be filed direct, rebuttal, and surrebuttal testimony?
Yes, I did.
And did you prepare and cause to be filed 15 exhibits?
Yes.
And to the best of your knowledge, is the information contained in your testimony and exhibits true and correct?
Yes, it is.
Mr. Stasek, I have some additional questions for you, focused on the testimony of Mr. Coble, Mr. Mulemans, and Ms. Probst. First question for you is, have you reviewed Mr. Coble's additional analysis of transmission costs at surrebuttal PSC Coble 2 to 4?
Yes, I have reviewed Mr. Coble's surrebuttal testimony.
How would you characterize Mr. Coble's results?
Well, the PCA that Mr. Coble used for his analysis in his rebuttal testimony was submitted by the company in December, so he could have presented that analysis with his direct testimony in January. That aside, Mr. Coble's analysis assumes all costs in the referenced PCA would be incurred are exclusively incremental costs that will be incurred to serve the VLC referenced in that PCA. But that's not necessarily true. First, within that PCA, there are $330 million of costs identified as contingency by ATC for the purposes of protecting other customers. As contingencies, these costs are not part of the capital cost of the transmission projects and may very well and likely not ever be spent. Second, I understand that MISO has determined certain transmission upgrades that are included within that PCA are necessary for overall system reliability and stability as part of its regional transmission planning process. This means that a portion of those costs included in the PCA would have been or will be incurred to provide reliable transmission service to southeastern Wisconsin, irrespective of the VLC and their plans to invest in the region.
What is your understanding of Mr. Nelson's break-even analysis and how it relates to transmission reliability costs and the contingency costs in the PCA?
Given the factors I noted in my prior response, there's a significant probability that the actual cost for transmission investments made to exclusively serve the VLC and backstopped by the VLC in the PCA are lower than the break-even cost that Mr. Nelson presented in his testimony. If that's true, then correcting Mr. Cable's analysis would show a net benefit to existing customers under the proposed tariffs, even if that project were included as Exhibit STASIC 12 within my direct testimony.
Sorry, is that, you said like Cable, or is that Coble? Is that the same name?
I'm sorry, Coble. I'm probably not pronouncing it properly. That's
fine.
my error.
I just wanted to make sure it was the same person. Thank you.
Yes, sorry.
No, Evan, is it Coble or Cable?
Coble.
Coble, thank you. I didn't know that either. I'll probably get this one wrong too, so apologies to the witness. Mr. Stasek, I want to shift gears to Mr. Mulemans. Have you reviewed Mr. Mulemans' testimony about a rider-style tariff?
I have, yes.
What is your reaction to Mr. Mulemans' proposal?
Mr. Mulemans' proposal is very similar in effect to what the more detailed proposal for reevaluating the cost allocation of 75% versus 25% of base rate revenue requirement allocation for capacity-only bespoke resources I testified about in my rebuttal. Both proposals attempt to address a situation where the actual benefits of capacity-only bespoke resources are not the same as those forecasted.
Are there benefits to your proposal compared to Mr. Mulemans' proposal?
I believe so, yes. First, Wisconsin Electric's proposal is more detailed and would establish a specific cadence and mechanism for adjusting rates for both the VLCs and non-participating customers. Mr. Mulemans is clear that staff has not developed a full proposal in his rebuttal testimony. Second, it is not clear how Mr. Mulemans' proposal could be fully developed before Wisconsin Electric's next rate case, which will be filed on or about April 1st of 2026, just a few months from now. Third, we worked closely with the VLCs to develop the proposal I submitted with my rebuttal testimony, and I understand that the VLCs do not object to that proposal. I believe that the proposal I presented in my rebuttal testimony is preferable to Mr. Mulemans' suggestion that the Commission order Wisconsin to propose some non-fully specified change to these tariffs shortly after they would be approved.
Have you reviewed Mr. Mulemans' testimony at page 6, in which he proposes a concept of a floating ROE that would be pegged to ROE authorized in rate cases?
Yes, I have reviewed that as well.
What is your reaction to that proposal?
In all of our discussions with the VLCs to date, they have emphasized the importance of cost predictability. The current VLCs were willing to agree to a higher and fixed ROE as included in the proposed VLC and bespoke resources tariffs in order to ensure that stability and predictability on that aspect of their energy costs. From Wisconsin Electric's perspective as well, having a fixed ROE provides predictability and enhances our ability to plan for the future. And from non-participating customers' perspective, Having a fixed ROE for the VLCs and the bespoke resources to serve them doesn't really make any difference to them. Therefore, we would oppose Mr. Milliman's proposal on this issue.
Thank you, Mr. Stasek. Moving to Ms. Probst. Have you reviewed Ms. Probst's testimony recommending deferral accounting related to the minimum billing demand charge proposed by Mr. Coble?
Yes.
Do you agree that deferral accounting is needed?
I do not. Wisconsin Electric's position is that the minimum demand charge is inconsistent with the MISO tariff, not linked to any overall harm to non-participating customers, and should not be approved. Even if that minimum billing demand charge is not approved, deferral accounting is not necessary.
Do you propose a clarification to Ms. Probst's proposal?
Yes. Ms. Probst seems to presuppose that any overcollection from VLCs for transmission costs would be given to non-participating customers. In our view, if the Commission were to approve deferral accounting, it should not prejudge how and to whom the deferred balance should be returned. There are situations where VLCs will contribute more to transmission costs overall, even if there is a deferred balance under Ms. Probst's proposal.
Would you give an example of how VLCs could still contribute more to transmission service, even if there is a deferred balance?
Yes. If a VLC's load ramps more slowly than forecast, but reaches a higher ultimate level of demand more quickly than the forecast, they could pay a minimum billing demand charge in 1 month, but then contribute more to transmission service costs overall during the period of time between rate cases. Additionally, the MISO tariff could increase transmission demand costs over time, thereby increasing a VLC contribution to overall transmission service when they're operating at that higher demand. In either scenario, it would be accurate to say that non-participating customers, in either scenario, it would not be accurate to say that non-participating customers have paid more for transmission service as a result of the transmission projects necessary to serve the VLC's load. If the Commission were to order deferral accounting, it should leave open the possibility that the deferred balance could appropriately be turned to the VLCs if they ultimately contribute more to transmission service than simply paying for transmission infrastructure necessary to serve their load through a transmission minimum demand charge.
Does that complete your testimony, Mr. Stasek?
It does.
Your Honor, Mr. Stasek is available for cross.
All right, so we'll go through our list here. We have Cub signed up first, so let's hear from Attorney Narvi.
Thank you, Judge Newmark. Good afternoon, Mr. Stasek. I'm Daniel Narvi, attorney for the Citizens Utility Board, and I have a few questions for you. Part of your rebuttal testimony focuses on the interpretation of the legal standard under Wisconsin Statute Section 196.192. Do you recall that?
Do you have a specific page I can turn to just for reference?
I do. You can take a look at page 7 as one example.
Oh, appreciate it. Okay.
Mr. Stasek, would you agree with me that the meaning of section 196.192, including the meaning of the phrase harm to customers, is a question of statutory interpretation?
Yes.
Do you have any legal training?
No, I did not attend law school.
Okay. What's the basis for your understanding of the meaning of the statute?
My understanding, or my basis for the understanding, is my role here at the company, serving as a witness in multiple rate cases, including when other market-based rates have been evaluated as part of those rate cases, and commission deliberations and decisions on those cases.
Is it the company's position that the statutory standard of customer harm is satisfied as long as the customers make out better under the proposed tariffs than they would under the current CP1 rate?
I'm sorry, could you repeat the question?
Let's read it back.
Thank you.
Question is it the company's position that statutory standard of customer harm is satisfied as long as the customers make out better under the proposed tariffs than they would under the current CP1 rate?
Interject an objection to form the meaning of make out. Not sure what that means.
We can imagine.
I can rephrase.
All right, let's rephrase.
Yeah. Is it the company's position that the statutory standard of customer harm is satisfied as long as non-participating customers do not pay more under the proposed tariffs than they would under the current CP1 rate?
I don't think it's necessarily meets the statute, but it's very similar to similar conclusions the commission had reached, as I had talked about on page 7 of my rebuttal, where the commission has stated in other opinions that that statute is met, that market-based rates do not harm customers who are not subject to the rate if they do not pay higher rates as a result.
Is it your position that the meaning of customer harm is that the customers do not pay higher rates under the proposed tariff than the CB1 rate?
I'm not suggesting that's what the statute says. I'm suggesting that's my experience and how I've seen the commission interpret that statute. Or as I reference again on page 7 of my rebuttal.
Is there a proceeding in which the commission compared the current proposed tariff with the amounts paid by that would be paid by customers who took service under CP1?
Not that I can recall.
The CP1 rate is subject to change in each rate case, correct?
Correct.
And that rate is based on cost allocation principles?
That rate is based on cost allocation principles, correct.
If the commission finds during a rate case that CP1 recovers insufficient costs from the customers that take service under CP1, the commission can change the CP1 rate going forward, correct?
Just as they could with any other cost of service based rate, yes.
And CP1, as it stands today, was set in the last Wisconsin Electric rate case in 2024, is that right?
And that was the last rate case, correct? Rates were reset with a 2-year test year, just for clarification. So they were different rates were established for 2025 and 2026, but the proceeding occurred in 2024.
Yes, thank you for that clarification. When the commission decided that rate case, had any VLCs taken service yet under CP1?
Well, I guess it depends on how one defines take service. Are you talking at that time, were they taking service or were they forecasted to take service?
Well, let's take both. Had they, at the time of that rate case decision, had any VLCs taken service under CP1?
Quick objection. I think record would benefit from clarity of what time he's talking about. My understanding would be that would be December 18th or 19th, 2024. Is that the time period we're talking about right now?
Yeah, thanks for the clarification. I'm referring back to the last Wisconsin Electric rate case. Mr. Sasek, is it your understanding that that would have been in December 2024?
Yes, that is my understanding.
At least the issuance of the final decision?
Correct.
So focusing on that time period, are you aware whether any VLCs had yet taken service?
Service, I believe there was some construction service to one of the VLCs, but not, I'll call it full service, for lack of a better term.
And then turning to the second part of the sequence, was were any VLCs included in the test year forecast that was considered in that rate case?
There was some incremental small load on the front end of the load ramp included, correct, for one of the VLCs.
Okay, so relatively small load compared to what the test year forecast will be for the next 2 years, correct?
I guess using standard definition of relatively, yes.
Do you have any involvement in how customers apply for and receive service under CP1?
I do not.
Okay. I'm going to ask a few questions about the capacity only option. Your testimony and that of other Wisconsin electric witnesses is that the capacity only option will only be available to VLCs if your analysis shows net benefits to non-participating customers. Is that accurate?
Yes, it is.
And is it your position that the analysis presented by other witnesses in this docket is that the two capacity-only resources identified so far show significant benefits to non-participating customers?
That is my understanding from what our other company witnesses have presented here.
And those net benefits would largely come from selling electricity on the wholesale market?
It would come from the net dispatch benefits of those resources, as well as the ancillary services that are earned by those resources as well.
Now, if the VLCs acquired those resources as full benefits resources rather than capacity only resources, the VLCs would get all those net benefits instead, correct?
As would they also pay the incremental cost for the 25% of the base rate revenue requirement and all of the fuel costs associated with those resources.
Is Wisconsin Electric committing to conducting the same type of analysis for future capacity-only resources that it has presented in this docket and in the respective construction dockets for the Foundry Ridge and Red Oak Ridge projects?
I believe we've stated so in testimony in this case already, yes.
Okay. And is Wisconsin Electric proposing that the commission would approve or reject the acquisition or construction of those future resources based on its review of the net benefit analysis?
I can't speak for what the commission will do, but my presumption would be that that would be part of their evaluation when evaluating the applications for those.
Thank you. I'd like to turn to your surrebuttal testimony now. If you could pull that up, Judge Newmark.
Sure thing. Give me a second here. Are we going to focus in on?
Yeah, thanks. I'm going to turn to page 3. Oh, sorry, page 7.
Okay.
And focusing on line 12 here, you are making a proposal for the capacity-only resource option, and you state, if actual results are outside the tolerance band when compared to the model projection of net benefits to non-participating customers that has been presented, the commission could reset the revenue requirement allocation percentage for the entire portfolio at the percentage of the base rate revenue requirement that would result in a change in net cost to non-participating customers equal to 0. Do you see that?
I do.
Can you clarify what is intended here by the phrase change in net cost to non-participating customers equal to 0?
Yeah, so what I'm essentially proposing here would be in this step, what would happen is the cost allocation. So the currently proposed at 75/25 would be modified such that the differential identified in step 2B, I guess, or step 1, because I can't see step 1 on here and I don't have a hard copy in front of me. But so it'd basically be to, at the end of this process, the understanding or the proposal would be that the difference between actuals and forecasted would be 0 after we change that cost allocation so that it matches what the forecast was.
And is it part of the proposal that if the actual net benefits to non-participating customers falls outside of the tolerance band you've described, that the revenue requirements for bespoke resources would be reset to achieve the originally projected level of net benefits?
That's correct, based on the analysis done earlier in the process, but yes, and to reset them prospectively.
Right. Under this proposal, what would happen if the net benefits to non-participating customers fell below zero, meaning that there are net costs to non-participating customers, but also fell within the tolerance band?
If it was within the tolerance band, our proposal would be that there would be no change. And the reason for that is the anticipated benefits would accrue to the customers, non-participating customers, to be clear, over the life of the assets. And there will be some variability within there. And this is meant to be a safety valve. So if things moved more than a reasonable amount in the, sort of year to year, because nothing runs on a straight line, you would have the ability to sort of course correct. But if it stays within that tolerance band, it would be presumed that those benefits would continue out as forecast over the life of the asset, keeping in mind that these are very long-term assets with long-term stretches of net benefit and net costs.
Would the company be willing to accept a modification to the proposal that would impose a zero net benefits trigger for resetting the bespoke resource revenue requirements?
I'm not sure I understand the question.
Yeah, let me put it another way. Would the company be willing to accept a modification such that if net benefits to non-participating customers falls below zero, that would also trigger the resetting of bespoke resource revenue requirements?
I don't think that would be appropriate, particularly early on in the life of the asset, as the modeling would show. The first several years of an asset through traditional utility rate making principles with the cost recovery curve for capital. These are very capital intense investments. The early years are more likely to have net costs, with the future being where those net benefits would start to accrue and build. And then over the life of the asset, you get a net present value of benefits, which we presented here. And I think the intent is to not have this be one of those things where it whipsaws all over the place by resetting things just because you had anticipated early on in the life of the asset. You might have net costs in years 1 and 2, and if you do the analysis just on years 1 and 2, that would, just because it was a net cost, even though you shouldn't be triggering the reset when those costs were when that forecast anticipated being a net cost. It's really the differential between what was expected versus what actually happened relative to the analysis. So I don't think just a result of the actuals being a negative number, meaning a net cost, should trigger that, because it's inconsistent with, I guess, the principle we're trying to protect from with this safety valve mechanism.
Okay, I have no further questions for Mr. Stasek.
Okay, well, let's move on then to Clean Wisconsin.
We have no questions for Mr. Stasek. Thank
Okay,
you.
that's fine. How about ELPC?
Your Honor, we've waived per our discussion earlier. Thank you.
Oh, Stacy too. Okay, didn't miss that. Okay, Sierra Club.
Yes, I have just a few questions. Mr. Stasek, my name is Priyam Desai. I am an attorney with Sierra Club. I have just a couple of questions for you. I'll try to keep it short. You testified that the VLCs have already made substantial investments in Wisconsin and made commitments to invest even more significant amounts in the future, correct?
Yes.
Are you aware if these commitments are binding?
I don't know if the commitments are binding. I'm not privy to that, but I am my statements in the testimony are supported by press releases, news articles, and public announcements that have been made. I'm also familiar with the fact that construction is well underway at the two sites of the two customers that are currently considered VLCs.
Okay. Therefore, based on your understanding, these commitments could very well be non-binding, correct?
They could be, yes.
All right. Okay, you stated in your rebuttal testimony that the proposed tariffs require the VLCs to take market risks, correct?
That's correct.
Is it your opinion that no customer should be forced to take market risks?
I think it's an option that's available to customers. I don't think we're forcing it on anyone.
Can we turn to your rebuttal, Stasek, at page 42, please?
Yes. Just a
Thank
second.
you.
All right.
Okay. Do you have that before you, Witness Stasek?
It's there. Yep.
Okay. Do you see from lines 2 to 4, you state the proposed tariffs are a significant departure from traditional cost of service rate making and require the VLCs to take market risks?
Under the proposed tariff, yes. Okay. Yep.
Okay. And you, in your opinion, you think that that is not appropriate?
No, I didn't say that. That was certainly not the question I thought you were asking.
Okay. I can move on. You stated in your rebuttal testimony that the commission should not prejudge the capacity-only option because of the limited factual evidence in the docket, because the commission will have the opportunity to evaluate each specific resource in other dockets and proceedings, correct?
Yes.
Do you anticipate that this opportunity to evaluate will include comparing resources or assessing their value relative to other resources?
Based on my experience working through other generation acquisition and construction dockets, yes.
There are currently several resources which are being considered as bespoke resources up for commission approval. Has WEPCO provided analysis on the relative value of those resources as compared to other potential bespoke resources?
Objection, Your Honor, to form. That was quite vague as to what resources she's talking about.
I can clarify. I'm talking about the Red Oak Ridge and Foundry Ridge resources, which currently have buy-sell dockets open, and WEPCO has provided an application for that. So my question is, has WEPCO, in that proceeding, has WEPCO provided analysis that those resources relative to other bespoke resources?
Another objection, Your Honor. Those dockets do not have notices of proceedings yet. Applications have been filed, but the proceedings have not been opened by commission order at this point in their life cycle.
Does WEPCO?
So is your objection? Is your objection to the fact that the question included the words currently? That we currently have buy-sell dockets open.
Wait.
Okay,
I didn't hear the end of what.
Excuse
me, Judge. I didn't hear the end of what you said. So is your objection to the fact that the question included the word currently? Is that? And then Mr. Proctor Brown spoke. So
I said yes. Yes, Your Honor.
Okay. Okay. Yeah. It was. So that I think the issue is if we can take out of the question a factual inaccuracy that the dockets are currently open. The buy-sell dockets are currently open. I think we're sure there's no notices of proceedings out there yet. That's true. But either way, if you can just take that characterization out of your question, I think the question would at least pass that objection.
Sure. I can also just simplify the question.
Even
Does
better.
WEPCO plan on providing analysis that compares the relative value of the Foundry Ridge and Red Oak Ridge facilities in their respective dockets relative to the other bespoke resources that the company is considering?
Not 100% sure I fully understand what comparison you're asking about. What I will say is, as with every other generation docket that we've filed for the recent past, going back to at least 2018, our acquisitions and requests for the acquisitions, I should say, are supported by economic and need analysis that compares those resources being proposed to other alternatives to meeting our capacity and energy needs.
Okay, thank you. No further questions.
Okay. I can say that Foundry Ridge is open, docket 9835 CE 100. Notice of proceeding went out on January 21st.
Your Honor,
And
that's
to
actually
my
the
knowledge,
CPCN.
Yeah, that's the CPCN.
Oh, you're talking about the dicel. Okay, there you
Right.
go. Right, good. Then I stand corrected as well. Okay. So let's go with any other questions. That is Walnut Way.
Yes, Judge, thank you. Good afternoon, Mr. Stasek. This is Krista Westerberg on behalf of Walnut Way. Can you hear me?
I can hear you. Good afternoon, Attorney Westerberg.
Thank you. Per your direct testimony, you're the company's primary witness as to these tariffs. Is that right?
Yes, it is.
Were you also the primary company employee responsible for developing the tariffs?
I wouldn't say primary. There was a small team of 3 or 4 people that were most heavily involved in them from the company.
Who was the leader of that team?
I wasn't truly a leader. I think we worked together as a team. There wasn't one person that was, quote, in charge. Things were facilitated by our Director of Economic Development through how the customers came in. But I believe we responded to some discovery recently of yours that indicated who is involved from the company's perspective.
Was there a project manager for developing these tariffs?
No.
And who with the company was on that team of 3 or 4 people?
As indicated in the discovery, it was myself, a gentleman named Joel Burrow, who's our Director of Economic Development, Chad Cook, who's a market strategist, and then because there were some legal elements, Kate Phillips, Senior Internal Counsel, was also part of the team.
And Your Honor, I had not designated that exhibit for use today. The discovery of the witness has just referenced, but since that's come up now a few times, would it be helpful if we mark that?
We have several documents that Walnut Way has shared with parties and myself to be used at the hearing. So which one are we looking at?
That's the issue, is that this one was not among them, but I could send it out right now to the parties. It was simply the response to 6 Walnut Way DR 17.
Your Honor, pursuant to our stipulation, we don't have an objection based on the not sharing this discovery response by the 1:30 p.m. deadline yesterday.
Okay. So I did see an email. So let's go off the record. I see an email that was sent at 2:35. Well, I guess it was sent, to everyone, 2:35. That's looks like discovery 13. Is that? I thought you said a different number.
I did say I wasn't planning to ask about 17, but we can certainly mark it, and that might make things more efficient since the witness has referred to that document a few times.
No objection from applicant, Your Honor.
Right. So the documents that you've provided for use of the hearing, are we going to go through them all and mark them and introduce them? Is that the plan?
I don't think we need to do all of them.
Okay.
But there are two we were planning on, and now possibly three.
Okay, so I don't see the 17. So you wanted 17. So I guess I'm not seeing that one.
Yeah, that's exactly it. We weren't planning on marking it, so I didn't email it to everybody, but now that the witness has referred to it, I'm wondering if we should mark it. So I'm happy to do that. And I can email it out here as well.
So that one hasn't been emailed yet at all?
Correct.
Okay, all right. I was confused. All right, yes, please send that out.
Okay. Or maybe, so I'm not double multitasking, I'll ask Attorney Castro to do that, and I'll come back to it.
Benefits of co-counsel. Yes.
Yes, thanks. Okay.
Back on the record.
Okay, but let's see what we're up to now. So, what's our next? What are your plans at this point?
I will mark that the document we've been discussing off the record, the response to 6.
Are we back on or not?
No, this is one that you just sent? Is this the one?
No, this is the one that hasn't been sent at all. But we can send it out here within a few minutes.
Okay, well let's wait for that then.
Okay, and I can circle back to that. Would that make sense?
I think it would, just so we're not waiting.
Yeah. And do you have more questions, or is there another document that we have receipt of that we can mark?
I'll just move on to my other questions and come back to that document, Your Honor. Thank you. If we could pull up.
That sounds good. Let's get back on the record.
I'd like to pull up your direct testimony, Mr. Stac. And page 3 specifically.
Okay.
And, I don't have detailed questions, but essentially exhibits 2 through 6. Those are the tariffs and service agreements for which WEPCO is seeking commission approval in this proceeding, correct?
That's correct. Those are the proposed tariffs and the proposed service agreements that go along with them, yes.
And these were not modeled in whole or in part on tariffs, service agreements, or regulatory documents from other states or jurisdictions, correct?
No, they were not.
They were built out of whole cloth, so to speak, by WEPCO and the VLCs.
I'm sorry, you use the term I'm not familiar with. Out of what cloth?
I said whole cloth.
Okay. Blank sheet of paper, whole cloth, if that means the same thing, yes, essentially.
Right. And as to the timing, WEPCO started work related to developing the tariffs in early 2023. Would you agree?
Yes, generally that's right.
And this was after Microsoft had reached out to WEPCO about taking service for prospective data centers in WEPCO's service territory in 2022, correct?
That's correct.
And then WEPCO worked with Microsoft to develop the tariffs over a period of nearly 2 years. Is that correct?
Yes.
And once the language of the tariffs was agreed upon, then WEPCO developed the service agreements, correct?
Yeah, that's correct. Yeah.
And then as additional prospective very large customers or VLCs contacted WEPCO, the documents were provided to them. Is that fair?
I guess, could you just clarify when you say VLCs, which you're referring to?
Well, well, broadly speaking, Cloverleaf and Vantage and eventually Oracle, correct?
Oh, yeah, correct. I didn't know if you were including Microsoft based on the line of questioning. So, got it. Oh, yeah, that is a correct statement then.
Thank you. And then Cloverleaf had contacted WEPCO in about Q3 of 2024. Is that right?
That sounds about right from recollection.
And Vantage contacted WEPCO in about Q2 of 2025.
Yes, I believe that's right.
And followed by Oracle in Q3 of 2025.
Yes, that's correct.
And did any of these three later VLCs, Cloverleaf, Vantage, and Oracle, make any changes to the tariffs as negotiated between Microsoft and WEPCO before WEPCO filed its application in this docket on March 31st of 2025?
No.
Did any of those three, again, Cloverleaf, Vantage, and Oracle, make any changes to the service agreements before WEPCO filed its application on March 31st of 2025?
No.
Is it true that no non-VLC customers or customer representatives participated in the negotiations to develop the tariffs?
No, that's correct, other than, I guess, the employees who are also customers, but I don't think that's what you mean.
That's correct. Thank you. Did other entities like American Transmission Company participate?
No.
Aside from WEPCO and the VLCs, did anybody else have input on the tariffs as they were being negotiated?
Not directly, no.
And what about indirectly?
I guess what I would say is there was a midpoint where we were close to having something final where we did a briefing with the customers at our side in Madison and just sort of previewed where we were heading with the commission staff and discussed questions they had. And some of those questions maybe influenced a few of the terms as we moved on.
When approximately was that meeting?
So I got to try and get my years straight. So we're in 26. So that would have been in the first quarter of 2024.
Yeah. And for the sake of ease, the document we talked about off the record, Judge, has now been emailed by Attorney Castro.
I'll look out for it.
Okay.
Continue with your questions.
Okay. Would this be a good time to mark that document, or is it still pending?
I just got it, so let's get off the record. Let me just take a look. Okay, so we're off the record, but I just wanted to say it's 6WW-DR-17. That's the one we're currently going to be marking. Is that right?
Yes.
And that relates back because the witness had referenced the information in that response already. Okay.
Yes.
Your Honor, just before we get back on the record, I think this was filed too. The version I was emailed doesn't have the file stamp. I don't know where the status of that is. We don't object to either version necessarily. I just want to highlight that.
Yeah. So we can use this for purposes of the hearing, but when it gets filed, Walnut Way should use the version that as it appears on Earth as the basis for the exhibit.
We will do that. Thank you, Your Honor. All
right. So let's get on the record. So go ahead, Attorney Westerberg, with the exhibit offer.
Okay. Mr. Stasek, a little bit ago when we started talking, you mentioned discovery response that that WEPCO had provided to Walnut Way earlier this week, and the judge has now pulled up on the screen the WEPCO's response to 6WWDR17. Is this the data request response you were referring to?
Yes, it is.
Okay, and this shows the individuals who participated in the tariff negotiations from WEPCO to the best of your knowledge,
That's correct.
as well as on page, as well as some of the other parties from or individuals from Microsoft. Is that right?
Yes, it is.
And you are the respondent for that data request response, correct?
Yes, I am, or was.
Okay, thank you. Yeah, I don't have any further questions related to that, but I would like to mark that exhibit, which I believe would be Stacy 16.
That's right. So we've marked that Stacy 16. Any objections?
No objection. Pursuant to the stipulation, Your Honor.
Yes, and I'll note that this was filed out of time, but the at least the applicant's not objected. So let me just make sure if anyone else has any issues with this, let me know. Okay, it doesn't appear to be. So, okay, we can accept that document. Appreciate that.
Thank you.
And we'll move on.
Okay. If I can draw your attention to back to your direct at page 6. You mentioned here that since WEPCO filed the tariffs on March 31st of 2025, some additional changes have been negotiated with the prospective VLCs, and those were included with your direct testimony. Is that right?
Yes, that's correct.
Okay. With which prospective eligible customers did WEPCO negotiate those changes?
Those were primarily driven by discussions with Vantage and Oracle.
Okay. Have any prospective VLCs requested other changes that WEPCO did not agree to include in your direct testimony, specifically related to non-fossil sources of generation?
No.
Were there any other changes that WEPCO did not agree to on any subject?
Objection, Your Honor. I think it's a little bit vague as to who's requesting the changes. The testimony says we negotiated additional protections, also agreed to additional changes in this docket. So just ask for clarification as to who's asking for a change here and in what time period.
Okay, that's fair.
The clarification would be that whether the VLCs requested any other changes to the tariffs or service agreements since the application was filed that WEPCO did not agree to.
No.
Okay.
None that I'm aware of.
Okay. And then I want to look at page 9 on your your direct testimony. And you discussed there are 4 policy objectives, 4 major policy objectives. You see that?
I do. Yep. You're starting at line 5 there.
Exactly. Were those developed internally at WEPCO?
So I'm just rereading them. I would say for the most part, yes, but they were set out as the kind of joint understanding of what the objectives were for this tariff with at the time Microsoft and with the other VLCs when we talked to them. But I would say if your question, what you asked was if they were developed internally, yes.
Okay. And the tariffs were then developed against those 4 policy objectives?
That's correct.
Were they discussed with any government official like POC staff?
Objection, Your Honor. What time period?
Okay, I agree.
Prior to development of the tariffs?
They were, I would say, not before we started developing the tariffs. They were included in as background for the information that we shared with commission staff when I referenced the discussion we had with them in the early part of 2024.
the meeting in Madison.
That's correct.
Okay, thank you. I'd like to talk with you about your rebuttal now. If the judge, you could pull that up.
Okay.
Kind of,
Go ahead. It's may just be a little bit of a lag here.
sure. These questions are all going to be about the resource mix for the VLCs. Starting with page 55 of your rebuttal.
Moment while I get there. Okay.
And at line 17 to 20, you say Wisconsin Electric has serious concerns about substituting local reliable generation with distant resources, artificial constructs like virtual power plants or demand response, or many of the other suggested resources proposed by various witnesses. Did I read that correctly?
As I was following along, it seemed that way.
And looking to pages 22 to 23 on table 2, I'm wondering if those would, there's a list of resources, and I'm wondering if you consider those to be local examples of local reliable generation that you mentioned on page 55.
Can I just interject real quick? I think, Your Honor, you do not have the rebuttal up on the screen. I don't know if, I just want to be clear, this is the direct that I see.
Yeah, you're right. It's not, I'm not able to access it at the moment.
Okay, I just wanted to.
Reasons I can't explain.
The witness has it though, is that correct?
He does have it. I just wanted to, I wasn't sure if we intended to have it up.
It's better not to confuse the audience on YouTube, so I appreciate that.
Thank you, Your Honor.
Could just given the, make sure I'm completely answering the question, would it be possible maybe to have the question just read back real quick?
Yeah, let's read it back. That's fine.
Thank you.
And looking to page 22 and 23 on table 2, there's a list of resources. I'm wondering if you consider those to be local examples of local reliability generation that you mentioned on page 55.
Thank you. Yes, I think these are definitely examples of local generation resources as they're all located in MISO LRZ2.
Would you also consider behind the meter generation on site at the VLCs to be local generation?
Yes, it would be local.
Okay. And depending on the resource, it could also be reliable.
It could be.
On-site solar, in fact, would probably be more local than, say, a solar farm being erected in Whitewater or somewhere more distant from, say, Ozaukee County or Racine County.
Objection, Your Honor. Form. There's a couple of different incomplete hypotheticals there, and it's not a statement that can be answered as a yes or no.
Okay, let's have you rephrase, please.
Sure. Wouldn't on-site solar generation at a VLC be more local than utility scale solar being built in a different county, for example?
It would be more local, presuming they would have sufficient room to actually build the generation equivalent to what you could do at a site such as those listed on the table on pages 22 or 23.
I'd like to pull up now an exhibit. I think it's been entered into the record by 2 different witnesses, but I'll pull up exhibit Walnut Way Nelson 18, which is a data request response.
Okay, let's go off the record for a minute and cross your fingers. Okay. Got it there. All right, let's get back on the record. Go ahead.
Thank you. So this was a multi-part question posed to WEPCO by ELPC and responded to by you. Is that correct?
Is how it appears. Yep.
And this question was referenced the definition of a bespoke resource in the bespoke resource tariff. And subpart A asks if that definition precludes customer-owned or third-party distributed energy resources, such as behind-the-meter batteries, on-site solar or backup generation to serve their own load, or provide grid services. And I'd like you to look down at your response or the company's response in sub A. And let me know when you've had a chance to review that.
I have.
And you say there that that based on the scale of the firm demand requested by the participating customers, the tariff was designed collaboratively with the VLCs to have all capacity and energy.
I'm sorry, can you slow down? The firm demand requested by
the participating customers. The tariff was designed collaboratively with the VLCs to have all capacity and energy served by company-owned generation resources that are grid interconnected. Did I read that correctly, Mr. Stasek?
That is correct.
Okay. Was that an explicit point of discussion that WEPCO had with the VLCs we've talked about so far prior to the filing of the tariffs application?
Yes, it was discussed early on in the process.
So was it discussed only then with Microsoft or with the other VLCs as well?
It's been discussed with the other VLCs. I think your question was before it was filed. So that would have only applied to Microsoft based on the timing with which you laid out earlier in your cross-examination.
In that discussion with Microsoft, did they explicitly agree that they would have no customer-owned generation if the tariffs were approved?
I think that was my recollection, but we're going back a couple of years.
Okay. Were you able to recall whom at Microsoft may have explicitly agreed to that?
I would not be able to recall a specific name, no.
And am I understanding your testimony that the other VLCs did not explicitly agree that they would have no behind the meter generation?
Not before we filed, no. We hadn't talked to them. There's not been any objections to the tariff either.
Has there been any objection from them to this data request response that we've been discussing?
None that I'm aware of.
Did they, any of the VLCs well, strike that. You say that there's been no objection. Are you aware of any specific agreement to the arrangement that's depicted here in your answer to data request response 1 ELPC 5A?
I would say yes. They've all agreed to support the tariff as it's been filed.
Where in the tariff does it say you cannot have behind the meter generation if you were taking service under the bespoke resources tariff?
I don't think it explicitly states that directly. I think what the tariff does is define what a bespoke resource would be, and that the VLC is expected to be served under the VLC tariff through bespoke resources.
Behind the meter generation would not be a bespoke resource, is that right?
I think based on the definition that's laid out in the tariff, I'd have to go back to that. And I don't believe so, right? If it's behind the meter, it's not grid connected. So based on the definition of a bespoke resource, I think that's a correct statement.
Okay. In that case, then, is the behind the meter generation explicitly not allowed?
These are legal documents that have been filed with the commission. Mr. Stasek is not an attorney. This response talks about this in B. I'm not sure where we're going with him searching the tariff in his testimony or memory to get to an answer here.
I think this goes to the questions that were proposed in the offered evidence list, at the end of the offered evidence list. I think it's a question that we all have, and part of this is what was the agreement, and is there some other place in the between the tariffs, the VLCs and WEPCO? I don't think that this question actually has been answered, which is why it's fair cross right now.
Okay. Because it hasn't been posed.
I'll allow. Go ahead. So do you want to read that question back?
If you don't mind, Your Honor.
Absolutely.
Easy for you to say. My computer
I saw your face.
it just froze. I'm like, why is it just sitting there? Usually things are blinking and things are moving.
Go figure.
Yeah. I'm gonna have to put in some stuff from the recording here because it didn't. I didn't know it stopped. Let me just reset it real quick. It'll just take me a second.
Okay.
Sorry.
Judge Newmark, while we're waiting for the reporter, can I ask a logistical question? And it may be too early to tell, but
how late we're going to go today?
that was the question because there's a commission witness who has a conflict. It seems like we're probably going to be back tomorrow, but I wasn't sure if you were going to try to plow all the way through.
That will be physically impossible.
Okay.
To get everyone in today, I'm sure. So, we did hold tomorrow as a spillover day, and it sounds like everyone was on board with that. So I don't think there's anyone who can't make it tomorrow that we haven't heard yet. I think there's one person, one of the WEPCO witnesses. But so yeah, we will not go too late today, so that we can proceed in the morning tomorrow, and we'll probably. Let's commit to a 9 a.m. start tomorrow. Maybe that'll be helpful as well.
Sounds great. Thank you.
Okay.
Are we stopping?
I
wasn't listening.
We're all going home. You weren't here, so
I have the last question.
Okay, go ahead.
In that case, then, is the behind the meter generation explicitly not allowed?
I would say it's not defined as a bespoke resource. The bespoke resources are defined on page 2 of the proposed tariff, which is within Exhibit WEPCO STASIC 2. I think the other thing to keep in mind when you start talking about behind the meter solar, just how much real estate you're talking about.
I'm going to
when you've got
back the witness. There's no question pending.
Okay, yeah, that's not really the line here, but So this just begs the next question, which I don't know you may be asking next, but I just wanted to ask, and maybe this is what we need, maybe not. But I guess what I'm wondering is now that you have a customer committing to a certain amount of demand, and I guess the question that kind of gets begged is, can the customer have more demand than that and serve itself? Or is that not what's intended under the proposed regime that the applicant is applying for approval?
That's not what's intended, Your Honor.
Okay. But as far as you know, the tariffs don't explicitly say that's prohibited.
It doesn't say it's explicitly prohibited or explicitly allowed.
Okay, that's good to know. All right, go back to your questions then.
Would a very large customer have to get permission from WEPCO if it wished to use a behind the meter resource in the future?
Customer would have to, like any other customer, if you were going to interconnect a system behind the meter, follow the rules of interconnection as defined by and governed by PSC 119. That does involve working with the company.
Is there anything in addition to that a VLC would have to do relative to the tariffs that are being proposed here?
Objection. Lack of foundation and calls for a legal conclusion, Your Honor.
I'm going to let him answer based on his understanding of the tariffs. The fact that we've certainly established he's familiar with what's being proposed. So go ahead.
As I understand the tariffs as they've been drafted and submitted, there is nothing additional that I am aware of in the tariff that a VLC would be required to do in that instance.
Aside from the normal interconnection rules, are there any criteria that WEPCO would apply in allowing behind the meter resources?
Objection, Your Honor. This is calling for speculation about some incomplete hypothetical about future events at this point.
Okay. Well, I'll have him answer to the extent it can be answered within the four corners of the proposal.
So the interconnection process, I'm not directly involved, but as I understand it, would involve a variety of evaluations, again, consistent with PSC 119 as they're approved at the time the request is made. So I don't know what those requirements all would be at some future date, but that would be my expectation and understanding of how such a request like that would be evaluated.
Is there, we'll strike that. You had mentioned before that the tariff doesn't explicitly allow or not allow behind the meter resources. I think, correct me if I'm wrong, I think that's what I understood you to say. Does it effectively prohibit that arrangement based on the fact that a VLC has to subscribe to a certain amount of capacity?
I guess I would go back to my prior response and the response actually to subpart A of, I think it was whatever this ELPC discovery is that's up there is the customers have agreed to the definition of a bespoke resource. They've agreed to have sufficient bespoke resources to meet their firm service level forecast based on the accredited capacity of the bespoke resources.
Is it also your understanding that they've agreed not to utilize behind the meter resources?
My understanding is through the discussions that, as far as I know, it's not being considered, largely because of the significant amount of real estate that would be involved.
But have they agreed not to do it? But to your understanding?
Not explicitly. I didn't ask the question, but the discussion has been around what is a resource that will serve our load, and it's been focused on bespoke resources.
Okay. And the question also it was originally asked by ELPC, had similar questions about grid services such as a virtual power plant. Is the understanding that you've described as to behind the meter resources, would that also apply to an arrangement like a virtual power plant?
I would again point back to the definition of a bespoke resource and what's included in that definition.
In your opinion, then, would the or your understanding that virtual power plant or demand response would not be allowed?
It wasn't the intent of those being a resource.
I'd like to draw your attention now to again some of the documents that we emailed ahead of time. And the first one would be, this was sent yesterday.
Okay, we're ready.
Microsoft response to 1 Walnut Way 8 and attachment 1.
Okay. I think I have that here.
Okay. And explicitly referring to attachment 1.
Your Honor, so thought this was filed as well. I don't see a file stamp. Maybe I've missed the cover sheet.
Yeah, this is the one I
it's-
mentioned. Sorry, Attorney
I'm
Becker.
sorry.
I know what you're going to say. This is the one I mentioned this morning that when we file it, we'll do the one with the stamp on it.
Yeah, and my instructions just apply to all of these. So please.
And I just want to be clear. The attachment might have trade secret or confidential information in it. So I just wanted to raise that. I don't know that it does, but we have it on the screen on the YouTube.
Yes, and this, I haven't checked it yet, but this, well, let me check it now. This file name says public redacted on it. So yeah, it is redacted.
Thank you, Your Honor. Apologies for the
attachment.
paranoia.
That's all right. We all have to save our jobs. Okay, so we're at, we have this request. Do we want to lay some foundation?
Yes, thank you, Your Honor. Mr. Stasic, are you aware that Walnut Way has moved to compel responses to discovery from both Microsoft and WEPCO as to discussions around the tariff development between Microsoft and WEPCO?
I'm aware of it. Yes, it occurring, not the details involved in anything beyond that.
Okay. And pursuant to the administrative law judge's order on the request to compel Microsoft, Microsoft responded with this document and attachment 1, and I understand you may not be familiar with the written response, but for the sake of completeness, I've included it with the attachment, and I'd like to go to the attachment and see if you are familiar with this one.
It looks vaguely familiar.
Is this a copy of an agenda for discussions between Microsoft and WEPCO when the tariffs were still in the development stage?
Given the timing, based on what date is on there, yes.
Okay, and that would have been about this time last year, correct?
Indeed.
Okay, so was any part of the discussion at this meeting, did any part of that discussion concern when you're talking about the bespoke resource tariff, behind the meter generation, distributed generation, or services like virtual power plants?
I honestly don't recall the specifics that were discussed at a meeting over a year ago.
Okay. What do you recall, if anything, about the discussions on capacity only bespoke resources?
I'm sorry, capacity.
Only bespoke resources?
Thank you.
Objection form is the time period this meeting?
Yes, at this meeting.
Yeah, I don't, again, recall specific topics underneath these larger categories.
Would you have seen this agenda prior to today?
I would have seen it February 6th.
Okay.
of 2025.
And who, do you know who prepared the agenda?
Generally, agendas would have been prepared by Mr. Burrow, Joel Burrow, as I referenced earlier.
Okay. And how many sets of agendas like this, to the extent you can recall, were created during the course of WEPCO's negotiations with Microsoft?
I honestly don't know. We had meetings sporadically. We had calls. So I don't know.
Okay. Do you recall what specifically was being discussed about the tariffs at this meeting?
No, I do not.
Were there ever any minutes created to your knowledge?
No, not minutes that I'm aware of.
Okay. In that case, well, eventually I'll like to mark this, Your Honor, but there's another similar document, the one I emailed just about an hour or so ago.
Okay, we can take that one. Well, let's just mark this now that we've already discussed it. So
A617.
So this one is 1WW8. That'll be Stac 17.
Thank you.
And
No objection.
yeah, okay, well, let me ask. So any objections?
No objection, Your Honor.
Okay. So that'll be in the record, and then we'll move on to the next one.
Yes.
Which one is that?
That'll be the response to 6 Walnut Way 13.
Off the record, I see 6 Walnut Way DR2, and then I have 1 Walnut Way 6 and 1 Walnut Way 10.
Yeah,
Is this one on the email? Is that what you said?
Yeah, it was the one I emailed just about an hour and a half.
Right. Forgot about that. Sorry about that. Okay, there we go. Okay, so 6WWDR-17.
Sorry, no, it's
Nope, that's not it.
6WWDR 13.
2 hours ago. All right, here we are. So let's get on the record. Go ahead with your questions on this data request.
Thank you, Your Honor. Mr. Stac, are you able to see what's been pulled up as 6WWDR13?
Yes, it's on the screen in front of me. Thank you.
And is it true that this is a response that you on behalf of WEPCO made to a data request response from Walnut Way, and that was provided yesterday late afternoon?
Yes.
And this data request response also attached an agenda like we were looking at before. Judge, you may scroll down to that. And it's got another page. That look familiar, Mr. Stac?
Yes, it does.
Okay. And is it true that this is an agenda from a meeting between Microsoft and We Energies from early June of 2024?
Yes.
And at this meeting, the presenter on ATC rate schedules and cost recovery is listed as a McKee. Who is that?
It's a gentleman named Robert McKee, or goes by Bob.
Is he an employee of WEPCO?
He's an ATC employee.
What did he have to say at this meeting, to the extent you can recall?
My recollection was a summary of the ATC rate schedules. As you would recall from my exhibit 2, I believe, the Bespoke or the VLC tariff, we list out the ATC billing schedules. So it was just to provide a summary of that.
Why had ATC been invited to the meeting?
The ATC tariff is what drives those schedules. So to provide a direct understanding of that ATC tariff, we thought it'd be helpful for the customer to hear directly from somebody who's involved in administering it.
Do you recall if Microsoft had any questions at that time on that issue?
I don't recall the mechanics of all the discussion that took place under that topic. Just the intent of having Mr. McKee there.
And earlier in that day at 9:15 in the morning, it looks like there were some still some gaps in the VLC rate discussion. Do you recall what those were at that time?
At that time, no, I don't recall the specifics on that.
Okay. Do you recall if there were any particular sticking points on that issue as those discussions went along between WEPCO and Microsoft?
Not at any given point in time. I mean, there was a lot of communication of, understanding background, restating why certain elements we thought were important to preserve the 4 principles we talked about, protecting other customers, et cetera. So, there were a lot of discussions around that throughout that entire period. But I couldn't tell you on any given day or month or quarter, sort of which topics were being discussed at this point.
Okay. And then on the second page, there are discussions reflecting resource models for renewables and various kinds of capacity. Do you see that?
I do.
And when the issue was options and CO2 positions, what is meant by CO2 positions?
I wasn't actually on in the meeting at this point. These were discussions that were more, I'll call them commercial and generation planning, not specific to the rate. So I don't recall participating in this. So I don't know exactly what was discussed.
I'd like to move admission of this exhibit, which I think would be Stac 18.
Sure, that's fine. Any objections?
No objection pursuant to our stipulation.
Yes, okay, so that'll be Stac 18. All right, and you have other documents?
Don't have other documents.
No.
I do have a few more questions.
Sure, okay.
Mr. Stac, based on what you know about the VLCs currently being constructed or planned in WEPCO's service territory, can you say how many gigawatts of demand from VLCs do you expect in the service territory in the next 10 years?
And I think this would call for confidential information. But I guess I'll let the witness confirm it.
I'm asking for like a gross number, not any specific to any certain resource or customer.
Well, I would say that based on how we filed all this information, whether it be a VLC specifically or in the aggregate, that's all been considered trade secret.
Right, but in the next 10 years, we don't know who else may be applying for service. So it's kind of, I mean, I guess I know what I would object to, but
I guess I didn't understand it that way, Your Honor, but if it's
okay,
10 years from now, it would be called for speculation. If it's something that's in the record right now, I think it would be a trade secret.
Okay, so any response?
Yeah, I intended it, I guess, to be based on what the witness knows right now about what's being currently constructed or planned. Would he have an idea of how many gigawatts could be expected in WEPCO service territory to come online within the next 10 years?
That I think is targeted on the current customers, which would be trade secret. We've answered this question. I don't have a problem with them answering it, but not in an open YouTube.
Mm-hmm.
I can withdraw it. But and ask a different question. Does WEPCO continue to talk to new prospective VLCs that are not included in this proceeding? Without saying who.
WEPCO is approached, I would say WEC Energy Group has been approached by other potentially interested individuals, parties, for potential development of data centers and VLC loads.
And then last question, Mr. Stasek, at the beginning of your examination today by Mr. Proctor Brown, you had some Sir rebuttal. Is it fair to say you are reading that Sir rebuttal from a document you prepared ahead of time?
That is correct.
And had anybody else at WEPCO reviewed that Sir rebuttal before you read it today?
Correct, yes.
Can you tell me who that was? Without saying, if it's legal counsel, I think you can identify them, but not identify the content of the discussion.
I coordinated with my colleague Aaron Nelson simply because there was some coordination between the two to ensure that we didn't leave open-ended anything.
Okay. That's all I have. Thank you.
All right. Great. So I see Commissioner Hawkins is up online here. So I'd like to call you and have you ask your questions. Please go ahead.
Thanks. Good afternoon, evening, Mr. Stasek.
Good afternoon or evening, Commissioner.
Yeah, I guess I'm in evening. A couple questions for you. First, just kind of connected to the last line of questioning from the previous witness. Is it your understanding, and I'm going to apologize on the front end for any gate departure announcements or airport noise. I'm sure there will be some, and I'm really sorry about that for everyone.
Well, I appreciate you taking time out of your attending this hearing while traveling. I appreciate that we could keep our schedule as it is and have you accommodate us in this way.
Definitely. So, Mr. Stasek, is it your understanding that having behind the meter generation located at the site of a VLC would serve to shift transmission costs to other customers?
I think only to the extent that it would be very situational, I guess, Commissioner, to the extent that you build out generation to serve a portion of load, let's just say 2,000 megawatts of a hypothetical, that infrastructure is built and the load ends up being 2,000 megawatts, but then they put 500 megawatts behind the meter, then you could certainly have a case for that. In the event that you built out 2,000 megawatts of capacity to be served through transmission, and then the load became 3,000 and they had 3,000 megawatts and they had 1,000 megawatts on site to sort of counterbalance, you're still at the 2,000, then I would say no. So it would be situational.
Got it. Thank you. Thank you for that. All right, and I'm gonna hop around a little bit. So in the progress payments part of the tariff, is it correct that those cover the financing of new infrastructure that's being built, but those only apply to generation?
The progress payments would apply towards distribution or generation that the customer chooses to pay for, because they're going to be directly assigned those costs. If they choose to pay for those financing costs through current return versus AFUDC, they would have that option to do it for generation or distribution. And that's when those in-progress subscription fees would apply.
Okay, and those payments, I guess, just generally are needed because the financing costs for investments of this size can be rather sizable. Is that fair?
Yes, that is a reason why that is an option for the customer. Yes.
Okay. And are you aware of how financing costs for transmission are paid for?
At a high level. I don't get too involved in the rate making of ATC.
I know commission staff had a data request on this. It was Laura Witzling 1.9, which asked for a quantitative analysis of the financing costs for interconnecting a VLC. And I noticed that there was no response provided to that request. And in the request, the question was also posed in a way that if a quantitative analysis could not be provided, a reason for why not was asked, and that was also not provided. So I'm just interested to know if the applicant has analyzed or looked at the impact that the cost of financing the transmission associated with serving new load in any sort of meaningful way.
We have not done that simply because we don't have the available information to do that, since it's really going to be an OTC project, Commissioner.
Okay. In your familiarity with how transmission is financed, are you aware that existing customers might currently be paying for that financing?
Depending on the timing with when those investments are made relative to when the revenue requirement forecast is pulled together, there is that possibility, yes, based on some, kind of how the mechanics of that work out, it is possible.
And is it safe to assume that that could happen for a number of years before a VLC is contributing to any transmission costs?
I guess it depends on how you define a number of years, Commissioner. I think part of it depends on how fast the load ramps up, number one. The other is depending on how long they're under construction, because those financing costs really just accrue during the construction period. Once they're placed in service, they become in-service capital, and then it's placed into in-service capital. Sorry.
Thank you.
Or rate base, probably easier, better, more common nomenclature. And then you've got the other sort of challenge you have is the way the load ratio share calculation is based. It's on essentially a 15-month lag. So it is certainly plausible that it could be a period of time. The duration of that depends on a lot of factors.
Okay. And are you aware that if ATC is similar to other transmission owners and how they finance their new load interconnection?
I don't know how they are relative, certainly to other transmit or other RTOs or transmission operators.
Transmission
and
operators. Sorry.
Thank you. Go ahead, Commissioner. I'm sorry.
Thank you. And do you know if ATC could modify how transmission is financed in its footprint? Your testimony referred several times to the MISO tariff as controlling, but does ATC not have a unilateral right to modify that at any time?
So my understanding is that there's limited, if any, capabilities there. We do continue to have discussions with ATC, and we're working as a group. I think the other IOUs in the state, we're all sort of hearing some of the feedback, not only in this docket and others, want to try and find a workable solution that can be consistent with what ATC's tariffs allow. I'm not the expert on what ATC can or can't do, but my understanding is they're very limited, but we are working to try and find ways to have things line up more appropriately with cost causation, then maybe you can get rid of some of these lags. And by we, sorry, Commissioner.
No, I'm sorry, go ahead.
I just want to say, when I say we, I just want to clarify, it's sort of at a state level. So there are multiple utilities, as I think you're aware, as many are, all of ATC's customers take service under their tariff. And so the way cost allocation works impacts every one of their customers, whether it be an IOU or cooperative, et cetera. And so we want to try and, I think we collectively want to find a way to sort of modernize the way transmission costs are recovered in today's environment.
Okay, and I think your response was primarily focused on ATC's current tariff, but my question was on ATC's ability to modify that tariff.
So my understanding is to modify the tariff would require a proposal, and then I don't know the mechanics at MISO. I know you are more intimately involved in that than I am, but my understanding is it would require some sort of a decision from the FERC because it is a FERC regulated tariff. So my understanding is that it can't be unilaterally changed.
Okay, my understanding is slightly different than that, but I'll move on from that. The response you had to the proposal on the minimum billing concept, you raised legal concerns with what was proposed by staff for the minimum billing proposal. And I was just curious if you were aware that FERC had approved similar mechanisms for other transmission owners across the country.
I'm not aware of what FERC is authorized for other transmission operators.
And within the Wisconsin Commission's jurisdiction, is it your understanding that we do have the authority to divide transmission costs between our various customer classes?
Yes, at a load serving utility. Yes, that's my understanding.
And that was the proposal put forward by staff?
I think generally, yes, the minimum demand charge would affect that. Yes, I think that's fair.
Okay. We'll leave the minimum billing concept and switch to the discussions around direct cost assignments. Several times in your testimony, you said that direct cost assignments were not possible under the existing tariff. And Judge, I had provided you with a document which is the MISO tariff attachment FF. And I sent that around yesterday. I'm unfamiliar with the normal timeline, so I hope I got that under what was expected by you.
I received it and I have sent it to parties with my offered evidence list.
Okay, if we could go to page
Timelines
49.
don't necessarily apply to you, so that's fine. But let me okay, there we go. All right, so where do we want to be on this document?
PDF page 49.
Okay, sorry.
Thanks. We're looking at the definition of a market participant funded project, which is a project type that is completely funded by a single market participant. If you would take a look at this, I'm interested if you would understand this to be a way of direct cost assignment.
I think it's possible. It appears there's some exceptions, particularly around things that are included in the MTEP appendix, which I think there's certainly some projects in Wisconsin that there's potentially some overlap. So I think there's just a lot of nuance here, and as I think I try to be clear about it. I'm not an expert on the MISO tariffs or FERC regulation. I presented information as I understood it from the work that we've had up to this point, and the basic understanding I have of the way we're billed for transmission service.
Fair. The other document that I provided was an ATC business practice manual. And on here, I've lost what exact page I was interested in. I might need a moment. But there was an intervener that raised, a couple interveners raised the complexity of serving new large loads and the lack of reliability standards. I believe it was Witness Adams. And I'm just interested on your perspective of whether you're aware of specific reliability standards to serve loads the size of a VLC, or if there's anything unique required from a transmission perspective to serve these types of loads.
I'm not aware of anything specific. My understanding of what took place is as we were approached by the VLCs for seeking service in certain points within our service territory, ATC was engaged with the load interconnection request form, and the process from that point was triggered, and studies were done per ATC standards. I did not have involvement beyond, or even an understanding beyond that level of detail, Commissioner.
Okay, and then if we just go to the top of this document, the purpose statement, it's right there in number 1. Basically, this document speaks to, ATC's standard design for serving a load and the potential need for particular customers to need something beyond standard design, and allows for those customers to elect to pay for something additional to what would be required otherwise. And so the presence of an elective transmission path, I'm wondering if you would see this similar to the market participant funded project as another avenue where costs could be direct assigned to a customer.
I guess in my read of this, just really quickly, I think again there's the possibility, but it talks about under circumstances, as it's that second sentence under 1, in which ATC's proposed design for satisfying this obligation is different from a customer's requested design. These elective interconnection facilities may apply. So, I'm not close enough to how ATC would apply that standard and where it might get triggered to where it could become applicable in interconnecting or building facilities for either of the 2 VLCs or any future VLC for that matter, Commissioner.
Okay. Thank you for that. I think we can leave this document and go to, I guess, just a more general question on the definition of a bespoke resource. And I'm curious as to why in that definition it's a requirement that WEPCO needs to be the owner of the bespoke resource.
Well, a couple of reasons that I recall from when we started the process. The customers wanted grid connected. From our standpoint, there's not retail choice, so the utility would really be the individual entity that would own and operate that for their behalf, being the 2 primary reasons.
And I believe there was a question, maybe a data request about the potential to be served through a PPA with the applicant. Is that something that's allowable under the tariff as proposed?
As proposed, PPAs really don't fit the definition of what a bespoke resource is.
Are you aware of other tariffs that WEPCO has that limit the ownership of generation to a certain ownership type?
No, but there's no tariff that really sort of is comparable where customers are subscribing to and paying for specific facilities to serve their firm demand requirements. So I'm not sure that there's something that's comparable. I guess the only thing that would be close would be the DRER tariff, so Dedicated Renewable Energy Resources rider. I know that's a mouthful. That was approved in 2018 for customers that wanted to subscribe to certain portions of renewable resources, but that was company-owned resources as well.
Okay. And I'm curious if this requirement to have the VR resources be company-owned resources, in your view, is this contributing to the financial risks to the credit metrics that are highlighted in the discussions around the required ROE and the need for an increased ROE and the requested capital structure?
I would suggest that it not directly. I think it's the significant investment that's going to be needed, and then the large bills, and whether particularly the MISO market revenues, for example, because these customers, at least as proposed, would buy all of their energy at market. So we have some significant legs there, so that creates some risk on cash flows. So I would say in totality, the tariff does that, but I wouldn't point to any one specific thing that I would say triggers it.
Okay, and then I'm going to repeat a question I asked of several of your colleagues earlier, much earlier, I guess, in the day, related to the reliability of resources located external to LRZ2. And I'm wondering if you are aware of any evidence in the record as to the diminished reliability of resources not located in LRZ2.
I'm not aware of anything different or more than what the other witnesses had shared. Beyond that, I guess the other context I might provide to that to answer your question is, the thought is the closer that the resource is, and I think witnesses aren't covered this a fair bit. You're not as dependent on, you don't lose as much on losses, and you're less susceptible to congestion. So it's just more efficient, I guess I would say, and more resilient to have that generation as close to load as you possibly can, knowing you can't get it all right on top of it. The other thing from our perspective is that does two other things, or at least one other key thing, is having the resources within LRZ2 close to load. It balances out the supply and demand to keep MISO market prices, whether it be day ahead or real time, sort of in check compared to what those prices could look like if all the resources were located outside of Zone 2, for example. Because you'd have the local generation and not have to worry about the other elements.
And is it fair to say that requiring resources to be located in Zone 2 increases the rate base of ATC?
I think it's likely that it would, but it wouldn't necessarily. There's going to be, I think every project needs to interconnect, but whether or not it would require improvements beyond that, it would be situational.
And are you aware of the costs that WEPCO customers pay for transmission service to access resources in zones outside of LRZ2?
I do not know that.
Okay. I wanted to ask you a question about your exhibit STASIC 12, which I believe is a comparison of transmission costs.
Your Honor, this exhibit content would be confidential in some part.
Yes, I understand.
Okay, just wanted to flag it.
Yeah, public version I'll display, and I'll ask the commissioner if you do want answers regarding the confidential information. We can go into closed session.
No, I don't. It's just on the approach and the methodology used, so we should be clear.
Okay, thanks.
So I just had a question. In this comparison, generally, in your direct assignment approach that's used here, is it accurate to say that the direct assignment of the projects that would be required to serve the VLCs, in that method, it assumes that no other costs would be incurred from utilization of the entire existing transmission system to serve the VLC?
Correct. The direct assignment was to identify the revenue requirement of facilities that would otherwise, but for the VLC, would not have otherwise been constructed.
Okay, so we're comparing the entire system with the facilities for the VLC to just the VLC facilities, and that then assumes utilization of the system at zero cost.
That is a way to summarize it.
Okay. Thank you. I think that is it on this exhibit. Sorry for being disorganized, but I do have one more question related to the requirement for resources in Zone 2. I think you mentioned price risk or congestion earlier, and that was in some of the testimony, and there was discussion earlier in this hearing about the PRA prices. I think that was witnessed earlier. Are you familiar with how frequently there's price separation between Zone 2 and other resource zones, or if there has ever been?
I'm not personally familiar with the details to that level.
Okay. And then I was asking a question earlier this afternoon, and it was, I believe, referred to you related to the insufficient capacity charge. And in the definition of that, there's a requirement of a 36-month consecutive insufficiency. And that would be an insufficiency of, I believe, bespoke resources and fleet firm resources.
I'm sorry, and what resources?
And fleet firm.
So I'm just going to pull up the tariff and have it in front of me, because I did look at that. I was watching while you were talking to Mr. Arndt. I knew it was coming my way.
What exhibit are you on?
It's going to be, I'm double checking right now. It's going to be Exhibit 2.
Okay.
I'll get you a page number in one moment, Your Honor.
Okay.
And I appreciate
page
this
15.
I did not do the homework.
Page, give me that
15.
page. 15, huh? Computer's not cooperating. Okay, let's do this. There we go.
All right. So where I would start by answering that question, commissioners, I think there's a slight distinction between when it's triggered and how it's calculated. And so the triggering occurs when the bespoke resource firm service volume is not, I'll say it the other way. The metered peak demand, so the customer's actual demand, is beyond the bespoke resource firm service level during the previous 36 months. So there's not a consideration of the fleet firm service level to determine if this charge gets triggered. But when it is triggered, we look at the meter demand minus the bespoke minus the fleet firm, and then that 100 megawatt allowance to determine what their actual penalty would be under this insufficient capacity charge.
Okay, so the sufficiency is only compared to the bespoke resource quantity and does not consider the fleet firm quantity that's available.
I'm sorry, your voice is dropping. I'm sorry.
Sorry.
Bespoke resource quantity and does not.
Consider the fleet firm service.
That's
quantity.
correct. That's correct. To determine whether or not the charge is going to be charged. The calculation of what that is would factor that piece in.
Got it. I think that addresses my concern on that issue then. So I believe that brings me to the end of my question.
All right. Thank you, Commissioner.
Thank you.
And so we've heard from the parties listed here. Any other parties have cross?
Your Honor, yes, Steve Heinzen for WEG has some cross.
All right. Just gonna rearrange people here a little bit. Let's see where you are. Here we go. Oh, it's not working at all. Hang on. All right. That's close enough. Okay. Excellent. Go ahead.
Good afternoon, Mr. Stasek. Steve Heinzen for the Wisconsin Industrial Energy Group. I have some questions regarding what you earlier today called the safety valve mechanism in connection with the capacity-only bespoke resource during Mr. Narby's cross-examination.
Okay.
And, right, and if Your Honor, if we could look at Sir Rebuttal Testimony, page 6. It's a spot to start.
Sure. I have it here. Go ahead.
All right. Yes, thank you. So, Mr. Stasek, here you describe a process whereby the commission can review the actual net benefits earned by capacity-only bespoke resources that could result in certain prospective rate-making adjustments if the actual benefits differ from projected benefits. Is it your proposal that this first review year would occur in test year 2033 rate case?
Yes, that is the proposal.
All right. Well, given that the Sir Rebuttal Testimony was filed just 2 days ago, would you agree that parties have not had extraordinary amount of time to fully vet the proposal in this proceeding?
I don't know. I think no, I'm kidding. Sorry. Yes, I would agree.
Okay. Since the first review you propose is well into the future, would WEPCO be willing to submit this proposal in the upcoming rate case to allow parties more time to fully review it?
I guess I'd have to. It seems like this would be the place to capture that because I think the VLCs are looking for some understanding of what it is that they're signing up for. So I don't know. We'd have to consider that and think through. And I think that'd also be a question that would be relevant and germane to ask the intervening VLCs in this docket, Mr. Heinzen.
Okay. Well, all right. Thank you for that. Is the review mechanism? Well, you remember you are familiar with Mr. Pollock's testimony?
Yes, I've reviewed it when it was first filed. Yep.
Right. So is the review mechanism that you're proposing here intended to be a substitute for what he described as the operational ring fence? Or is it WEPCO's version of how an operational ring fence might work?
I would say that this would be our proposal to address the concerns that Mr. Pollock and others had raised with the tariff, as it were. So it'd be we would offer this as an alternative to other alternatives proposed, including Mr. Pollock's.
Okay. Would you agree that that your proposal is not testing whether or not there are net benefits, but instead is a comparison between what WEPCO projects will be net benefit or cost and actual net benefit or cost?
I think the comparison proposed is properly characterized in your question, that it would be comparing forecasted benefits to actual net benefits or costs in any given year. However, I would also point to testimony that's been provided in this case and our commitment to not put forth capacity or resources as a capacity only bespoke resource unless they're modeled to show net benefits to non-participating customers over their life.
Okay, yes, right. Okay. But at the end of the day, your proposal is not intended to ensure that non-VLC customers have a net benefit.
I think over the life of the projects, yes, it is intended to do that. And I think that's how it would be accomplished. It's the concern of trying to, what we're trying to adjust for is the fact that, as I talked about earlier, when Citizen Utility Board Attorney Narvi was talking with me, is just early on, there's some of the modeling shows that, there might be a net cost in the first couple of years because of the way revenue requirement works, and not to automatically trigger a realignment just based on what's expected, right? Okay. And so this would be a mechanism to compare what was expected versus what actually occurred. And if that variance is outside of a band, then an adjustment probably needs to be made, because you can perceive that you can project that variance in the future. But if there's a net cost, but it was projected to be, I don't think it would be appropriate to make an adjustment just because of the first 2 years of operation, one of them had a net cost.
Okay, and would WEPCO be making a forecast on an annual basis, or would it be relied upon the forecast that it had submitted in support of the project before the commission in the first instance?
So the intended baseline would be the initial baseline would be the forecast included in the analysis with the project, and then actuals would be compared against that on an annual basis. So the first year of in-service, you'll have a forecast, the second year all the way through the life, and you'd compare the actuals to that initial forecast.
Okay, so whatever you would have a forecast for, the 15th year out as part of the proceeding to get the project approved by the commission in the first place. And that would not change it would never change. That would just be the forecast that was being relied upon, that you would then compare the actuals to in the 15th year.
The proposal yes, the proposal includes that as the baseline, because that was the analysis the commission used to make its decision in the generation, acquisition, or construction docket in the first place.
Okay. All right. Thank you for that. Could we look to figure 4 on page 16, please?
Sure.
And
hold on, I got things crossed in my head, and I went to page 14 looking for figure 6.
No, yeah.
No, I know, I caught it. Now I'm where I need to be.
Figure 6. All right. No, thank you. So it's really, it touches upon both figure 4 and figure 5, but we'll start here on figure 4. And I just want to make sure I understand what you're setting forth here. In this case, the forecast was a $10 million net benefit and an $11 million actual benefit to non-VLC customers. Is that right? That's on line 10?
That's correct. That's what this example shows.
Okay, so the non-VLC does better than the forecast, which is outside the 5% bandwidth. And the result is shown on the following page on figure 5, which is to then make an adjustment to the ratio between the VLC and non-VLC customers to decrease the percentage responsibility of the VLC and increase the percentage responsibility of the non-VLC. Correct?
Yes, that's correct.
All right, on a going forward basis.
That's correct.
Okay. I want to just switch this up now. If we could pop back to figure 4, please. And for this, really, I'm only interested in 10, 11, and 12, those lines. But to switch it up, what I'd like to have you consider is a forecast that is a $10 million net cost to the non-VLCs when the actual net cost is $9 billion. So like the results that are shown in figure 4 and 5, the non-VLCs have a better actual cost than the forecast cost by $1 million, which is outside the 5% bandwidth. All right, do you understand?
Tracking. I'm understanding you. Yep.
Okay, so in this result, then, there would again be an adjustment to the ratio between the VLC and the non-VLC customers. And that result would be, again, to decrease from 75% the percentage responsibility of the VLC and to increase from 25% the responsibility of the non-VLC, correct?
That would be the effect, yes.
Okay. So in this circumstance, and what we have here is the non-VLC customers would in fact have a net cost in that year of $9 million. And they would then in the following year have still a worse ratio responsibility for the generation resource.
I would say they would have a allocation percentage that would attempt to realign the actual net benefits or costs in a given year to be consistent with what was modeled when the commission would have authorized the project to get the net benefits over on an NPV basis over the life of the asset.
Okay, so then on an annual basis, so we could have a circumstance where there is a significant net cost to non-VLCs, which is certainly not trued up in the approach that you're taking in this proposal, right?
I'm not sure I followed the string there. Sorry.
Sure. No, it's not intended though to bring the non-VLC customers closer to a benefit in an annual basis. It is strictly looking over the long haul.
Yes, that's correct. It's intended to be a safety valve for delivering the net benefits on an NPV basis as forecast when the projects were evaluated by the commission at the onset.
Okay. Okay, thank you. I appreciate you walking through that with me. I don't have any further questions.
All right, thanks. And I do want to interject before we move on that we had the two the two exhibits from that were offered by Commissioner. We've discussed those. I've marked them. So there's the MISO, the FF tariff. I marked that as STASIC 19, and the ATC BP, the business practices document, is STASIC 20. So I'm going to ask if there are any objections, but I'm not going to take any objections. So
I do have a concern, Your Honor, on this.
Sure.
500-page document.
That's okay. We have plenty of storage at the commission here. We're getting more. It sounds like so we're all good. Okay, so let's move on. Any other cross?
No parties have any cross. Commission staff does have some, Your Honor.
All right, sure. Go ahead.
All right, we're approaching evening here now, so but it's still a good afternoon, Mr. Stasek. Evan White's on behalf of commission staff. I want to start. I'm going to try to work sequentially with your Sir rebuttal testimony. So, Your Honor, if we could pull it up on page 5.
Right.
Sir rebuttal page 5. I'm just to confirm.
Yep, that's correct.
Okay. Thank you.
All right. Let me know if you're there.
Oh, yep, I'm there. Thank you.
Okay. So on page 5, you note that the Bespoke Resources tariff as originally proposed includes a provision that would allow modification of the 75-25 split for capacity-only resources, correct?
That's correct.
So a question I have on that is, can the commission initiate that modification, or would that only occur if there was mutual agreement between the applicant and the VLC?
So I think the way that the language is drafted in the tariff, this would be something that would be initiated through mutual agreement between the company and the customer. That being said, I think the commission has the authority and jurisdiction to open a docket or a proceeding for whatever it chooses to. So, certainly could do this on their own as well.
Even if the service agreement specifies something different, you're saying that could be modified by the commission?
I guess I'm not an attorney, but my understanding is the commission has they always retain jurisdiction in every order that they issue. So to me, and my fundamental understanding as a regulatory person without a legal training or background, that would give the commission the authority to do that.
Would the applicant be open to amending this language as we see here on page 5 to make that explicit that that could also come from commission initiation, or the commission could initiate that conversion?
I think given we filed this with the support of the VLCs, we would need to hear from the VLCs on that before we could unilaterally agree to a change.
Okay. A follow-up question on what the commission's evaluation would look like in such a circumstance, whether that be whoever initiates it. What sort of information would the applicant be providing to support a request for the commission to determine whether or not it's reasonable to approve conversion of a capacity-only resource to full benefits?
I think it would certainly depend on a variety of circumstances. But I think conceptually at a high level, you'd expect to see up to that point how the bespoke resource that's capacity only looking to be converted had performed relative to how it was forecasted, as far as dispatch and marginal costs, et cetera, as well as what it might look like on the future. And then what would that do to the capacity need and potential costs of having to replace that capacity to I'm sorry. Yeah. Let me just think about that. The energy production, sorry, for our non-VLC customers. So I think it would have to be a holistic approach to evaluate how it has performed, how we anticipate it would perform, and then what does that do to the needs for our non-participating customers and the costs there. Again, going back to what I referred to, I think it was when Attorney Westerberg was talking with me around the 4 principles. So one of those things that we talked about from the beginning is we want to make sure that anything that's included in this tariff adequately protects our customers and is properly evaluated before changes will be made.
Would that presentation of information include addressing the concern, I guess, and I think you were just referencing some of this in the cross from Attorney Heinzen, that for some of these resources, the first few years are very cost heavy, and the benefits are more on the back end. So how would that look if non-participating customers are incurring costs up front and then it's converted to full benefits, whereby the VLC would derive the benefits on the back end?
Yeah, I think it certainly factors in. It would have to factor into the evaluation how mechanically. I think it's a little early to say. I'm not sure I can articulate that exactly as I sit here on the stand, but that concept of we have to maybe get additional resources to backfill for that energy that the customers, non-participating customers, had already paid for, that all needs to be factored into the equation so that there's not a free ridership concern.
Okay. One other quick question here on the tariff as originally proposed. Does the initial designation of a resource as capacity only or full benefits require commission approval, or is that a company decision?
Could you just clarify what you mean by initial, Attorney Whites?
Sure. I guess let me ask it this way. When the company offers a resource as capacity only or full benefits and provides the accompanying service agreement, because there's 2 different ones depending what type the resource is, can the commission say no to capacity only that can only be offered as full benefits, or is that a unilateral company decision as far as which resources to offer under which umbrella?
So in my understanding of your question, when the resources are proposed, so sort of fast forward 6 months and we're maybe have an order here and something to follow, and we would propose a new generation facility that would be a bespoke resource of some kind. Our expectation is there would be a service agreement that would be executed between the company and the customer for that resource, designating it as either capacity only or full benefits. That would be filed as part of the application to acquire and or construct that that facility in a docket. And then the commission, as part of its overall evaluation, would still need to approve the service agreement while it's approving the generation facility. So ultimately, the commission could make a determination at its discretion at that time.
So if the company or the applicant is proposing a resource as capacity only, and you include that service agreement, as you just said, as part of that docket to either construct or acquire the resource, and the commission determines that it would not be appropriate to offer it as a capacity only resource, the company would still pursue that construction or acquisition, but convert it then to full benefits, or how would that work?
I think at that point, if the determination from the commission was to deviate from what was initially agreed to, the customer would have to evaluate if they want to take that as a full benefits in that case. And then depending on the outcome there, we would either move forward or maybe, there's just a lot of scenarios that could play out there. But we certainly wouldn't just go as intended or as approved, or I'm sorry, proposed if it was different than what the commission approved.
So essentially, even if the commission said this was more appropriately a full benefits resource, the customer and the company would have the final say whether to move forward with that.
No, I think that mischaracterized. I'm going to object to that because I think it mischaracterizes the testimony. But
I think you're seeking clarification with that question, which is so
exactly. Yep.
We can have those.
So if I got that wrong, Mr. Stasek, please feel free to correct me how you were envisioning this happening.
So what I was intending to say, and I'm not sure if this is how you're articulating it, is if we file for project X as a capacity only resource with a service agreement that's been executed to take that bespoke resource as capacity only, and for whatever reason the commission says, yep, you can go ahead and build it. However, we don't think the economics that were presented to support it as a capacity only resource make sense, or for whatever other reason, they say this resource cannot be offered to, under this service agreement as proposed as capacity only. At that point, we may choose to not proceed with the project if there's not a customer to take it. So we're not going to just build it for the sake of building it without a customer. So if the customer were to elect to say, no, I don't want that as a full benefits resource, in that hypothetical situation, there is the potential that the company could then maybe not pursue the project.
Okay, thank you. In that scenario, then, for whatever, a long lead time equipment or expenditures had been made prior to authorization, would the VLC customer still be responsible for those costs?
Your Honor, I think this gets into one, potentially terms of PCAs that are still confidential, and really a very nuanced legal question that Mr. Stasek is not an attorney.
I'm just asking Mr. Stasek's understanding of how those costs would work.
Okay, well, I think the witness knows the parameters of disclosing, what information shouldn't be disclosed to the public, and can speak to his understanding of the proposal. So go ahead and answer with that in mind.
Based on the understanding that I have, the circumstance that you had conveyed, the initial customer who had subscribed to or signed a service agreement to subscribe to that agreement would have cost responsibility for any costs that were incurred up to that point before the commission decision.
Okay, thank you. Now I want to turn in your SIR rebuttal to pages 6 and 7, which outline this new approach to the capacity only resources, which essentially allows the periodic rebalancing of that 75-25 split. Is that a fair summation of it?
I think it allows for it in the event that an analysis hits a certain trigger point. Yes.
Sure. So in that description that you have on pages 6 and 7 and some of the follow-up questions, you make reference to comparing the forecasted, what's forecasted to the actual results on a portfolio or portfolio basis. When you use that term, does that mean across all VLCs, or is that specific to each VLC?
So the portfolio as it applies to each VLC. So the analysis would be performed individually by resource, then aggregated for all of the resources for a specific VLC.
Okay. And would that just include the VLC's capacity only resources, or would there be anything else included in that portfolio as you understand that term?
It would be the capacity only resources.
Okay.
Only.
Why did the applicant choose to apply this framework that you propose in your SIR rebuttal on a portfolio basis rather than looking at each capacity only resource individually?
Our view is that, I guess, statutory, sorry, it's just been a long afternoon. The statutory framework really applies to the tariff as a whole, that customers shouldn't be harmed, non-participating customers shouldn't be harmed by the operation of this tariff as a whole. And so rather than look at individual resources and make decisions there, to look at them in the aggregate was more consistent with how application of the regulatory or the statutory framework would be most appropriate.
Okay. Turning to, and this sort of bridges the gap between what we were talking about earlier and your new proposal. Under this new proposal, could a VLC still seek conversion of a capacity only resource from capacity only to full benefits?
They could, in the event that it triggers I'll call it the safety valve for lack of a better term in shorthand. But if the safety valve were executed, we go through the process and it triggers, so it's outside that 5% tolerance, and it would necessitate or result in a cost allocation change. At that point, the customer could choose to just forego that if that cost change and then convert to a full benefits resource.
And would that still require commissioner approval then for that conversion?
I think everything that would be done here would be subject to commission's approval because, again, as we talked about, I think a little earlier, Attorney White's, the commission always retains jurisdiction in all of their orders.
And I think your previous answer gets to what I'm looking for here, but that conversion, so under this new proposal, that wouldn't be subject to that same 10-year and then every subsequent 5-year timing as originally proposed. It sounds like a VLC could elect to convert at any time that there is this rebalancing.
That's correct.
Okay. And should a VLC elect to seek conversion, would that also be on a portfolio basis, or would that be resource by resource?
I think they would have that. They would have the option to do either, as I understand it, and the way that we articulated it, at least as proposed.
You stated that the VLC would have the option after this kind of comparison between the actual results and the forecasted results to convert. Could the commission require conversion from capacity only to full benefits in lieu of that rebalancing?
I'm sorry, could the commission require conversion?
From capacity only to full benefits in lieu of rebalancing.
Thank you.
Under what we've got proposed, that wasn't an element of that. At the same time, I think we've talked about this. The commission's ultimately deciding these tariffs, so I can't certainly speak for what they would consider to be an appropriate condition or a modification. But that, as you've articulated, it was not part of the proposal. No.
Okay. As proposed, this rebalancing would occur every other rate case. Could there ever be a scenario where a VLC is responsible for greater than 100% of capital costs to make up for the actual results, causing substantial net cost beyond what was forecasted? Net cost to non-participating customers.
That not as part of this proposal, no.
So even if the actual results, and it might be helpful, Your Honor, if we can pull up, I want to say it's table 4. I don't remember the page in the Mr. Stasik's SIR rebuttal.
Well, that's page 16. I remember that from when Mr.
right.
Heinze was talking to me.
Yes, that's right.
Thank you.
That's the first table, yeah.
Okay, so again, to use that example that we were talking about earlier, for this hypothetical, the difference from expected net benefits on line 11 is $1 million, correct?
That's correct.
And then if we go to figure 5 on the next page, how the rebalancing then occurs is that $1 million is essentially added to the non-VLC revenue requirement on line 4 and subtracted from the VLC revenue requirement on line 4. If you need to go back to figure.
No, yeah. So what this does essentially, and maybe I'll just kind of step it through, is we just did in Excel, there's the function to basically solve for, to get that difference that was 1 million in figure 4, to get that to be 0 here. And so that's just changing the allocation between VLCs and non-VLCs so that the year being evaluated in this hypothetical example gets the same result as what was forecasted. Then that it's not a recapture of any kind. It just applies that split, the adjusted split on a go-forward basis for base rate revenue requirement.
Well, if we just compare the line 4, so the revenue requirements of 55.6 million and 19.9 million to the previous page, where the revenue requirement is the 56.6 and 18.9 on the right of that 4. Line
yes,
4.
I see. I see it.
So essentially, it's just adding that $1 million from line 11 to 1 and subtracting it from the other.
I guess mechanically that's yes, but that's not how we got there. But yes, that's the result.
Okay. So I guess that's a long way of getting at if that delta or result, however you rebalance, yields a result that actually should be that the costs incurred by the VLC should exceed 100% of the revenue requirement to achieve that same rebalancing, that would still be capped at 100%.
Yeah, I guess I'm just running through. I don't think the mechanics would ever get to a point. Maybe you've got someone that has done that to try and, I'll call it, break the model. But I'm just thinking through it here on the fly. I don't know that there would be a scenario where the actuals would deviate from the forecast so much that you would be allocating more than 100% of the costs. I guess I could tinker on the side and try and figure out if there's a way to break it, but
I mean, just looking at what we have on the screen, the forecasted net benefit here is $10 million, right?
Yes.
Compared to a forecasted revenue requirement for non-VLC customers of $18 million, right?
Yes, that's all there. Yep.
So, I mean, it'd be an extreme example, but let's say for whatever reason, there was a $8 million or a $9 million cost instead of a $10 million benefit in the actual results, that would exceed the revenue requirement as far as the delta on line 11, right?
It would, but that's not the mechanics of how the rebalancing would work. You would rebalance the percentage, not the dollars.
Okay. So it's strictly on a percentage basis.
Yes, that's correct. You would just recalculate what that split percentage would need to be in order to rebalance or reset, for lack of a better term, to get to that forecasted net benefit or cost for that given year.
Got it. Okay. So I guess with the theoretical 100% limit, would that also apply to non-participating customers where I struggle to think of an exact hypothetical, but where conceivably, depending on the performance of the resource, that rebalancing could cause the cost to non-participating customers to go up to a hard limit of 100%?
In a purely hypothetical and academic sense, potentially. I don't think from a practical standpoint, you would see that result.
Okay. Under this framework that you propose in Sir Rebuttal, what happens if a VLC terminates service at some point in the agreement?
Nothing different. I guess maybe if I could clarify, like when did they? I'll just answer the way I thought you asked the question at this stage. The terms of early termination, which lasts the entire duration of the Bespoke Resources Service Agreement, not the VLC service agreement, but the Bespoke Resource Service Agreement, which for natural capacity only non-solar and wind assets is the life of the asset. That does not change. So they would still be on the hook for those costs. And it would be whatever the book value is based on the percentage that is in force at that point in time, because that's how the rate base would be sort of recalibrated in the rate case most recent to that event.
So based on the end of your response there, that would be fixed in time at the time that they terminate rather than rebalancing continuing to occur post-termination.
Correct, because they would be required to essentially write a check at that point of termination. And then that, as we've talked about in testimony in this docket, the asset base gross plant would be written down so that it's no longer on the books.
So if that split is fixed at the time that they terminate and they have to write that check, would the non-participating customers or non-VLCs still be on the hook for their contribution going forward, irrespective of whether or not the actual performance deviates from the expected net benefits?
At that point, yes, if it was still rendered to be an asset that was needed to provide service, yes. And the customers that are non-participating customers would at that point for their, we'll just say 25% locked in at that point, would still be, they'd be paying for the 25% of that book value that's left, the operating expenses and the fuel, but then they get all the benefits of the capacity, the energy, and the ancillary services, the full complement of benefits that those resources provide at that point in time.
Okay.
Sorry, Debbie.
Oh, that's okay.
So, do you have anything else along those lines, Evan? Because I just had a follow-up from what you were just...
Go ahead.
So I'm just curious if the VLC termination, there's no that could happen at any time under the agreement.
It can. And if they terminate at any time, they're on the hook at that point in time for the book value of the asset, provided there's not another customer to step into their shoes, right, or the commission we weren't able to justify and get commission approval to I'll call it repurpose it to serve our general customer base.
So it's theoretically possible for a VLC to wait till this allocation goes below 75% and terminate and have less of a cancellation cost than if the allocation's at 75 or higher.
Again, hypothetically, sure. I just don't know that there would be a mechanism for them to have that kind of foresight till the reporting was pulled, but it is theoretically possible.
But the allocation is going to last for a year, correct?
So the way we have it proposed, the allocation would be sort of locked in for a period of until every other rate case. So it'd be
Every
sort of
other
there
rate
for a
case.
4-year cycle.
Yes, right. Sorry, you're right. I'm thinking about a different kind of system we have in place. But yeah, okay. So they would have that. They would know what the allocation is. So it could be less than what's being committed to at the beginning. Okay. All right. Sorry, Evan. Go ahead.
No worries. And I guess one last question before I leave this topic. You mentioned the timing, the 2033 is based off of projected in-service dates for Foundry Ridge and Red Oak Ridge. Are there any other capacity-only resources that would have in-service dates earlier than the timing of those two?
According to current construction schedules, you would likely have the Paris Rice facility and the Oak Creek CT facility achieving in-service in late 27 to mid to late 28.
Based on that, would the applicant agree to an earlier implementation of this proposal than 2033, given that those resources would have more operational data sooner than Foundry Ridge or Red Oak Ridge?
I think certainly wouldn't be opposed to that. What we need to be mindful of as that's thought through is those in-service dates along with when filing dates would be for rate cases to line up. So if you think about it, we're in 2026 now, filing a 27, 28 test year. So it means in 28, we'd be filing early 28. We'd be filing a 29, 30 test year, which we really wouldn't have data even for a plant that would be in service in the middle of 27. You only have 6 months of actual data. So you're probably, best case scenario, having realistic data to look at would be a 2030 rate case filing with a 2031 and 2032 test year. But it would be pretty isolated to those two resources if that were a route the commission pursued.
Okay. All right. Leaving capacity-only resources. Earlier, I asked witness Gerlikowski some questions about firm gas expense. Were you present or did you hear that line of questioning?
Indeed, I was, yes.
Could you just describe, I think, what witness Gerlikowski was trying to get at as far as how those costs or expenses would pass through and whether they'd be incorporated in either O&M or monitored fuel?
Certainly. So our intent is to file in this next rate case for a change in the way that we allocate those costs and how we recover them. Obviously, that's going to be subject to the commission's approval in that rate case. But the way we're thinking about it and plan to propose it would be that those firm gas costs for things like the infrastructure you're talking about with some of the recent projects that have been or are pending approval, moving those out of firm gas costs through PGA and having those be collected through a demand charge. That demand charge would then be considered O&M and then split 75-25. It would not be anticipated that those would be collected or recovered for any customer, non-VLC or VLC, through the monitored fuel.
Okay, thank you. Then I want to turn lastly to your Sir rebuttal that you gave. Seems like a long time ago now, but I guess just earlier this afternoon.
It's only 3 hours ago.
You mentioned some response to Commission Staff Witness Cobal's testimony about the transmission expenses. And I just wanted to confirm, did you perform a separate analysis or was your discussion of that based on the analysis that Witness Nelson was talking about earlier today?
So it was just, it was not a separate analysis. It was complementary to Mr. Nelson's analysis.
Okay.
And it wasn't I guess it was context around what his analysis showed. So with that break, okay.
Okay. You mentioned that part of, I guess, the disagreement between the applicant and Witness Cobal's analysis is there was $330 million in what you termed contingency costs, which might not be spent. Did I get that right?
That's based on the information that's in the payment and cancellation agreement that witness Coble, sorry, I hope I got that right, because I always get the wrong one in my head. But what he referenced, there's $330 million of contingency ATC identified in that PCA. That's what I'm referring to.
And certainly you're familiar with the applicant's construction projects. Isn't it fairly routine to include contingency costs in estimating project costs?
Yes, but I think it comes down to the timing with which the contingency is provided and how much the contingency is to the estimated project costs. I can't speak to how ATC does it, but I know when we first start out with projects, there's a number used, but by the time we file our projects for approval, the contingency as a percentage of the project is significantly smaller than when we initially started to do forecasting and internal budgeting.
And even with contingency costs built into a project's budget, in the recent past for construction projects, has it been your experience that oftentimes those still go over budget and incur costs even above and beyond those estimated contingency costs?
They have recently, due to a variety of factors, force majeure, trade policies that kept us from getting solar panels out of those were the ones we had the most, where we couldn't get them out of customs custody because they were waiting to clear tariffs that were put in by the federal administration. So yes, there were some cost overruns, but for very, very unique circumstances.
So there's certainly reasons that that contingency money could be spent, or costs could exceed those contingency estimates even.
Could be. That's the whole point is of what I think we're trying to say is that analysis was done. We didn't have an opportunity by witness Cable to really ask questions or to provide sort of an alternative view of it because of the uncertainty of what those costs actually would be around contingency, as well as the other factors that I referenced in my rebuttal testimony. Sir, rebuttal testimony.
But in your analysis, you remove those contingency costs. Did I get that right?
To demonstrate what it could be on the opposite side of where you could still see a benefit for other customers through that analysis for that project.
Okay. Another point that you made, or some costs that you removed, you mentioned that MISO had concluded some of the transmission upgrades were part of the long range transmission planning, or LRTP process.
Yes, that's my understanding.
Are you also aware that some of the upgrades proposed by ATC have gone through the separate EPR review because of their need for interconnecting the VLC customer?
Yes, but I don't think that necessarily really gets at it. Doesn't change the fact, the timing doesn't change the fact that the upgrades would be needed either way. It's a timing difference and not a cost difference.
So your understanding is that those costs would still be shared across the regional footprint rather than being directly allocated to ATC?
I'm saying it's not fair to just assume that those costs are only being incurred to interconnect the VLC.
Okay, maybe I'm missing the nuance of your point. So you're saying even if those costs are incurred exclusively by ATC, that it's not just driven by the interconnecting customer. Is that the point?
Yes, that is the point. That some of the investments included in that PCA, that the VLC to that PCA is backstopping and committing to, would be incurred even if that customer didn't exist. It may not happen on the exact same time frame, but they would be required.
But the LRTP projects are cost shared beyond just ATC, correct?
That's my understanding, yes.
Okay. Thank you. With that, I don't have any further questions.
All right, great.
So that's all across from parties and commission staff. I did have a quick question. I'll try to be brief. It's pretty specific. And I was just curious if Witness Stasic, you understood what WEPCO means when it uses the terms on its special service tariff. I can show that if you need. It's volume.
Yeah, I do have I do have the ability to answer, but I wrote notes and I don't have them in front of me. Is it all right if I step away for a second to grab them?
Oh yeah, sure. Let's go off the record.
All right. Thank you for that.
Great.
Yes.
All right, let's get back on. So yes, in terms of that special service tariff, it's volume 17, section 102.4, sheet 15. And the two terms that are used there, special service and power service, if you could give us the working definitions for those, please.
Sure. Special service is essentially where a customer pays the whole cost of a new service without what we call embedded credits. Because one of two things are met. We either have already provided service to that property and the customer wants an additional service, and they're requesting a second service. The second situation would be under special service, would be requesting a service they wouldn't otherwise qualify for. So they essentially want to upsize their service beyond what their service needs actually are, but they still want it for their own reasons. The customer is requesting sort of a unique design or a design beyond normal spec. So that's considered special service.
Okay.
And then should I just go right into the power service, Judge?
Sure.
Okay.
Sure.
All right. So power service, basically, it's provisions that we added to the tariff back in 2006. And the term power service really just sort of a unique term that best we can tell was added to the tariffs there just to be a synonym for electric service. It doesn't have a unique working meaning.
So just service, basically.
Yeah, basically, yeah, electric or power is sort of synonymous with one another, but yes, just regular old service.
Okay. I'm sorry, Debbie, go ahead.
Did you say 2006?
Yes.
Okay, just making
2006.
I haven't written that in a while, so just making sure I did that right.
Well, we've been around
back
since
when I had hair.
Yeah, right. Okay, so I guess looking at the tariff then, I guess one of the provisions that comes up when you read the special service tariff is this qualification. It's if we can cite it as 102.4 sub B sub 1, and it does talk about when special service is being requested, there is sort of a qualifier, is that service, such service. So let me back up. So this is important. So the company may, at its option, supply such special service where, and then sub 1, such service can be reasonably provided by the company. So that language seems to mean it's sort of a qualifier. The company has some discretion. Would you agree with that?
I'd say there is. I don't know if I'd call it discretion per se, but that it can be reasonably provided. So I guess in that sense, the word reasonably does certainly imply some discretion.
Mm-hmm. Okay. And then the way you gave us the definition of special service, I guess to me it seems like that's sort of the counter of standard service, and I'm wondering if in your experience or in the company, if the company has a position that the VLC customer scenario that's being presented in these cases, their demand levels and their requirements of service is something that would be non-standard, therefore possibly considered a special service. Does the
So I think in the context of here, service isn't sort of the general, it's literally the service that comes off of our distribution system to their facility. Not service as in we're going to serve you as a customer. It's, what facilities, how big of a conductor, how big is the transformer? Are you at 14,000 volts or are you at 9,600 volts? Are you 40 amp service or 400 amp service? Those are the types of that's the type of service that 1024 is covering, Judge.
Okay, that's different than what you were saying.
It is, yes.
Okay. All right, so that's great to know. Now we can so in the company's position, is special service in a voltage situation?
So where the customer is requesting a special service, meaning more facilities from our distribution system to their, I'll call it their meter, their building, beyond what we would normally, our specs, our standards would require us to serve the load that they're bringing. So if they say, let's just say we needed to serve them at 13,200 volts, they're like, no, I still want 24,000 volt service. Okay, we can do that, but you're going to pay for those facilities because they're beyond what you need to be served. But it's really, think of it as transformers, like a single transformer for that customer, and the insulated wires you see come off of our distribution system and either put underground to the customer's facilities or overhead.
And then power service, is there any further definition you have for that besides electric service?
So in our view, I think it's just one of those things where it's either a special service or just sort of a regular service, sort of the standard service that would apply given the power levels that they're going to use.
And power levels? Power levels meaning voltage or demand?
Meaning it's more voltage, amperage, not how many megawatt hours or kilowatt hours you're going to consume at a given time. But certainly that, a 5 megawatt facility is going to require different as a standard than a 50 kilowatt facility, as an example. But keep in mind, these are customers that will be served off of our distribution system. There's not really a situation based on what we're proposing and the customers that have come to us for service. They're being fed directly off of transmission substations. We will have distribution infrastructure at the customer's election. One of them is chosen, but we're going to own the substation and then the conduit or conductor that goes from the substation to the customers. They're not using any of the other distribution facilities. This would be for what I would consider a normal run-of-the-mill customer that sets up, outside of where we have existing feeders, and they're just connecting to the existing distribution system. Very different from what we have here.
Okay. All right. So for a normal run-of-the-mill CP1 customer, I did have that the explanatory service contract here that we have redacted the customer. I don't know. I'm not sure if you're familiar with this. I have a question. It may just be something for council, but I was just curious if you're familiar with these sorts of what we have here is the CP1 electric service agreement. This is just an example of one that the utility had on file and provided to us.
Yeah, I'm familiar that these exist. I think it was Attorney Proctor Brown had referenced. Really, none of the company witnesses have really experience working through this. This comes through generally our service managers, and potentially if it's a very large customer, they might have an account manager, but they handle all of the what I consider the administrative side of onboarding a customer. This would be sort of at the tail end of that process.
And a current very large customer is what you're talking about?
No, I'm talking just any customer that would be a little bit not your typical. So maybe a larger manufacturer, somebody that might use a megawatt or two might have an account manager assigned. We have a department of, a handful of those. But then for sort of your, I'm careful with the words I use, but for your sort of typical commercial customer, it might be a retailer or something like that. They would have service managers. But the key point there is there are specific roles in the company that would really facilitate this process, and they're not party to this case. Witnesses on the company's behalf.
Sure, that's fine. It's getting late. I don't want to trip you up. I mean, there's a lot of attorneys in the room here, but I just wanted to note, and this may be something as a point of reference for council. This was provided. The agreement on the screen was provided to us as sort of a standard, typical General Electric general primary service agreement. And I don't think we need to display this. It's redacted, but I don't understand all these rules anymore about what's confidential or not. But so I have in the response to the staff data request TCM 1.1, one of the attachments, well, two of the attachments are electric service agreements from the VLCs. But they look different. They're very different. One looks very similar to this standard agreement that I'm showing. That agreement has the same paragraphs and the same information. That one was filed on December 1st. That first batch of these attachments. Then on January 16th, we got another batch where there was another agreement filed with a different VLC, and that has different language. And I guess it has additional language that's more particular to the situation that's being proposed in terms of the demand amounts. So I guess my question, this could just be a flag for the refiling process, is just to make sure that we have all of these agreements, and that if the customer that we have on file that has the agreement from December, if there's an updated version, let's produce that as well, so we know where we're at the moment in terms of where these agreements sit. But I would note that you can go back in the record and look at it, but I will note that the agreement for the customer that we received in January is different and does have different terms and conditions than the standard agreement that is before us on the screen.
Thank you, Your Honor. Again, I think we talked about this a little bit off the record, but it was a rushed affair in January. And so, yeah, we appreciate the note and we'll endeavor to get it exactly accurate this time around.
Yep, that's fine. Yeah, no need to apologize. All right, so that's all I have for that. So do we have any other questions based on those?
I'm not sure who you're asking. I do have redirect.
Well, any other cross questions based on what I've said? All right, let's move on to redirect.
Your Honor, I would say I have about 20 or 25 minutes of redirect.
Okay.
I don't know where you want to stop or if I should just start. You had mentioned ending before 5 before, so I wanted to check.
I did, but that's just how this goes. Let's take a 5-minute stretch and we'll get back and finish up for the day. So let's be back at 5:37.
Any idea about tomorrow? Like how long?
Long. I mean, there's questions for many of the witnesses here.
And where are we on Tuesday? Do you know?
I knew it this morning. I can't tell you if I actually know.
Oh, it's on Zoom. I hope it's not like the other one we just did.
Tuesday is on Zoom. Yeah. Tuesday's on Zoom. Thursday we're away. Thursday's
it's not like the other one we just did, is it?
No, it'll be.
I'll be alive after.
I don't think there's any parties in the next case. It's just, or any interveners. It's just staff and applicant. All right. Well, let's get settled here. Do we have? Let's see our.
There he is.
People. Okay. Where's our witness box? Oh, there you go. Excellent. Okay. All right. So let's continue on the record with rebuttal. Redirect.
Thank you, Your Honor. Mr. Stasek, you were asked some questions by Commissioner Hawkins about a document from MISO. Do you remember that?
Yes.
I believe it referred to market participants in that document. Do you recall that?
I do.
Are the VLCs going to be market participants in MISO?
No, they are not going to be market participants.
Mr. Stasek. And then you were asked some questions about business practice document by Commissioner Hawkins. Are the VLCs going to be ATC customers?
No, they will not.
Structure the tariff as proposed. Who is the market participant?
It would be Wisconsin Electric Power Company.
And who is the ATC customer?
Wisconsin Electric Power Company.
Thank you, Mr. Stasek. You were asked some questions about behind the meter generation by, I believe, a couple of attorneys. Do you recall that?
I do. Yes, I do.
Have any of the VLCs made a request of Wisconsin Electric to host customer-owned generation?
They have not in any discussions part of.
When you started to talk about the acreage or the size of the property involved in hosting the customer-owned generation, and I believe we're cut off in answering that question, for the record, would you answer how much acreage? What's the scale of the property needed to serve these customers using customer-owned generation?
Well, just using rules of thumb that we've run across in the past, you're at about 7.5 to 8 acres for every megawatt. We're talking about loads that, for round numbers, we can say they're about 1,000 megawatts. With capacity accreditation of solar in the 25% range, maybe 30 if you're being generous, you'd have to build out 3,000 megawatts of solar to get the accredited capacity in order to meet a 1,000 megawatt load. So you take 3,000 megawatts, multiply that by, let's just conservatively call it 5 acres. You're needing to get 15,000 acres of land just to host solar facilities without things like buffer land, inverters, transmission interconnects, or even just interconnect lines, because you're going to have to get the power, even though it's behind the meter. 15,000 acres is a significant area to cover. On the flip side, I've heard, or I think seen reference to rooftop solar. Rooftop solar is one where you're fixed tilt and you're at about 100,000 square feet to get a megawatt of capacity, of nameplate capacity. And so you're talking about needing to cover many times the number of buildings that are there to get any meaningful impact.
Thank you, Mr. Stasek. I want to switch gears to power purchase agreements. I believe there were a couple of questions about power purchase agreements. Do you recall that questioning?
I do recall some questions on PPAs, yes.
Would PPAs obviate the need to build generation to serve the significant load the VLCs are projecting?
I do not think so, no.
So would PPAs obviate the need to incur additional construction costs to serve these customers?
No.
And you're asked some questions about capacity only resources and the way, the nature of those resources. Do you recall that line of questioning?
Yes.
And I believe you testified that these are long-lived assets. Do you recall that?
I'm sorry, long-lived.
Assets.
Thank you.
And is that true for most generation investments to serve customers of Wisconsin Electric?
As far as I know, yes.
And does Wisconsin Electric expect to see net benefits in the first year of operation for a long-lived capital investment?
Not typically, no.
So are the capacity only resources that we're proposing to serve these VLCs different than how we proposed other generation assets to serve non-participating customers?
Not in any material way that I'm aware of.
Stacey, you were asked some questions about the proposal to evaluate actual costs against forecasted benefits for capacity only resources. Do you recall that testimony?
I do.
And in your surrebuttal testimony, you cite the 10-year period to reopen certain pieces of the resource agreements. And then you propose an additional proposal about evaluating actual results. Do you recall the relationship between those two aspects of the tariff?
Yes, I do.
Is the proposal to eliminate the 10-year and then subsequent 5-year reopening that's already addressed in the tariff?
It was not the intent. The intent was to have an additive provision.
You were asked about whether there were any changes to the tariff that VLCs asked for and WEPCO refused. Do you recall that?
I do.
Is it your testimony that Wisconsin Electric agreed to each and every proposed term of the tariffs and service agreements at every stage of the negotiations?
Absolutely.
Can you describe?
I'm sorry, did you say absolutely?
Absolutely not.
Okay, I saw your mouth move, but I didn't hear not.
Okay.
Thank you.
That's a good catch.
Yeah, that's a distinction.
Kinda. Good thing I'm watching lips too.
How would you describe the process of negotiation over the 2+ years that you talked about earlier?
Well, the process was, pretty involved. We started with establishing sort of a general overview and landscape of how rate making works in Wisconsin, establishing and articulating those 4 objectives we talked about, and then really just working through what ultimately, I would classify as the sections or categories of the 2 different tariffs. And so as we initially started down the path, it was a single tariff, but it got overly complicated. So that's where we decided to leverage existing sort of frameworks with a base tariff and then the bespoke resources tariff to go along with that, very similar to our DRER tariff. But throughout the course of the process, there would be a variety of ideas that were proposed, reviewed, evaluated, run through its paces on how it would impact the cost to other customers. One specific example I can cite there is on the Act 141 charges, just due to nuances and how sort of the provision for the large energy customers is implemented. We had to go through and just explain to the large customer, the VLCs, why the language had to be the way it was in the tariff. So there was just a lot of back and forth, a lot of education, and a lot of just general understanding, because the experience that these customers had in other markets, whether that be other retail jurisdictions in Wisconsin or foreign countries across the globe, is just very different. And they needed to understand those things before we could really get to a place where we could agree on a term that met their needs for speed, met their needs for meeting their obligations to their ultimate customers, but at the same time protecting our customers, which was a key objective throughout the process for our company representatives.
Did the VLCs ever propose a different split for capacity only resources?
Wouldn't say there was ever a specific split proposed. I think there was questions around why the split needed to be, I would say, so high towards the VLC. So we went through and explained the rationale that we've used in explaining our proposal in this tariff here to ultimately get the customer to understand the basis for that and the reasonableness of it.
Are you aware of other Wisconsin utilities that do have a different cost allocation percentage for generation plant?
Certainly, there are different utilities run their own different cost of service models, and I think from my understanding of looking at rate cases in the past, there are other utilities that do have different splits. I believe Power and Light and possibly Excel have, instead of a 75-25, I believe it's closer to a 60-40 production plant allocation for capacity versus energy.
Changing gears to the VLC's investments in Wisconsin, what is your general understanding about the status of construction for the two VLCs?
They're well underway. Frankly, my understanding is the facility down in Mount Pleasant is being energized very shortly and going through a lot of testing now, and is getting much closer and is a little further along, certainly, than the one in Port Washington. But that is actively under development and literally coming online pretty much in small pieces day to day. I can't speak to the specifics on that because I just am not close enough to it. But seeing some of the status reports and just through the media, certainly that facility is not only under development, but coming online. With regards to the Port Washington facility, I happen to live in a portion of the state where I drive by that a fair bit, and I see it is actively being constructed and has been since early December.
Do you have a sense of literally how much steel is in the ground at this point? Is it $10,000 or something different?
Jack, I think this exceeds the scope of redirect.
Yeah, I think we've kind of covered that there is development in the area. The amount of steel is probably not as probative as what we have so far. So
Your Honor, the questions were about whether the investments are non-binding, and I think literally putting steel on the ground is about as binding as it gets. And I have two more questions after that. I just wanted to give a sense of the dollars involved that cannot be taken back, because to this extent the witness knows.
Well, yeah, exactly. Do we have any foundation for the witness to know how much steel and how much that costs?
I believe he's in communication with these VLCs on a fairly regular basis, and is attuned to the investment that's happening and can give a general statement about that. I could ask him some more foundational questions about that if we'd like, but I think it's kind of squarely within the scope of the 2+ hours that we had of cross.
We'll test his knowledge on that. Ask your question.
Thank you. Mr. Stasek, do you have a general sense of how much investment has literally been put into the ground at the two VLC sites?
Generally from high-level discussions and also reading public media reports.
And can you give an estimate for both of the sites about how much that is,
Generally, it's in the hundreds of millions of dollars that has been deployed and put into construction that can't be undone.
There was some suggestion that the commitments to investments are not binding in some of the questions. Did you mean to imply that the PCAs Wisconsin Electric entered with the VLCs are not binding?
Not in any way, no.
And is it your understanding that the PCAs are in fact legally binding?
That is my understanding.
And what was the intent of those PCAs?
The intent for those PCAs was to serve as a mechanism to protect our non-participating customers as well as our shareholders in the event that any unforeseen or unexpected result were to occur, including the VLC not actually doing development, stopping development, and no longer requiring the resources that those PCAs back up, which can include distribution facilities, as well as generation facilities and transmission facilities that We Energies had to make a commitment to ATC since we ultimately had to request those facilities to serve our customers.
Mr. Stasek, do you have an understanding of the scale of those investments that are backstopped by binding PCAs?
I do.
Can you give a general sense of that kind of how much that investment might be?
It is in the multiple billions of dollars.
Thank you, Mr. Stasek. That's all the redirect I have.
All right, great. Okay, that's all for you, witness Stasek. You're excused. We will,
Thank you.
then, we're gonna go off the record. I think we've done this enough today, so we're gonna adjourn till tomorrow. I think let's meet back at 9 a.m. and
Yeah.
we
Your
won't
Honor,
have yes.
I got an elbow earlier to follow up on one point while we had Mr. Grylakowski still available. Just want to make sure we offered exhibit WEPCO Grylakowski 1 and that was accepted into the record. If there was more foundation, we'd have him available. Necessary, we'd have him available to testify about it tomorrow.
Okay, well, let's get back on the record. No, we did discuss Grylakowski 1 that was shared as a document to be used at the hearing. So that is already marked. Are there any objections to receiving that exhibit? Okay, so that's in the record too. Any other loose ends we need to tie up here before we leave? All right, so yeah, so I'm thinking 9 a.m. we can reconvene on our Zoom link. Let's try to be here so we can start on time, and I will and give me a minute to adjust screen names. So if people can join in like 10 minutes before, that might be useful, so we can start on time, and we won't have a lot of preliminary items to deal with. So hopefully we can hit the ground running. So with that, let's go off the record. Is there any? So I think the first order of business will be Singletary for witnesses, just to give people a roadmap here. And then doesn't look like anyone had any timing issues for tomorrow, so we'll just
Your
go.
Honor.
Yeah.
Clean, Wisconsin did have timing issues with witness Jester that were in our pre-hearing notice.
Okay.
He's unavailable tomorrow from 10 to 11, and then again from 12 to 1.
Okay. Okay, we can work around that. I read that as being today, and I was like, oh, there's no no way we're getting to it today, so I didn't think there would be a problem. But okay, so we will probably be skipping Jester then and jumping to Bernhardt because probably around that time will be when we'll be expecting to excuse Singletary, so it'll be in that time frame, I'm sure. So expect to probably likely we'll skip Jester, skip to Cloverleaf, and then continue. So what was the kind of the set time, or after those time frames where he's not available? When will he be here for an extended time?
After 1 p.m.
1 p.m. Okay, yeah. So we'll work him in after 1. All right. Anyone else has any new timing concerns that I forgot or have just arisen?
Have to be done by 11 tomorrow.
Okay, I'll note that. We'll just let AI do the transcript.
Go ahead and see what you
Oh
get.
boy, that's it. That's all I had to say.
I've seen some of those before.
I know, so have I. Trust me, they're horrible.
I have
okay, that's
security.
it. So see you back at 9. We're adjourned, and get some rest.
Thank you, Your Honor.
Stand for a
Thank you,
second?
Your Honor.
Oh, I can stay
Thank
on.
you.
Yeah. Okay. Bye-bye.
I just was mostly asking you about next